the lighthouse. All that I think is excluded.
Okay. Next is my understanding.
Hold on. He's got something he wants to interject on the Roth, I think.
Yeah, just for clarification, though, yeah, obviously the report's out. The court made that very clear, but the testimony is still there. So I intend to comment on the testimony of that.
Any objection with that?
Yes, because as we mentioned, we can't get in the lighthouse, so how's it getting in the report?
Well, what in the report's of value to you?
What's that, Your Honor?
What in the report's value to you?
Circumstantial evidence, Your Honor, has to intent and causation. He's the only one doing this in the entire hospital system.
It gets back into it. It was part of that whole process at the end. Sorry, Mr. Zion, what's good for the goose is good for the gander. I locked it all out, so you're out.
So not only is the report out, all of the testimony of both Dr. Swanner and Dr. Roth is now being excluded before closing argument. Is that your ruling today, Judge?
Well, if it's the pre-events going up, like I said the other day, going up to the actual investigation by your office and the police, I think all that's fair game. Anything else after that, I don't think is fair.
All right. Well, Dr. Swanner was testified that he saw a report that couldn't be located, that verified he was the only one doing it. That's when he realized he had a problem. Dr. Roth, later on at the request, like in 2020, like a year and a half afterwards, that wasn't part of Lighthouse. That report was produced at the request of the defense. So, I mean, that's why I thought, you said the report's out because it was cumulative, not because it wasn't relevant. You said the report was cumulative, so the report itself is out, but the testimony stands. Are you now changing that ruling in regards to Dr. Roth? Because that was not part of Lighthouse. That was produced as Ms. Menashe subpoenaed that information.
Okay.
I thought, my understanding is that there were significant issues with that testimony, both from Roth and Swanner.
Well, my response is very simple. Most of that was done after the fact. It goes into the lighthouse, so no, can't be raised.
Now, I understand the court's ruling in terms of Project Lighthouse, but when the court refers to after the fact, you are referring to after indictment. Is that correct? Absent Project Lighthouse. Lighthouse aside, everything up until indictment is okay because of the investigation by law enforcement and
As to the nature of the investigation, it is fair comment.
Okay. So I just wanted to make sure because where the line was on that. So.
Well, the lighthouse is a post-remedial action taken by the hospital to control the media. It has no relevance to the case. Okay? We went through a lot of it. You tried to tie it in, never got in. Okay? So that's my ruling.
Okay. And then I have, my understanding is the Tracy Young records cannot be referred to. However, the testimony can. Is that correct?
No. That was not my thing. Tracy Young was deemed irrelevant. We objected to everything regarding Tracy Young. You said that's not entitled in. We had no one testify about it directly that was there.
It's a specific act. Tracy Young is out.
I'm sorry.
It's out.
I just want to clarify something. There's the issue now of a deficiency in the investigation because they did not, after having received it, did not do anything with that. I think that's a significant issue with that. However, there are the separate Tracy Young issues with Project Lighthouse, such as the reports and things like that, and what the hospital did with that. I'd like to still be able to discuss the investigative part and the deficiencies thereof as it related to her.
Judge, they had the opportunity, they made the decision not to bring in, they had the nurse who was at bedside with Tracy Young. They decided not to bring that in. They didn't bring anybody else in that was there. They had everyone's subpoenaed. They made the decision not to bring anybody in that would have had either firsthand knowledge of what happened with Tracy Young or they didn't put on anybody that had a full review of those records. So the court made it very clear Tracy Young is out.
That's not entirely accurate. They objected to us bringing up issues with Tracy Young as it related to our case in chief. However, there's still the detective's testimony and his lack of action as it related to Tracy Young. And I think that's, and then you have that whole portion of his testimony as it relates to that, and I think that goes to the investigation. I can understand I understand clearly the court's ruling on Lighthouse and how her name came up multiple times through that, and that cut out a lot of what I was going to say about her, but there's only so much I can say in reference to the detective anyway.
Well, if the detective was the one who brought it up, or it was brought up through his testimony, I'll permit that.
Okay.
Your Honor, for the record, the only thing he said was we will not provide with a patient by the name of Tracy Young.
That's not all he said. He was aware.
Yeah, I remember something different with that. I thought that he talked about Tracy Young for a minute.
We did, and I've since reviewed it. I am quite certain he also was aware that it was Dr. Husel who brought it up to his civil counsel. He's also aware of several other facts as well. And Dr. Schweiger also had Tracy Young's medical records as well.
But you don't want Dr. Schweiger's in anyway.
No, but he testified about Tracy Young. That's the only.
As to the detective find, Schweigert I have my problems with.
Okay.
And state's position? You guys...
May I address Dr.
Yeah, go ahead.
Schweiger, since I handled that examination? Dr. Schweiger had a few records supplied by civil plaintiff's counsel at the civil deposition about Tracy Young. He opined at the civil deposition about a couple things and then answered to Ms. Menashe's cross about that exchange at the civil deposition. What I think is germane for our evaluation here is that he never fully examined the entire record. He was told some things by civil counsel, looked at a couple of documents, which he did not quantify, and then did discuss the fact that she was not opiate naive, quite the contrary. So there was never a fulsome review of her records by any witness in this case, certainly not Dr. Schweiger, and the cross-examination was kind of a sideswipe cross-examination about it, certainly not enough to warrant a discussion about Tracy Young at this point in the case, because there's not enough evidence in the record to give it its due.
As to what Schweiger testified, you can go into it.
And the last thing is, I wanted some clarification on the doctors for Mount Carmel. I'd like to be able to express that they're not experts in this case and that their testimony shouldn't be considered as such.
That would follow what I had. They were subjective witnesses.
Correct.
Even though they had qualifications, they are still to be treated as such. Their testimony was treated as such throughout. They weren't giving objective opinions such as the three doctors, so you can go into it that way.
Perfect. And any references to, I'm going to do this, and I'm sure the state will do it as well, but any references to the testimony, I'm going to preface with the court reporters, the official transcript, they are to rely on their memory and the official record only, that anything I I say about the record and what was testified to is for argument purposes only.
Okay. One of the things that concerns me is, in mentioning transcripts, they'll want copies of transcripts, and it just takes too long to produce them. So be careful in going through that, because the first question we'll get is, we want a transcript of Dr. So-and-so's testimony. And it's like you have to remember on your collective memory.
I'll refer to it as testimony, not transcript.
Okay, fair enough. Anything else before I get into my issues?
Just so I'm clear, Judge, you have a copy, they have a copy of my PowerPoint. There is a slide with a picture of Dr. Swanner and Dr. Roth as they appeared in this courtroom and testified. Where was administration? The next slide is administration realizes they have a serious problem. Only doctor in the entire Mount Carmel, et cetera, et cetera. You have that slide, Judge. Is that out now, you're saying?
No. Just like I told him, you can get into the investigation up until you guys are involved.
Well, Dr. Roth's investigation was not part of, what he did for that was not part of Lighthouse. That was in response to a subpoena from the defense. And you said the report itself, you said it was relevant, but the report itself was out because it was cumulative. So Dr. Roth can still be part of that even though that was in 2020, that he investigated that part. So that's well after.
It's well after, again. It's out.
It's out. Okay, so let me change this. Judge, and I will. We also would like a final copy of the jury instructions before we begin, Judge. I'm going to pull the record on that slide.
You may. There's your copy. If you'd be kind enough to take this copy to defense counsel. Okay. Anything else from the lawyers at this point in time? I've got two issues I have to discuss with you. One of our jurors sent a text to Ms. Schaefer this weekend. Clearly, he had been paying attention to the news. He's currently isolated in the back, okay? He was questioning about the events of last week. He threw in several terms of art that were concerning. I've got him isolated. Clearly, he was paying attention to the media with his questions, okay? I think I need to excuse him. He is one of the 12, but clearly he was less than complimentary towards parts of the case. And I have some concerns. I didn't want him tainting any other jurors, so he was immediately separated upon his arrival, and he's currently back in the judge's office. Any comments on it?
Can we approach to figure out who we're talking about here, Judge?
Sure. David, just chill.
Right away.
Go out there and entertain the gallery so they can't pay attention, David. Thank you. also,
I need to change this.
he'll sit for a minute so you can get so much of the
So this is a text box.
We worked on it. It works with David's machine. It's currently set on David's machine. It's not set.
They were saying they couldn't hear the audio back there. And there's so they need this.
Start jazz then.
I will have her law enforcement for that. See if she's done.
Why don't you get Mr. Gales out? Mr. Gales out. Let's try to put the odors in here first and dismiss them.
We have an issue, if we could grab David.
David, what do we have an issue with?
May we approach again?
Sure.
I did say, is this a prop?
I've got stickers here.
Oh, Dave?
Yeah.
It disappeared? I think it has.
Simulated somewhere.
I haven't seen it since last week, so.
Likewise.
Do you know what happened to the stapler?
Oh, it's hard.
Never mind. Thank you. I'll put it back on my desk if you need.
All right.
Oh, relax. Relax, everybody. Counsel, I don't need it on the record. Come on up. No. The alternate's already been sworn in. You've got two of them now.
Judge, you want to test this? I had to unplug it to do some edits, so.
Oh, you tested my luck on it. There you are.
All right, thank you, sir.
Are you guys using the PowerPoint?
Yes, sir.
Okay. During the break, because I imagine we'll break after he finishes his, we'll test it.
We have some things to talk about that we provided that this morning. We gave Mark a copy this morning. They emailed it to us. We have some things to talk about that with the judge.
Okay.
Want to talk about them now?
Now I want to get a jury here and get going. All due respect, but they've been on ice for a while now.
Understood.
doesn't matter. We'll call it Court Exhibit 14. Is that okay? I think we're at 14.
Hold on. I don't know. Okay.
Mr.
Well,
Lapis.
go
thinks it's
15 to be
17.
safe. Huh?
Mr. Lapis thinks it's 17.
17? Fair enough. Distraction. So I take out the car accident Friday?
All rise. Thank you. Please be seated.
Good morning, ladies and gentlemen of the jury. We're now entering the final phase of the trial. It's the closing arguments and the charge given by the court. Can you all hear me okay?
Yes.
Okay. Before we get into it, I want to take a second. I want to thank you all. You guys have been wonderful throughout this trial. I do appreciate it. I'm proud of each and every one of you. You worked hard for me, and I just want to give you my thanks. I know it can be tough at times, but thank you very much. The closing arguments are what the lawyers feel the evidence has shown. It's not evidence itself, but it's aid and assist you in your deliberations. After we get done with the closing arguments, then I will give the charge. Now, the state has the burden of proof, so they get to give the first argument, and then they're entitled to what we call rebuttal in response to the defense. So we have those three phases to go through before we get into the charge. Okay? With that, Mr. Zion, you ready to proceed?
Judge Holbrook, co-counsel, defense counsel, Mr. Husel, members of the jury. Let me begin, as the judge did, by thanking all of you for your service and for the attention that you have given the testimony and the evidence in this case. I know defense counsel would agree with me when I say we've done a good job picking a jury when we can get 12 plus people from our community that paid as close attention to the evidence as you have in this case. So I want to thank you all for that. Let me begin also by apologizing in advance for anything that I say during my closing or my rebuttal, which is not how you remember the evidence. Sometimes when you're with a case for a while, and I've been with this case for a while, you think evidence comes out in a certain way or I said, and that would be in my argument. If it's not how you as a group remember the evidence, please don't think I'm trying to trick you or pull the wool over your eyes. What's important is how you remember the evidence. What was the evidence? What did the state of Ohio have to prove before you can find the defendant guilty of murder as charged in counts 1 through 14 of the indictment? Well, as the judge will tell you later this morning, murder in the state of Ohio is very straightforward. That's it. That's the entirety of the murder statute as defendant stands charged. You must find beyond a reasonable doubt each one of these elements: that he purposely caused the death of another. Venue means that it happened here in Franklin County. Is the Franklin County Court of Common Pleas the appropriate place to hear the case? And identification. Is the defendant the one that is responsible for this? Purpose. The judge will tell you, the law of Ohio says a person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that in the time in question, there was present in the mind of the defendant a specific intention to cause the death of another. So if you want to figure out what do they mean by purpose, it's like, what did he intend to do when he administered these doses of these medications to these patients under these circumstances? What was his intention? What was his purpose? So this is a very good point, a very important point that I point out to you. As the judge will tell you, the purpose with which a person does an act is known only to himself. You've got to get in his mind. You've got to see what his intention was when he was doing this. And unless he said it to people at the time he's doing this, you have to figure it out from all the facts and circumstances surrounding these deaths. A person is presumed to intend the natural and reasonable and probable consequences of their voluntary acts. That's also part of the definition of purpose that the judge will give you. And what I would emphasize here, and what I will say again and again, you are here instead of professional lawyers and jurists and law professors. You're here as members of our community in Franklin County because we are relying on your reasonableness and your common sense. You'll see that word over and over again, reasonable. Once again, you've got to look at all the circumstances when you're trying to figure out what a person does something for. What is their intention? Circumstances. And this is why we spend so much time on circumstantial evidence in voir dire. Remember that silly little example of the cherry pie? That's what we're talking about here. So if someone tries to argue, it's just all circumstantial. What do they got? It's just circumstances. Well, circumstances can sometimes be very powerful. As I would argue to you, they are here. Circumstantial evidence is proof of facts by direct evidence, which you may infer other and related facts that naturally and logically follow. Naturally, logic, common sense. That's what this is about, folks. Based on the common experiences we all have. And furthermore, just because it's all circumstantial, in the law, direct evidence and circumstantial evidence are of equal weight. What weight you give any particular piece of evidence is up to you as a group to decide what it's worth. But just because something is circumstantial doesn't mean it's not as good as direct evidence under the eyes of the law. So we don't only have to prove that it was his purpose, his specific intention to cause these victims' deaths when he gave these doses during these palliative excavations. We have to show that those doses, in fact, caused their deaths. Causation. Cause is an act which in the natural and continuous sequence directly produces to that death, and without which it would not have occurred. Now that would seem to be a problem in the state of Ohio because, candidly, these people were very critically ill. They were in the ICU for a reason. So you might be asking yourselves, well, how do we know it was just the medicine, just the 1,000 micrograms of fentanyl combined with the 10 milligrams of midazolam he gave them all at once that caused their death and not other underlying diseases? Well, the judge will tell you this is part of causation. This is part of the law. This is part of what you must consider in determining whether we've proven causation to him. There can be more than one cause to an event. And if the defendant's actions is one of those causes, it's not a defense that something else would have killed him too. example that is sometimes given to law students, I would argue to you, about a person that jumps off a building, and it's the height that they are, without a doubt, going to die when they hit the ground. When they hit the ground, they are going to be dead in seconds, as soon as they are at ground level. And a person in that building has a gun, and as that person falls past them, they shoot them. They shoot them right in the head and cause their death at the moment they hit there. 2 causes of death. But for the bullet, they wouldn't have died. But for hitting the ground, they wouldn't have died. 2 causes of death. It's not a defense to say they were about to die anyways. I just killed a dying man. It's not a defense to say they're going to be dead in a few seconds, a few minutes, a few moments anyways. I just hastened their death by my actions. That's what that instruction means. So when you heard the expert witnesses in this case, Dr. Ely and Dr. Schweiger, say that he either caused or hastened their death, that's what that instruction of law is telling you. If you hasten a person's death, even if their death is as sure as the sun is going to rise in the morning, if you hasten that along, you have caused their death under the eyes of the law. So what are we talking about here? Well, we're talking about the fentanyl. We're talking about these doses of fentanyl that the defendant gave, ordered to be given, prescribed to these victims. This is the cause of their death, folks. Even though they were very critically ill. And perhaps some of them were on a trajectory to die very soon anyways. You cannot hasten their death. You cannot quickly, painlessly cause the death of a dying person. You can't do it. Not in the state of Ohio. State's Exhibit 28B. That's what this is about, folks. Death of another. The fact that there were 14 people who died here will not be in dispute. I've got to prove each and every element of the murder purposely caused death of another. It happened here in Franklin County, and he's the one that caused it, and he's the one responsible for it. The fact that these 14 people died will not be in dispute. Those are 14 people whose death he either directly caused or hastened at the nighttime ICU when he ordered the doses of fentanyl and benzodiazepine. Don't forget about the benzodiazepines in this case during those palliative excavations. I've got to prove everything. The fact that Mount Carmel West, that all of these deaths occurred in Mount Carmel West, which is here in Franklin County, or was here in Franklin County, not in dispute. And that he's the one that's responsible for this. Sometimes, folks, that's the whole thing in the case. Everyone agrees a murder occurred. Everyone agrees that it shouldn't have happened. And the question is, who did it? Well, in this case, that's not the issue. I've got to prove it was him, but that's not the issue. They've stipulated he is the doctor prescribing these medications. So, a fair question. You may be asking yourselves, was it really his purpose to cause the death of these patients? And he's writing it down, putting it in the medical record. It's being reviewed by pharmacy. It's right there. So the question is, where's pharmacy? Why isn't pharmacy calling him on this, saying, you can't give this much medicine to these people? You're doing what? Where's pharmacy? It's a fair question. Well, as you heard, from each one of these men, Taylor Schroyer, Greg Dresbaugh, Randy Mile, John O'Connell, pharmacy was unaware. Because of the system that was in place at the time, at the nighttime ICU at Mount Carmel West, pharmacy was unaware of what he was doing. Completely unaware, when Dr. Husel ordered these medications and the nurse, as was their habit, as was their training on the job, at the nighttime ICU, you don't need to wait, just go hit that override button on the screen and just boom, real quick and easy, let's get it done. Hit the override button. Pharmacy gets a notification after the fact, that retrospective review. What did Taylor tell you? Taylor told you, I was trained that, it's already done. I mean, what's the point? What's the point of calling up to question a dose of medication for anything that's already been given to the patient? What's the point of, my point is, when something comes to me to review, is the patient allergic? Is the dose right? Is this medicine correct? Et cetera, et cetera. When it's already done, why would I go through that process? It's already in the patient. So his training was just sit and verify. Just clear it out. Just clear it off like junk email. Just get rid of it. Overrides. I mean, this Menashe made a point. Oh my goodness, how many things were overridden? Thousands and thousands of things. They overrode everything, including these medications during the palliative extubation. So whenever any of that medication was pulled to override, pharmacy is unaware. And remember, I kept saying nighttime ICU, and I think maybe there was some eye rolling whenever I said that, but that's important here because there's just 2 pharmacists for the whole hospital. Skeleton crew, less resources. After 11 o'clock, it's just, in many cases, Gray and Taylor down there on the first floor. They're not just the pharmacists for the ICU. They're the pharmacists for any surgeries that are going on. They're the pharmacists for the emergency room. Anything comes into the emergency room. They're the pharmacists for all of the patients' floors. 2 pharmacists for the whole hospital. And they're not going through these medication orders that are already done. The ones that were done on override, administered, we get a note, done, verified, move on. Other things to do. When they did get a chance to prospectively review, and remember Taylor told you, 1,000 micro. About 6 months before this all happened, before he finally told Randy about it, he called Dr. Husel. Did you add an extra 0? No, it's for a procedure. Okay. You know who am I? I'm the nighttime pharmacist. I have 2 years experience. He told me it wasn't a mistake. It wasn't an extra 0. I think that is very telling. I argue to you that is very telling that this pharmacist, with 2 years experience, sees 1,000 microgram dose in the ICU. It's like, there's got it. It's an extra 0. That's 10 times what you need for a patient. No, it's for a procedure. Okay. In October, though, October 24th of 2018, he finds out what that procedure is. That was his testimony. And he states, but not really giving 1,000 micrograms of fentanyl to a human being in the ICU. Not really doing it. It's not stealing. I mean, that's not medicine. It's not medicine to give that much of that drug to an individual in the ICU. They've got to be stealing it. That was his concern. Someone's up there stealing these meds. But if it really is for a palliative extubation, that they really are putting that much into a person, what were his words? Wildly excessive. Wildly excessive. And that's a young pharmacist with 24 months on, and he knows that is not appropriate. And he tells Randy Miles about it. Pharmacy was unaware until October of 2018. Now the radar's up. Now the experienced guy, Greg Dreschwall, is in there. Read his emails. You'll have this. States Exhibit 20A. Their radar is up. Randy, as you know, there have been a few instances of highly questionable, quote-unquote, palliative withdrawal orders by Dr. Husel in the ICU. Unfortunately, I have a new one to bring to your attention. Read that email. Greg knows this isn't medicine. Greg Dreschbaum knows this isn't appropriate. Read what he says in there. And how does he end that? I don't want to make any assumptions or accusations regarding what might be going on in the ICU, but it's worth noting some of the same nurses are routinely involved when these circumstances occur. November 19th, 2 days later, State's Exhibit 20B. Well, here we go again. This time it occurred on evening shift, meaning that's after the 9, you have a pharmacist on the floor till 9 and then 11. He stumbled across this. What happened when we received the 2 full credits? He wasn't even the pharmacist on this one. This was Greg White. And he happened to stumble upon it, because remember, these are being pulled on override. They're unaware. Their radar's up since they found out what's actually, they're saying the procedure is in the nighttime ICU. And he talks about the circumstances of Melissa Penix. Read that email. Obviously, there's great concern for the doses that were ordered and given, especially in the context of a patient who was able to report a pain just prior to administering such large doses of these very dangerous drugs. He's actually looking at the pain score going, well, she's reporting pain. Not realizing she's comatose. It is also concerning that the nurse removed the med 15 minutes before the orders were even entered. Pharmacy was unaware until. In pharmacy, Helen Schroyer and Greg Dreschbaum are the ones that bring it to the administration's attention. Pharmacy is the one that unearthed what was going on. Where was administration? Well, you heard from Dr. Swanner, pharmacist by training, way back. That's what he went to school for originally. He was a pharmacist for a couple of years. And then was a family practitioner for most of his career until he got into the administration. He doesn't know what's going on. He doesn't know if there's some new procedure. He doesn't know if there are some special circumstances. He knows he needs to investigate this. They missed it in October because that voice report, peer review, didn't meet. What happened? They just didn't meet scheduling problems. But when it happens 2 more times and Greg sends those emails, now they know they have a serious problem. He realized in his investigation, talking to the other ICU doctors. Remember, I told you I talked to Dr. Wallace. I talked to Dr. Mcdonald, who's head of anesthesiology. I talked to, is there something new?
Whoa. Off. Take it off. Go ahead.
And he testified to that exactly. Can I put the slide up, Judge? We talked about this specifically before I went
I prefer not, no. Go on to the next one.
May I talk about his testimony?
You can talk about his testimony.
His testimony was that he was the only doctor in the entire ICU and the entire hospital chain.
Okay. I need to talk to these guys. Relax for a second, ladies and gentlemen. David? You ready, Sam?
Yes, sir.
Okay, you may proceed.
What did Dr. Swanner tell you regarding administration? Unaware and realizing they had a big problem in the fall of 2018. Dr. Swanner told you he was made aware of the fact he's the only one doing this outside of the operating room, outside of somebody on a ventilator. Only one giving 500 micrograms and above. We're not even talking about 1,000 or 2,000 micrograms. This is 500 micrograms and above. And we're not even talking about the Husel. That dose outside of the OR and on the ventilators. That was his understanding. And that just wasn't in the ICU in Mount Carmel West or the ICU at the other 3 hospitals that were in the system. That was throughout the entire system outside of the OR, patient not on a ventilator. At that moment, he knew we had a serious problem. Remember, what did Dr. Swanner tell you about having an attending in the nighttime ICU? This is a new concept. Up until 2013, they only had these student doctors, these residents, these caretakers, so to speak, were there learning how to be doctors. To have a fully qualified doctor on their own, running everything in the nighttime ICU in 2013 is a new concept in ICU care. And Mount Carmel, wanting to be standard, hires 2 doctors to cover the nighttime shift. They hire the defendant, they hire Dr. Haggis. Haggis is hired first by a few months in 2013. But remember, he had several more years' experience and was board certified in internal medicine. All his testimony was he had been a doctor since 2009 out there in the world at other hospitals. The defendant was a brand new doctor. He's so new, he's not even boarded yet. And Dr. Swanner explained that's not unusual. It's a requirement that you're board certified in your area. But he's so new, he actually needs some experience before he's even allowed to sit for the boards. So he's not even board certified yet. And he's completely on his own there. It's not like he has those years of experience that he can rely on when he starts off with other doctors around him telling him, this is how you do this is how you do that. He's a brand new minted doctor. There's no evidence. Remember the testimony of Dr. Swanner, Dr. Haggis, Dr. Moody, Dr. Ralston. Never asked us about anything procedural. Talked to Haggis sometimes about scheduling. Never consulted them about anything that he was doing. He's in his own bubble, folks. I would call this, I would argue to you, he's in his own echo chamber in the nighttime ICU, dealing with other new people that he is training on his methods that no one else in the entire Mount Carmel system is doing. That I would argue based on the testimony of Dr. Schweiger and Dr. Ely, that no one else in the world is doing. It's just not done. And there's no literature, like Dr. Schweiger and Dr. Ely told you, to support what he's doing. Where are the attending and discharge doctors? Right? You have the medical records right there, states 1 through 14, and I'm going to ask you to look through them. There's a lot there. Look through those medical records. The discharge summaries are written by the attendings. And all they have to do is flip to the back and see what the drugs are that he's administering during these palliative excavations to know what he's doing. So where are they? Why aren't they flipping to the back page of those medical records, or they don't actually print stuff off anymore, it's all on a computer screen. Why don't they just go into the medication administration records and see what's going on? During the palliative excavation, everyone to a person told you, we didn't do that. We don't do that. I mean, some of these folks up here, they were the attending, hadn't even met these patients yet. Some of these folks up here weren't even actually the assigned doctor. Which one was it? Was it Dr. Varghese, who was actually covering, as like almost like a matter of duty or for Dr. Thurston? Because Dr. Varghese had been assigned it, but Dr. Thurston had been the one that actually did the history of physical. It should have, the computer system should have sent the duty of doing the discharge summary to him, but she was the assigned person, so it wasn't even her. It's a cut and paste job, folks. It's a form. It's a template that comes up. And she does it because, well, if you don't do it right, within a certain number of days, your practice gets dinged for not, getting things done in a timely manner. Why is it important to get the discharge summary and the death certificate signed? Because the body can't get out of the hospital, the body can't go to the funeral, can't bury the body. So those duty tasks, those duty matters are taken care of. Not one of them is doing a deep dive into any of these medical records. They are cutting and pasting the last progress note and signing forms. They are assuming good intentions. Not one of them were aware of the medications and/or doses the defendant had administered to the victims at the time of palliative excavations. They weren't aware of it when they wrote those discharge summaries. They were not aware of it when they signed those death certificates. Where are the other ICU doctors? You heard from three of them. Dr. Hager split the nighttime shift with him, Dr. Ralston, the director, and then Dr. Mooney, the co-director. They worked during the day. If they did pick up a night shift, it was because either Dr. Hagris or Dr. Ralston, Dr. Hagris or the defendant were not available. So it's not like they would work with them at night. If they did, they would work on their own. What did they tell you? They have never, ever given equal analgesic doses of pain medications and benzodiazepines anywhere near the dose in the ICU that the defendant was giving the victims during palliative withdrawals in the nighttime at Mount Carmel West. They called Dr. Ralston. You mean during palliative excavations? No. I mean ever. I don't use fentanyl, I use morphine. But remember what he said, an equal analgesic dose of morphine to 1,000 micrograms of fentanyl is 100 milligrams. Have you ever filled up a vial of 100 milligrams of morphine and given it to any one of your patients in your 30 plus years, 20 plus years, however long you've been a doctor, and stuck it into it? Not 90? Nope. 80? Nope. What was the most he ever said he gave? 10 to 15, and that's a divided dose. That's as needed. Start off with 10 to 15, of course, which would be the equal analgesic dose of 100 to 150 micrograms of fentanyl. It's just not done. What were they doing during palliative extubations? Generally, they start with 2 to 10 milligrams of morphine, which, as they told you, and as everyone else that testified that knew who this told you, is equal to 20 to 100 micrograms of fentanyl. And if needed, if indicated, remember their testing, if indicated, it's not like an automatic thing. If I think they also have some anxiety, I will also start with 1 to 2 milligrams of a benzodiazepine. And then you judiciously titrate as needed. Titration, that idea is that you start low and you go slow. Because remember, Dr. Ely, you're trying to cover the pain. No one is about people suffering during the death. No one is about, the redemptive quality of pain. No, it's about covering the pain. You did that with you need enough to cover the pain, to mask the anxiety, so that you get the benefit and not the harm, because these are dangerous drugs. And it's so easy to go from the harm being much greater than the benefit they are receiving. You titrate. There's no reason why you can't add more later. They are all about providing controlling pain and providing comfort. Okay? Well, certainly, though, you've had trouble with it. No. Never any issues at all. Never any issues when you start like this, you watch your patient, You listen to what's going on with them. You're at that side. You're listening to the family. Never have a problem. He told you specifically you use the small, frequent doses every 15 to 30 minutes, if indicated. So what are your factors, doctor, for dosing decisions for palliative extubation? What if someone's brain's damaged? And several of the 1 through 14 victims in this case had brain damage. What if they're brain damaged? What if they have evidence of an anoxic brain injury? Do you give them more medicine or do you give them less medicine? Well, you give them less medicine because when you're brain damaged, especially the upper part of your brain, you can't feel that anymore. Your body loses the ability to perceive pain. So you either give less or you don't give any. They don't need any pain medication. That's corroborated by Dr. Schleider and Dr. Dean. We both told you that. That's just not a Dr. Ralston thing. Age. Well, if they're a young man versus an old man, how does that factor in? Well, you've got to reduce the doses as the person gets older. Your body, as you reach age, as you reach these milestones in your age, you become elderly. You cannot handle these doses as well. Your liver doesn't work as well. Your kidneys don't work as well. So the older you are, you've got to cut it back. Because once again, the goal is to control the pain, is to mask the pain. But not to give them so much that you're causing them harm. Even if they're dying, they still have value. Right? Even if they're going to be dead, you just don't say, well, hell, just give it. No. You still need to do that as a doctor. Just enough so that you're covering that pain, you're masking that anxiety, but not so much that you're causing them harm. You look at their liver and kidney function. If they have a compromised organ system, and remember how important the liver is in this function of processing these drugs and getting rid of the toxins that they produce. And so if your liver's not working as well, as many of our patients, many of our victims, their livers were not working as well as they could have been, you cut it back. If they are needing dialysis, that means their kidneys are not working. You cut it back. You mask their pain, you control their pain, but you don't want to hurt them. Dr. Ralston said, well, and then I looked at the patient. So that for him, his practice is not to let a nurse go in and write whatever number. His practice, during the most important of things doctors can do, when there are people in their care, be with them when they die. He's with them when they die. And I look at them. And if they're in pain, that's me. Nothing more. He's there at bedside as they die. The family's there. That's another thing he said. They know better than I ever will. What do you guys think? Do we need more? He's asking them. Because it's not about people dying in pain and anxiety and fear. It's about controlling that pain. It's about controlling that anxiety, but not killing them. Her standard practice, Dr. Moody's, she said I'd start anywhere between 4 to 10 milligrams of morphine. 10 would be about the most I'd give. And then PRN, you'll see that quite a bit. PRN, remember that stands for, I don't know what it stands for, but it means as needed. Whenever you see as needed, that's an ongoing instruction to those that are caring for them. If they need this, just go ahead and give it to them. 2 to 4 milligrams, up to an additional 10 milligrams of morphine. She doesn't use the benzodiazepine of midazolam versus she uses Ativan. And she would typically start with 2 milligrams. And once again, remember her testimony. Only if it's needed. It's not an automatic thing. Dr. Hagris. I followed the order set. I followed the order set. Did you have any problems? Nope. You'll see the order set. There's several that were in effect in the time period in the indictment. 17B. Just clicking boxes for the nurses. You start here, and as needed, give them more. Look at these doses. 2 milligrams. 4 milligrams. It goes up to 10 milligrams. Fentanyl is not on here, but you do know the equal analgesic dose of fentanyl. Times it times 10. Nowhere near. what the defendant is doing in the nighttime at the ICU during palliative excavations. He never talked to anybody. He never said to anybody, ladies and gentlemen, and I'm talking about while he's working there. Never went and consulted with him. Never went and said, what do you guys do? This is what I do. What do you think? And the point of this, ladies and gentlemen, every time you heard the question, well, isn't it true that equally trained doctors with equal experience can say, you need to do this, and then you go get a second opinion, and an equally trained and equally experienced doctor can say, no, you need to do this, you get a second opinion type thing. He is not equally experienced as these other doctors. Not nowhere close. When you're talking about Dr. Ralston, or when you're talking about the experts, Dr. Ely or Dr. Schweiger. Nowhere near them. Not equally experienced. Not equally trained. He's not even board certified at this point. Where are the nurses? Once again, pharmacy has a record. Administration has a record. The attendings, all they got to do is flip to the back. Well, these are the folks at bedside. These are the folks that are actually putting this medication into these victims. They have training. And as you heard over and over again, they don't answer to the doctor. They can refuse any order that they believe is harmful to a patient. In fact, they're obligated to do that. They answer to their champion, the charge nurse, the administrative nurse. But once again, it's the nighttime and the ICU at Mount Carmel. And how many? The director? Oh yeah, we always had a director or nurse somewhere. On the floor? Oh, no, for the whole hospital. It's a skeleton crew at night. So there is someone they can go and talk to about this. But it's not like they're at the nurse's feet. Their chain of command is somewhere in the hospital, and it's one person in the nighttime. Skeleton crew, less resources. One of the circumstances you can consider in how all this happened. Where are the nurses? I would argue to you, they are enthralled with the defendant. Ms. Grubb used that term in opening, enthralled. I had to look it up. It's not ENTH, it's different. Enthralled. It is a slavish devotion to someone. It is an unquestionable loyalty to someone. It is someone that you are captivated by and you don't question. That's what it means to be enthralled to someone. They knew where to train. Cleveland Clinic, in their world, this world of medical professionals, that's like the Harvard and Yale of places to go. You go to Cleveland Clinic, you train at Cleveland Clinic, you're the best of the best. And isn't it interesting, ladies and gentlemen? That was a known thing. None of these other nurses knew where Dr. Haggers went to school in Maryland. None of these other nurses knew where the daytime people that they mentored with. I don't know. They knew where Dr. Husel was. With Cleveland Clinic. They knew he was Doctor of the Year in 2014. His first year as a doctor. He's voted doctor. You'll see the certificate. He's got the piece of paper to prove it. And they all knew it. And they knew he was always willing to teach them. Yeah, come here, let me show you the settings on the vent. Let me show you how to do this. Let me show you how to put in an arterial line. Let me do this. They were enthralled to him. But what was their training and experience? For the most part, they were all very young and right out of nursing programs. Some of them went from like nothing in 13 months in the accelerated program to being on that floor a little over a year. And you're right into the nighttime ICU. Brand new. Some of them had prior experience in other sections, but like they told you, well, ICU is different. Each time you switch to a different thing, it's like you're brand new. You got to learn how they do things. So even with those nurses that had prior experience, they didn't have prior experience in the ICU. The more experienced nurses had just a few more years than the brand new ones.
Excuse me.
Remember the one charge nurse? How did you, well, I got 2 years, maybe 3 years experience. Well, what did you have to do to be a charge nurse? I shadowed another charge nurse for 3 days. Now they're the charge nurse. So even the experienced nurses are new. And in schooling, they all testified when asked, yeah, you take a course, maybe an 8-week course, maybe a semester course on pharmacology, like you know what an opiate is, you know what benzodiazepine is. What about those? Learn all of that on the job. You learn all of that from other nurses and doctors and techs and everybody else you work with. That is something, when you start, you learn. And before I make this last point, ladies and gentlemen, I will say this, and I will argue this to you. They didn't sign up as new nurses in the ICU at Mount Carmel West because they wanted to be good nurses. They did this because they wanted to be great nurses. They wanted to be the best at what they did. This is a challenging place to work. And to get there right out of the bat. You're not sitting there just taking notes on. You are in the mix, right there. Taking care of the sickest of the sick. Saving lives. Doing what you signed up for. They want to be great nurses. And here they've got this guy, the only guy there at night, teaching them, showing them bed settings. Other doctors don't do that. Showing them how he does procedures. Other doctors don't do that. I mean, if you ask, they'll explain what they're doing. But he teaches them. They are eager. They are motivated. This guy's Doctor of the Year, Cleveland Clinic training. He's teaching me. I'm brand new. They are enthralled to him. I would argue to you they were unwitting implicitors in these deaths. They didn't know what they were doing when he ordered them to do this. But that's what was going on with the nursing staff, ladies and gentlemen. Count one, Joanne Belisari. Extensive medical records. I've just put up a little blurb about each one of them. Help you remember these folks in your mind. She was a 69-year-old woman. She was 4'9". She weighed 126 pounds. She has a seizure in April of 2015 at her home. It's witnessed by someone. It's all in the medical records. She gets to the hospital. They run some tests. They see this tumor on her lung. She might have cancer. She develops pneumonia, maybe from being in the hospital. She's intubated for respiratory failure. She's there for a while, the longest of all of our victims. On May 10th of 2015, on the defendant's order, she's given 1,000 micrograms of fentanyl. She was extubated and died within 17 minutes. Regardless of whether or not she was at the end of her life at that moment, ladies and gentlemen, she was dead within 17 minutes of that tube being pulled out of her throat because the defendant ordered her to be given 1,000 micrograms of fentanyl. A woman that needed a machine to live. Not 1 unit dose, not twice. Not 100% more than a unit dose. Not 3 times, not 4 times, not 5 times, not 6 times, not 7 times, not 8 times. 10 times the amount of what any other doctor would do in that situation. And she's dead in 17 minutes because of the actions of the defendant. Remember, the brother testified. It was important to him. It was important to his sister Joanne. It was important to his whole family. They're old school Catholics. We go to a Catholic hospital. That was the Catholic hospital in town. That's why we went there. My sister wanted a natural death. Nobody wants anyone to die in pain, but she wanted to go on her own terms. In the divine's plan, in their belief. And he firmly believes, he told you. You didn't get that. He caused her death. He hastened her death, ladies and gentlemen. She might have been sick. She might have died anyways that night. But she wouldn't have died in 17 minutes. If you want to know if the doses are appropriate, and I've done this for each one of the 14, but you don't have these records yourself to look at. Look at, in the direct flows charting section, that's where you'll find pain scores. Of each of these medical records, they're all in the same place. The direct flow chart, just flip right to it, find the pain scores, find when they've been in pain, and then go to the back. The last section of all of these records is the medication administration record. That is where you'll find the medications that were ordered and given. There's a section called orders, where the medications are ordered along with everything else. I would argue to you should look at the medication administration records, though, because many of those things that are in the orders section are PRN or are not actually given. If you want to know what was actually given, when you're looking at these medication records, look at MRs, medication administration records. And look at the medication when she reports, for instance, she has a pain score of 7 on May 10th of 2015. At that time, at 1826. And look at the amount of hydromorphine, Dilaudid, that she was given to control that pain score of 7. The 1 milligram. And that's Dr. Husel ordering that. So he knows. He knows what will control her pain. 7. Pain score is 7. A little bit of, he knows what he's doing, folks. This is an intentional thing. 0 pain, 0 pain. Excavation, pain score 10. Where does that number come from? Brian Hayes. Brian Hayes is a different type of victim than Joanne Belisari. Brian Hayes in count 2, ladies and gentlemen, he's one of the 2 overdose cases here. He's the one that's admitted in April of 2017 after being found unresponsive by his sister in the bathtub. Remember, Ryan, who had troubles, his sister knew about it, intravenous drug use, his adult life. She thought he was doing better. She was letting him live with her because his job was nearby and he could get there easily. They had gone out to a bar and had a couple drinks, didn't get hammered, it wasn't like some big night, a party. It was just kind of a night of just relaxing. They had to work in the morning. She doesn't have a shower, so he's going to take a bath, and she hears the water running. He's down for a while. It's hard to say how long, but she calls the squad, she calls the police, they find drug paraphernalia. He's the one that had fentanyl, actually. Right? So he's not only using fentanyl out there, he's using the thing that's 100 times more, either wittingly or unwittingly, when he ingested those drugs out there on the street. And they're doing CPR all the way to the hospital, and it's in the med report. And they finally get him back right as they get to the ER. Dr. Ralston actually was his physician when he got there. One of Dr. Ralston's, they look at the medical reports. He's talking to the family. Ryan's the upper part of Ryan's brain, because they looked at the CT scan, they made a CT scan, and the images of the brain, you can tell he's the upper part, the part that perceives pain, the part that perceives emotion, the part that perceives anxiety, the part of what made Ryan is dead. It's gone. He's not legally dead or physically dead. You know this because even though he's on a ventilator, you'll see in the notes he's over-breathing. He's breathing on his own over that too. So remember Dr. Wilson explained to you. You got your upper part of your brain, that's the part of your personality, that's the part that makes you you. But you got this base primordial brain, whatever they call it, the bottom part of your brain, that runs the autonomic parts of your body, the heart, the lungs, the breathing. That's still rolling. That's still rolling. The family's interested in organ donation. Read the notes. It's okay to wait. We can't harvest organs from a person who's not breathing.
No breathing, he's not brain dead. But it's likely he's going to be brain dead in a few days. So it's fine to wait. Because he's not in any pain and he's not experiencing any anxiety. We tell him it's okay to wait. So the loop people come in, the organ donation people come in the next day. Ryan's body is not appropriate for organ donation, and the family decides to extubate him once the son is there. Remember they said it's very important to be at bedside. Lisa was at bedside. Was your brother exhibiting any signs of pain or anxiety? No, he's just lying there. He had a 0 pain score throughout his hospitalization, which corroborates everything Dr. Ralston testified to and put in his notes. Because no one is observing him in pain. He had no pain medications throughout his hospital stay. Because when Dr. Ralston says he's not incapable of receiving pain, that's true, corroborated by the fact that he had no pain. There it is in direct flow charting. 0 pain scores throughout the entire stay. That's it. Before you go, ask yourselves this. What possible purpose could you have in ordering the medications Dr. Husel ordered to be given to Ryan Hayes other than to hasten his death or cause his death? Pain medication can be given to control pain. Anxiety medicine can be given to control anxiety. This guy didn't have it. Doesn't have it. And he doesn't start off small. He wallops him with 1,000 micrograms of fentanyl and 10 milligrams of hydromorphine. Remember, the equal analgesic dose of hydromorphine and Dilaudid times 10 again. Well, excuse me, times 100, because that's like another 1,000 micrograms. That's equal analgesic dose of 1,000 micrograms. So that's like equal analgesic dose of 2,000 micrograms. 1,000 of fentanyl, 10 of hydromorphine, and 10 of the benzo. All together. Bam, hits him with that. And out of nowhere, Troy Rudman, yeah, it's a score of 10. I mean, it's out of nowhere, folks. What did the experts tell you? The people that have actually done this for years and years at other hospitals, at Vanderbilt and in Tampa, never seen that before. Never seen 0, 0, 0, 0, 0, 10, 10. Because no one else in the world does this. Ryan, possibly because he's a uses carfentanil out on the street and fentanyl, doesn't die immediately from that dose. So 43 minutes later, hit him again. Another 1,000 micrograms of fentanyl, another 10 of the hydromorphine, another is either 8 or 10 of the benzodiazepine. That does it. That is a few minutes later. It is a crime to kill a dying man, folks. Ryan Hayes was dying. The part that made Ryan was gone. But his brainstem was still working. He's still over-breathing the vent when they did the palliative extubation. And the only reason to give him that amount of medication was to get him out of the ICU. Get it done. Beverly Schertzinger. She's 63, 5'4", 168 pounds. She went in October of 2017 because she had a coughing fit at night. That she coughed so much, it's in the meds, she passed out, woke up, and her leg was hurting her. Her husband had died the year before from blood clots in his leg, and she's worried she might have blood clot because her legs hurt so much. So she goes to the hospital, has a neighbor drive her. There's no blood clot. And then they find a mass in the lung, possibly cancer. Got to check that out. And then they, after some more tests, see some spots on her liver, possibly cancer. They do a biopsy on 10/9. Now, it turns out she does have cancer, but whenever you see these patients, these victims with cancer, they're not at the end of some long hospice stay. They're not at the end of some natural, long, drawn-out process. She hasn't even actually been diagnosed with cancer at this point. It's later confirmed. Well, what gets her? There's the biopsy. Remember Dr. Ely, Dr. Schertzinger talked about how much blood is in the liver? Well, they make something in the liver. She's bleeding internally. They can fix her. That happens. Dr. Schertzinger even told you, that's a very common thing when you do a biopsy that causes some internal bleeding because the liver has so much of your blood coursing through it. They can fix her. Now, she's going to die of cancer. But Dr. Schertzinger told you, Dr. Schweiger told you, Dr. Schweiger told you, Dr. Ely told you, maybe not for another year or two. I mean, she had time. They just needed to fix the internal bleeding. But the family's called in. Her son testified. Nope, she doesn't have time. Your mom has no brain activity. That's what he told you. That's what he was told was going on with his mom. And what choice is that? Part of your mom, the major mom, is gone. She can either die here on the machine or she can die naturally. What kind of choice is that? They'd like to have her taken off. The mom that they've been talking to before this, I mean, she was awake talking to them in the hospital. And she dies within 10 minutes, never regaining consciousness. Because the defendant ordered that she be given 500 micrograms of fentanyl, which is 5 times the maximum dose that he should have been given, 4 milligrams of midazolam. It's nowhere in those records indicated that she would need this. Look at the direct flow charting. Look at the medication administration record. And when you're looking at the MARS, there's a section that is for things that are given all at once. The IVP pushes, that's in the first part. There is also, right after that section, infusions, which are the bags. Look at those two, because many of these patients, in addition to the medications that are in the MARS for pain, for the breakthrough pain, are also on continuous infusions, the drips, 25 micrograms an hour, 50 micrograms an hour, to get them to the baseline. So that's part of this story too. He doesn't order bags to be given to him during the act. He's ordering IVP pushes, boluses, all at once, 2 to 3 minutes, squirt it in them. And when you look at the pain she was in and how it was controlled before, there is no justification. What other purpose can you have in that type of escalation during that procedure with a woman whose liver is compromised, with a woman whose breathing is compromised, who is very sick, who is older? You don't give them more, you give them less. If your purpose is just to cover their pain and give them a peaceful, comfortable death. But they're trying to move them along, as I would argue the defendant is doing here. Get walled. What did Dr. Ely call it? Beyond thunderdome doses. Doing Millette, 74-year-old man, 5'6", 141 pounds. He originally goes to the hospital in November of 2017, and this is how it happened. He'd never been to his son said, I didn't think my dad had ever been to the hospital before November of 2017. It's because he stubbed his toe, like the month before, in his living room, on the carpet, got a little cut, it wouldn't heal. It got worse, and it got worse, and when he finally went to the doctor's like, go to the hospital now, this is terribly infected. And actually in November of 2017, had to amputate his toe and part of the other one. And he's not stable enough because he had part of his body amputated just to go straight home after that procedure, so they sent him to the nursing home, where after a week or so there, he becomes unresponsive, things aren't right with him, they don't know what, he's hallucinating. So he goes back to the hospital. His son Brian testified, yeah, I called my dad every day, and when I couldn't get a hold of him, I got a hold of my mom, we're on our way there. So after his stay at the nursing home, he's back on 12/5. He goes by squad to the hospital. He does code 3 times in the hospital. that day, on defendant's order, he's given 1,000 micrograms of fentanyl, 4 milligrams of midazolam, 2 milligrams of hydromorphine. He's extubated and dies within 18 minutes. The family was told, your dad has brain damage. You can either stay on the machine and die, or you can let him die naturally. What choice is the family really being given? What good information is the family really being given? What did Dr. Schweiger say the standard is in the ICU? You have to wait for the patient to pronounce themselves. Even folks that code several times. And remember, he's coding in the hospital, so it's not like Ryan who's down in the tub for who knows how long without CPR. He's in the hospital coding. And while that is very serious and can cause a lot of damage, he's got the best care, you know? They're doing CPR, they've got them lined up, they're giving them the right drugs, they've got the crash carts there. Patients will surprise you. You have to give them time to let you know where they're at. Time Danny Millette didn't get. Because of what the family was told, because of the drugs that were administered to him upon his extubation. The only other pain medication he was given during this stay was Tylenol, and that was as needed. Wasn't even very bad. 0 pain scores. Jacob Deemer, score of 10. Remember Greg Dreschbaugh's email? Seems like we have some of the same characters involved in these. Brandy Mcdonald, 37 years old, 5'7", 280 pounds. She was a cancer patient. She had beat ovarian cancer a number of years before. It had gone into remission, and it came back. And she's at the Zengmeister Center in experimental immunotherapy. And she's at a doctor's appointment, and they run some tests, and they're like, we don't like your liver enzymes. You've got these other comorbidities. You've got diabetes, you've got these other things. We want you to go to the hospital, and we want you to be monitored at the hospital so that we can carefully see what's going on. So yeah, she has cancer again. Yeah, she's getting this experimental treatment, but she is not a hospice patient at the end of a prolonged death. Calls her mom. Mom, can you take me to the hospital? Okay. They drive from London, get her to the hospital. They park in the parking garage. They walk in. This is not somebody that is on death's door when she goes to the hospital that day. She was in no distress. She was not dying of cancer at that point. Mom, her partner, man Ripley, they went and had coffee last time they saw him. Do you want me to spend the night? No. No, the weather's bad, Mom. Go home, I'm fine. That night, she develops severe acidosis. She's intubated and transferred to the ICU. Family's called. It's over. It's done. You can either let her die on the machine or let her die naturally. Well, they didn't want Brandy to live for the rest of her life on a ventilator. That was the choice they were given. Had Brandy pronounced herself? Had Brandy been given all the options? Were her cancer doctors at the Zengmeister Center called and consulted? Were the doctors that had been treating her for the several days called and said, hey, this is what's going on with her? No. Nighttime, ICU, family's told, do you want her to live the rest of her life on a ventilator? Or do you want her to let her, pull the plug and go natural? And who knows if she ever would have woken up because she was given, in the defendant's order, 1,000 micrograms of fentanyl, 6 milligrams of midazolam, extubated and dies in 5 minutes. Look at the pain scores from the hospital stay. Look at what was given to her to help her control any pain she might have been in. And ask yourselves, what was the purpose of these medications at the time of extubation? Frances Burke was 73. She's 5'3", 215 pounds.
Mr. Zahn, hold on. We've been an hour and a half. How are you all holding up? Do you need a break, guys? Okay. Let's take 10 minutes enough? Okay. With it, David called up.
All rise.
Remember the admonitions and do not discuss the case yet. You don't have the law.
go pull the records. Let's go look at it.
Wait.
Okay. Be seated.
Oh,
Yeah, so there are just
Okay.
little things.
all right, yeah, change that. Okay, yeah, go ahead
Yeah.
and make those changes.
Okay.
No, I did change that one back.
Okay. Mr. Zion, I'm guessing you'll probably go till noon by the time you're done?
Probably. I mean, I'm just going to go through the rest of the patients and records, and then, and then I have some closing remarks, but yeah, I mean, probably close.
Okay. Mr. Baez, I assume you'd prefer to start after lunch and get into 3 or 4 minutes of your argument?
If it's 3 or 4 minutes, obviously not, but if I have a half hour, I'd like to
Okay.
take.
I just getting a barometer because I always hated breaking them up if I could avoid it.
Understood.
Okay? So let's play it here. Anything for the record, Mr. Zion?
No, sir.
Anything, Mr. Baez?
No, sir.
Okay, enjoy your 10 minutes.
I did not change it. I mean, I just pulled the one and worked on it over the weekend, and it was on the K drive, so.
Yeah, I don't know how. Yeah,
Where was I? Was I here?
the one thing, so it's not straight, the last one. Someone else. Let's look at this. Okay.
Because I remember thinking,
Well, that's what.
Did I say husband? Oh, yeah, no, I know. Yeah, I know her husband had died. And this is the one that had the Easter.
Yeah.
They were out there having Easter dinner, gone to the park or something. Something like that for my mom would be like mortified because I put her height there. Jerry Brown.
Max, how's the kids doing?
Was I just there?
Yeah, I don't know.
We have a third one yet?
Start that. Let's start that.
Yeah, I'll let you know.
I just feel sorry for your daughter's absolutely lovely.
Yeah.
Thank you.
I dread you in about 12 years.
Yeah, I know it's coming.
Oh, you are in so much trouble. Well, he's getting handsome too, ain't he? He's getting big.
See this right here?
Yeah?
That's what it was like.
Oh, he caught himself hard, huh?
And he's sitting on the couch just
Tumbled?
after a long day. Actually, about to do his all. Next thing I know, whack.
And they are
Ooh.
Stars. And I'm like, I didn't even know it hit. I heard something fall on the ground. Like, moving over.
You should have called me. I've done it for you. You should have called me.
Getting vision issues, go and see the
David,
Is there any other changes to it? Declared themselves. What's that?
you with death certificates or?
Is it?
Yeah.
I'm not missing time working in the yard.
Hey, David.
Your dog food, now we pay a bunch of money. They're going to take CDC.
Yeah, I noticed this is all here.
She should be good. She's 18 years old. She loves it. She
It is up.
It should be on over there.
I can't actually see, I can see 5 different angles here.
What we'll do is on the break, we'll get IT in here. Next break, we'll get IT in here to fix it. Okay, how many patients?
Yeah, I don't know if it's a matter of.
Yeah, that's a good point.
The people we got the phone from said, yeah, they she's 2 more than
Silly.
That one, I know.
Together, my thing.
Okay. What?
Beth asked that you would check your IMs because she's sending you a message or something.
Oh, I was checking earlier. Okay.
It's nothing, so
Yeah.
minimize.
It should be working, everything up here is rolling.
Well, the power is on this one, but that screen is blank, so I don't know if there's a stuff. I don't see those on the desk.
Well, let's not worry about it right now, we can just.
Well, you can hear that. There's no dog, there's no dog.
no. And she couldn't find like the most expensive cat food we could find. She was
Oh, here's the final jury instructions and your copy of the verdict forms. And then I will give you, after I get done reading, I always give you this copy of the one I actually read. Okay? To the court exhibits.
yeah, she was legit. It was $78 and a bunch of chicken parts.
Yeah.
Could have been for a day and expensive.
Any luck?
There are people hearing right now.
Yeah. I'll tell you what, it's got all that fat and everything else in it. That's, just keeping it on. Since she put on, and she lost her, actually, she
That's where you have, I put Pedialyte and baby rice cereal. Dry milk. Anybody can use vitamin.
What, sir?
No. It's plenty of protein and fat.
Any, if she wants to put a mic out here so it can be heard. Any objections? Go ahead and get up there real quick.
All rise. Thank you. Please be seated.
Ladies and gentlemen, I hope you had a wonderful break. We're going to continue on. Mr. Zion.
Before we move on past Brandy McDonald, folks, I had the wrong name up there. For the record, I've corrected this slide. Brandy's mom's partner's name was Jerry Brown. That's the one that testified. She was the one that was that told you, well, we didn't want Brandy to live the rest of her life on a ventilator. That was the choice they were given regarding Brandy. Look at the pain medications, look at the MARS. Folks, look at all of the evidence in this case, but there is State's Exhibit 14 Prime. You'll have this notebook back with you. That has the MARS, some of the other direct flow Charge-sheet, pain scores, and the medication that was given to them. So in 14 Prime, that is from States 1 through 14. Look at that. Look at the previous pain medications, look at the previous doses of benzodiazepines, and ask yourself, what purpose did he have when he ordered these beyond Thunderdome doses for a palliative excavation? Frances Burke was a 73-year-old woman. She was 5'3", 215 pounds. She has a stroke at home on January 13th of 2018. You heard the testimony of her son. He said, remember, she was trying to buy a movie. She was trying to use the clicker for something that she doesn't normally use it for on the TV. She was looking for water. There's water bottles next to her. Something wasn't right with Mom. She had a stroke. And she's taken by squad to the hospital. She's vomiting in the squad to protect her airway. The squad intubates her on the way there. A CT scan does show a large brain bleed. She's critically ill. But on January 14th of 2018, before he's even allowed to see his mom in the ICU, the family is being asked to sign a DNR. He never talked to the doctor. That was his testimony. And when he did get to see his mom, she did not appear to be in pain. Remember what Dr. Schweiger said. You need a 48-hour to 72-hour time for the patient to declare themselves. An ICU trial. That's one of the reasons you sedate somebody, protect the airway. You even paralyze them so they're not fighting a machine. Give their body time. Let's see where they're at. Was she given time? She was critically ill, folks. Was she given time? She was given 16 minutes after the defendant gave her 1,000 micrograms of fentanyl. She was extubated and died. Look at the previous pain scores. Look at the medication he gave her when she was extubated. Jeremy Sue, her family called her Sue, Hodge. Jeremy Sue Hodge was 57 years old. She was 5'4", 225 pounds. She had shortness of breath. She tells her family she needs to go to the hospital. She collapses in the driveway, and the neighbor gave her CPR in the driveway. EMS is called, and they give her CPR all the way to the hospital. They take her right from the ER right to the cath lab, right to the place where they go and check out the person's heart. What's going on with her heart? Well, they can't figure out what's going on with her heart. They do know her glucose is very high. I mean, it was like 800, 1,000. It's in the medical records. She codes in the ICU, the PEA, the Pulseless Electrical Activity Code, and they bring her back. And once again, critically ill. But when you see these codes in the hospital, what did the experts tell you about it? There's a lot of survivability to this, because it's not like bystander CPR. You've got doctors and nurses right there doing CPR right and giving the medications they need to survive. She's not given time now. Robert Hodge, her son, said he
let to see her. He was never even allowed to go see her until after they had made the DNRCC decision on that same day. She's given 800 micrograms of fentanyl, 6 milligrams of midazolam. She's extubated and dies within 5 minutes. There's no pain chart. She's there for such a short time, they don't even chart the pain she's in. Give pain medication to control pain. Give anxiety medicine to control anxiety. It's not even in the record prior to the administration of these drugs. James Allen, 80-year-old man, he's 5'6", 180 pounds. His son Jim Allen testified. Back on May 24th, that date's wrong, I'm sorry. But on the day he went in, he's not feeling well, he's not eating, his vitals aren't good, and so his son, not Jim, his other son, takes him to the hospital where he eventually diagnosed with gallstones. He's having gallbladder issues. His bile duct's all clogged up because of these stones and sludge that are in there. Right? I mean, this is not a death sentence, folks. This is not, well, he's 80, it's over. This is something they can fix, and they try to. They do an endoscope. They get rid of the stones and the sludge in his bile duct. They put a stent in there, which is just something to keep everything open, to keep the duct open. But he doesn't get better. He has to go to the ICU. He goes back to the regular floor, has a low blood pressure. They can't figure out what's going on. He starts vomiting blood, and you see that coffee brown hemosis. That's what they use. He's throwing up blood. He codes. They bring him back. Well, what was going on with Mr. Allen is the stent wasn't in the right place that they had put it. They do a second endoscope and try to fix the placement of that stent that they had placed in to keep his bile duct open. So he's not, ladies and gentlemen, a man that is at the end of some terrible cancer or other illness. He needed time in the ICU to see if he could get better. But that's not what Jim is told. He's told his dad, he's told his son, he's told his dad is in total organ failure. His dad had no chance. It's over. Can you give us 20 minutes? It's my dad's birthday. 20 minutes. Midnight. We just can't. No one answers us. Nope, have to do it now. They sing happy birthday to him anyways. Remember, these are supposed to be planned events. There's nothing emergent about palliative extubation. You can wait for relatives who arrive from out of state. You have time to go and gather the team and talk to all the other doctors. This is not in the middle of the night. You have to do it now. You can't wait 20 minutes so you can sing your dad happy birthday properly. But that's what happened to James Allen. He was given 1,000 micrograms of fentanyl, 6 milligrams of midazolam on the defendant's orders. He's extubated, and he died. Look at the pain medication. Look at the direct flow charting. Ask yourselves what those scores mean, whether those scores are real, or whether that's just what the nurses are putting in. Troy Allison, he was 44 years old, 5'8". He was a big man, 312 pounds. On July 15th of 2018, he's brought to the ER by ambulance because he was having difficulty breathing. When he gets there, he has a seizure and codes in the ER. So once again, he's coding. It's serious. It's bad. But he's at the ER, and he's got everything Western medicine can provide to him to help him at that point when he's in the ER at Mount Carmel. He has another code shortly afterwards, but they bring him back again, and he's transferred to the ICU. Now, what do you know about Troy? They did a CT scan on him, to see what's going on with his brain, to see if they can observe, as Dr. Ralston did with Ryan Hayes. He's got an anoxic brain injury. But that report doesn't even come back before the defendant is talking to Mariah, the stepdaughter, and Christine, the wife, about extubating Troy Allison. Remember Mariah's testimony? She looked right at him. You have the results of the CT scan? What, if anything, did he say? He didn't say anything. He just stared at me for a second and then turned and started talking to my mom. They told you, defendant told them, 99.9% sure Troy is brain dead and his organs are failing. What choice are these families given? What choice is Mr. Allison being given there? So, in addition to looking at the pain scores and the charting, in Mr. Allison's records, I would recommend you look at that CT scan that came back 1 minute after he was pronounced dead. And look at the results of that CT scan, which results were normal. Was he given a chance to declare himself? Was he given a chance to be in the ICU to see if his body could recover from the critical illness it was in? If you're asking yourselves, why are we here talking for weeks and weeks and weeks and hours and hours and hours about sick, dying people, what is the point of all of this? Troy Allison, along with all the other ones that could have lived, that's the point, folks. You didn't even wait for this result back. They didn't even chart pain scores. No other pain medication given to him. What purpose did he have when he ordered these drugs? Someone that's not in documented pain. Bonnie Austin was 64. She's 5'4". She weighs 152 pounds. On September 30th, she's having trouble breathing, so her husband calls the EMS. On the way to the hospital, she codes in the squad. They bring her back. She has a pneumothorax, which the doctors explained to me was air trapped between her lung and chest wall cavity. And so they have to cut, when they put a chest tube in to get that air out, they cut into her with a scalpel. They do it without pain meds, folks. She's intubated and taken to the ICU. On that same day, on defendant's order, she's given 600 micrograms of fentanyl, 6 milligrams of midazolam. She's extubated and dies within 30 minutes. David Austin talked about how he met his wife and was married, was smitten immediately with her and married within weeks of meeting her 30-some years before. He was told his wife was gone before they extubated her. It's over. He couldn't even be there with her. He just started walking. I don't even remember how long I was there. We brought in Tara Schwartz. She is the Bonnie Austin's grandson's girlfriend, who was present after she was extubated. She thought she was seeing a miracle when Bonnie would look at them and mouth words and stuff, because they were told, no brain activity, Brandy, she's gone. That's why David walked away, not because he didn't love his wife, because he didn't want to hold her hand when she died. He was told she's gone. She's not there anymore. He just laughed. Why would you? Tara sat in there, held her hand. I'm going to take care of your grandson. I'm going to take care of David. It's going to be all right. And Bonnie turned her head, and her and her mom were talking to her, trying to mouth something. Bonnie Austin was not gone. Only pain charted is when she is given the 600 micrograms of fentanyl. Nick Timmons. He's the second of the 2 overdose cases in this matter. He was 39 years old. He was 6'1", weighed 196 pounds. In October of 2018, he's found, it's in the medical records, down in the basement. He hadn't moved, maybe for days. They're not sure how long he had been there. They do find a hypodermic needle near his body. And in anti-mortem blood, just detecting Ryan Hayes, there were illicit drugs in his system. They called the squad. They gave him Narcan on the way to the hospital. He has very low blood pressure and sugar. He's positive for cocaine and marijuana. He's not dead, folks. He's talking to them. In the medical records, you'll see that. He's not some coma guy that's not there. He's talking to them. He's sick. He's terribly sick, but he's not gone at this point. He had sepsis, which is the body's reaction, overreaction to infection. It's very serious. He needed dialysis. And he needed surgery for compartment syndrome. That's when you stay in one spot for too long and the muscles get, the blood can't flow correctly, and that actually fillet open the affected muscles or, to relieve that pressure. You'll see that surgery. In that surgery, it says he was given 14,000 micrograms of fentanyl. Remember what the expert said about that. That is not likely that that is what he was given. That is not. Dr. Schweiger, who to this day works 70 hours a week in an ICU right now, said that is not what happened there. Because I don't know what that 14,000 is. That is not a dose anyone would get during this surgery. So, but that is in the medical records. His brother, Lynn, a recovering addict, who's living in sober housing in West Virginia. He gets there the next day. He has to wait for his girlfriend in Portsmouth to drive and pick him up and take him. But he's not coming to say goodbye to his brother. He's coming to be with his brother, to get him through this, because Lynn knows, just because you're a drug addict in the bottoms of on the west side of Columbus, doesn't mean it's over. Doesn't mean you don't have value. Doesn't mean that you can't come back from that. That there is life after addiction. Lynn, the man that came in here and testified, he's proof of that. That you can come back from even heroin and fentanyl. That there's life after that. And he's there to help his brother through. And he's told his brother's going to be okay. Until the night shift comes up. I don't know. What do you mean? The day, what happened? Your brother coded. Well, okay, so what's going on? I wouldn't leave. Look, man, I've been up for 30 hours. I got to go. I'll be home. I'll call him. How many times did they call him? Oh, he's coded again. Save my brother. He's coded again. Save my brother. He's coded again. Save my brother. He's told it's over, though, when he gets back to the hospital in the middle of the night. He's told it's over. He agrees to the DNR, CC. They excavate him. They give him 1,000 micrograms of fentanyl, 10 milligrams of midazolam. They excavate him. And 5 minutes later, he's given an additional 10 milligrams of hydromorphine, and then another 10 milligrams of midazolam. Remember, hydromorphine times it times 100, if you want to know how much that's equal to in fentanyl. That's in 5 minutes in medical records. Remember Jake Dealer's testimony? Remember how important it is to know what's going on at bedside, what's actually going on at bedside? Oh, his brother came running out. Oh, he's in so much pain. Is that what Lynn told you happened? You're thinking, well, maybe Lynn's got an axe to grind here, a stone to grind. Maybe Lynn's not being truthful about that with everything that's happened since then. Well, what did the other nurse that was there that night tell you? Nurse Cheryl. I do not recall anybody coming out of that room holler and save my brothers or give my brother more pain medication. I don't recall that happening. The other nurse that was in the ICU that night corroborates what Lynn tells you. Now, ladies and gentlemen, I would argue to you, Nick just wasn't dying fast enough. Look at the medications that were given. Look at the pain scores. Count 12, Sandra Castle. She's an 80-year-old woman. She's 5 foot, 240 pounds. She went to the ER on 11/9 because she was having some issues that they needed to adjust the gabapentin medicines that she was on. They send her home. They say, go home, schedule an outpatient, stress test, see what's going on with your doctor, outpatient. But the very next day, her heart stops while watching TV. Her son does CPR until the squad gets there. They bring her back. The squad brings her back. They get her to the ER. They do the hypothermia therapy. That's where they take somebody that's had potentially an anoxic brain injury, whose heart is stopped, and they put you on ice. Literally put you on ice. And pull you way down so that they can take care of the swelling of the brain and see if you're going to be able to survive this. I would argue too, that's circumstantial evidence. They had not given up on her in the ER. They sent her to the ICU and she's intubated. Now, Dr. Dellinger and Dr. Mahoney do talk to the family about withdrawing care after she's been there, after she's been given that time to declare herself. Not the same day, not within hours, not in the middle of the night, 3 days later. 2 doctors. You're going to see that in the instructions, folks. What's a terminal condition? 2 doctors say someone's in a terminal condition. The law recognizes this should not be a decision by 1 doctor in the middle of the night. You need 2 doctors to say someone's in a terminal condition. So she's extubated in the afternoon on 11/13, and look at the medicine she's given. Look at the medicine she's given before Dr. Husel gets there. The levels of morphine. Because nobody is about people dying in pain or anxiety. She was having some pain and anxiety. It is appropriate during this procedure to give people pain and anxiety medication. And she lives. She doesn't die in 10, 15, 20 minutes. She lives. And the decision is made, instead of transferring her to the palliative floor within a couple hours, which would have been the procedure, because she has so many family members there, they say, I'll just keep her here and get to see her. Instead of making everybody move down, etc., etc. We'll just keep her here. She's not an ICU patient anymore. She's a palliative patient at this point. She's not being actively, intubated, life-saving measures. They are allowing her to die naturally. Until that evening, about 11 o'clock, her daughter, Sarah Burnham's there. She hears the death rattle, that secretions that as you are progressing to death, you can't clear them on your own. The drug they give you to dry that out. It's loud. She didn't think it was so loud, but remember what Sarah told you? Not Sarah not coming out saying, something's wrong with my grandma, she's in pain, please help her. You stuck, their family comes in. Want us to give you something for that? Quiet it down. Yeah. Okay. In this count, ladies and gentlemen, you get a glimpse of appropriate comfort care. Remember when Dr. Ely was being cross-examined by Ms. Menashe about all the other things all the other doctors were doing for these patients in these records? Yeah, there was some good care going on at Mount Carmel West. There was definitely some good care going on. And you get a glimpse of it here. About the pain medication she's given, this pain she's in, and the stuff that's given to her for that. Until. And there's so many of these is because this is how it's supposed to be. This is not 5 minutes and you're done, 7 minutes and you're done. They put out a craft cart for the family, they bring snacks in because this is a process. Until the defendant orders 1,000 micrograms of fentanyl and 10 milligrams of methadone. Where is that justified in any way in her medical records? What is his purpose to quiet that rattle when he gives her 1,000 micrograms of fentanyl and 10 milligrams of gasoline? He approached them about it. Rebecca Wallace was a 75-year-old woman. She was 5 foot. She was 226 pounds. Her husband had passed. Her parents had passed. The person she did have in her life was her friend from church, Janet Watkins. And her friend from church says, something's wrong. You're not breathing right. I'm worried about your heart. You seem to be having a lot of difficulty. And she's telling her friend, I want you to go to the doctor. I'll take you to the doctor. She finally does. Takes her to the doctor, and the doctor says, you need to go to the ER. What's going on with your heart? So they do a scan of the heart. It shows she has a narrowing aortic valve. They put a stent in. If you'll see in the medical record, she was very nervous about this procedure because her family doctor had said the dyes they use for that procedure are very hard on your kidneys. And so the kidneys are compromised. So don't let them do that, But she talks and talks about it, and she sees this as her chance to have more life. Even in her 75th year. This is not a woman that's looking like, well, it's over, I'm done, let's get it over with. She takes this chance on this procedure that she knows has risks because of the dye they use and the condition of her kidneys. She wants to live. But there are issues after that. And one of those issues is that large bruise, that internal bleeding she's having on her thigh, on her inner leg, because of where they went in and nicked her artery there. She's transferred to the ICU because of respiratory failure and because the hematoma kept getting worse. Janet Watkins had to go take care of her husband who was having some issues. She calls. Dr. Husel talks to her. I'm glad you called. Yeah, it's over. It's time. She leaves her, gets someone to watch her husband, and she goes right to the hospital. This is another person. This is another person that had a very strong belief about having a natural death. Not dying in pain, not dying in agony, that's not anybody's plan. But to die naturally. She wasn't given that chance, folks. She was given 1,000 micrograms of fentanyl, 10 milligrams of potassium. She's extubated, and she's gone in 5 minutes. Look at the pain medications. Look at the pain scores. Melissa Penix. This is the one. Here we go again. Greg Dreschbach, the pharmacist, stumbles across this one. This is the one that finally got things to stop. 82-year-old woman, 5'2", 146 pounds. I would argue to you she is diminutive in size. She's taken to the ER on 11/15/2018 because she was very short of breath and coughing up a bit of blood. It's described as scant. So it's not like she's vomiting blood, she's coughing up blood, and it's even in the doctor's almost reads like, yeah, she's on 3 different blood thinners. So that's an issue. She had recently been in the hospital in September, but not for some terminal condition, not for some terrible cancer or other disease that's incurable. She had thrush, a yeast infection in her throat. She does okay for those 5 days that she's there. She's having some trouble breathing. They place her. They don't go right to ventilation. They place her on the breathing mask, the BiPAP. Her daughter's there, Deborah Leonard, talking to her mom. They're not there on a death watch for their mom. It is not occurring to them watching their mom progress through this hospitalization that this is the end. Her granddaughter was helping her put her makeup on the day she died. Dr. Woodkey, she's one of those attendings, the first one who testified. This is a template, a cut and paste job. She was like, it's confusing what's going on with her. Clinical picture is confusing. Well, not to the defendant, who convinces the family that Miss Penix is done, it's over, she needs to be extubated. And he orders to her, now he's not even using different opioids. Not even putting in 1,000 mics of fentanyl and 10 of the 11. Differentiate that between 2 different categories, which nobody does. Don't give a patient 2 different narcotics at the same time. Now he's just out and out. For the first time, giving straight up 2,000 micrograms to this 82-year-old woman with compromised organs, compromised breathing. She weighs 146 pounds. She's 5'2". Gives her 20 of these vials all at once in a bolus. States Exhibit 28A. You heard the wonders. The one witness say, yeah, it's a big syringe. You got to put this in. It actually depletes the supply they have on the ICU that night. A nurse, you heard the testimony of Greg Greshfall. Yeah, we're out of fentanyl in the Fixus ICU. Go get it from the other. Go get it from the other Fixus. No, we're out of fentanyl in the ICU. Both machines. It drained the system of what they had up there. And for good measure, on top of the 2,000 micrograms of fentanyl, 10 milligrams of midazolam, she's extubated or dies within 4 minutes. Look at the paralytics they gave her. Remember, paralytics are given when someone is intubated to help them so they don't fight the machine, so that they can let the machine do the breathing for them. You've got to make sure those are out of a person's system before you extubate them. Because if you're on paralytics and you extubate them, you're dead. You can't breathe on your own. And this is an 82-year-old woman who is critically ill. Look at the timing of those paralytics. Look at the timing of that medication. And ask yourself, what other purpose did William Husel have when he ordered those doses to be given to this woman under these conditions? Look at the pain medication, look at the pain scores. You cannot look into the mind of another. So ask yourselves, what actions, what circumstances tell us his purpose? These are some of the things I would argue to you, some of the circumstances, and I would argue to you, tell you what his purpose is. The size of the dose of the fentanyl. State's Exhibit 28B. I would argue to you, this is not a mistake, that this is a unit dose of fentanyl, 100 micrograms. Remember, they all said that would be the most I would give in morphine. I would give 10 milligrams. Maybe I've done that, probably in a divided dose, which is equal to 1 ounce. This is not a mistake, that in the ICU, in the Pyxis machine, this is what they stop. Because if someone needs fentanyl, this is what you give them. If you don't double it, triple it, or in the case of Melissa Penix, times 20 it. The size of the dose of the benzodiazepine. No one could actually recall the unit doses that the midazolam came in, but they all said it was several doses of the midazolam. And all the other doctors and the experts in this case told you those are giant doses. You start with 2 to 4, if indicated, not 10. His training in anesthesiology. He knew what these drugs do to people. He was trained at the Cleveland Clinic. This is not negligence. This is not reckless. This is on purpose. He knows what fentanyl and these benzodiazepines do to human beings. He knows it. And he's teaching it to these brand new nurses. His reaction when asked by pharmacy. Not a conversation. Not a, hey, this is what I'm doing this for. It's for a procedure. Oh, so there's not an next. It's for a procedure. Remember, he's not a man of many words when he talks to me. He knows people are questioning it. His reaction when asked by nurses. What did he teach them? What did Jake Dean tell you about lactic acid? Lactic acid, that's like when you work out and your muscles are all sore, and these people have really high lactic acid. So yeah, I mean, I know they're not in any pain, and I know we didn't give any pain medication, but now you see they've got all this lactic acid in their muscles. That's so painful. Well, what did an actual expert in this tell you? What did Dr. Schreiber tell you? Lactic acid in the blood, which is what they have, is not the same as lactic acid in the muscles. And in Dr. Schreiber's experience, lactic acid in the blood is not painful. But the nurses in the ICU, unwitting complicitors to all of this, are being trained. That's why we're giving them all this. Lactic acid levels. Look at, oh, we had to jam in this arterial line. I mean, they describe a Foley catheter, which does not sound like a pleasant experience, but they don't say, inserting a Foley catheter into a male. Like, jammed, Jim Beamer said, Husel talking about being jammed into your penis. Well, is that how you describe a Foley catheter? No, it's not. It's not. Whatever you could do, whatever you could train them, whatever you could indoctrinate them on, how much pain they're in, That's what he would tell the nurses. The quick deaths of these victims. Dr. Ely, I told you, I added up the times. The idiot time was very, very quick. I had never seen this before. No one else anywhere is doing this under these circumstances. Not at Mount Carmel, and per Dr. Schweiger, and per Dr. Ely. No one else in the world is doing what he is doing. Not even close. And there is no literature that supports what he is doing. And we talked about the unit dose of fentanyl as dispensed in the ICU. He's intelligent. They all said it. All the nurses that knew him. He's very smart. I would argue to you that is one of the factors that show he knew what he was doing. He was doing this on purpose. He trained at one of the best hospitals in the country. He's very proficient at all the other tasks as an ICU doctor. Inserting arterial lines. Remember, every time, that's what they crossed him on up here. Look, he saved their lives during this code. And he saved her life by giving her this medicine. And he saved her life by doing this. And he saved her life. Yeah, he's very proficient at all the technical aspects of the job. He knows how to adjust a ventilator setting. Here, let's show you. What do we do then? He's very good at all the technical aspects of what he does. But I would argue to you, a terrible healer, a terrible doctor. All of these things and more show me what he was doing. He was purposely hastening and causing their deaths. Each and every one of them, folks. Look at what the other doctors, every one of them that testified, including the experts, say. PRN, it means has needed. Ask yourselves this. How come he doesn't order any PRN medicines for any of these folks? You want to find where the shots are that killed everybody is? Go to the medication records on each and every one of them. Not the infusions, because the infusions start right after them. But the medication records, turn to the last one. You'll find it right there. He doesn't order PRN because he knows this is it. I'm going to give them this, and they're going to die quickly. They're not going to need as-needed medicine because I'm doing it all right now. He knew this. How do we know he caused? And caused, remember, with that instruction, there can be more than one cause of death. Cause includes hastens. The testimony of Dr. Ely, the testimony of Dr. Schweiger. Look at his qualifications, look at Dr. Ely's qualifications and experience. He's board certified in internal medicine in 1992. Not as the defendant became as a freshman and a doctor in 2011. 1992, Dr. Ely has been doing this since then. He's board certified in pulmonary medicine in 1996, and he's board certified in critical care medicine in 1997. Decades of experience. He was also years and years doing lung transplants. Richmond agitation scale, you ever hear of that? Oh, yeah. Dr. Sessler, my friend Dr. Sessler. Yeah, from Richmond University. He came up with that. You heard from the guy that validated that. That is published in the Journal of American Medicine for validating the RAS score. That's in use here and all over the world. It's been translated in over 40 languages. This is the guy who 20 years ago, with his friend Dr. Sessler, validated the Richmond agitation scale is used throughout the world in medicine. There's just no justification beyond Thunderdome, how I describe it. Like driving 250 miles an hour through a school zone while people are crossing the street and thinking you're not going to hurt somebody. He's been practicing more than 25 years and would never, ever use these doses. Why isn't there medical literature that supports it? There's no literature. Nobody does this. These were lethal doses. So while the defendant is good at the technical aspects of what it takes to be a nighttime ICU doctor, I would argue to you Dr. Ely shows you what it is to be a healer, a doctor actually. Someone that is there to care for people and to treat them, even in their deaths. He's a technician over there, folks. He knows what he's doing. That doesn't make him a good doctor. Dr. Schweiger. Well, if you wanted somebody that had the same background as the defendant, because that sends you to a point that, well, Dr. Ely, internal medicine. Well, Dr. Schweiger has the background in anesthesiology that the defendant does, right? He has that. He's been board certified in anesthesiology since 1994. So almost 3 decades ago, he was board certified in anesthesiology. But what else is he board certified in? Critical care, which is what we call the doctor who works in the ICU. And what else was he board certified in? Acute and chronic pain management. Boy, that's what I would argue to you this case is all about, right? And this is the guy that is board certified and recognized as an expert in those fields. He's board certified in acute and chronic care management. He knows how to do it right. Had these patients declared themselves, term of art we use in the ICU. That's the whole point. We're not doing this just as like as a way to spend money on somebody at the end of their life. You're sedating them, you're intubating them, you're paralyzing them, not because we want to run the bill up, we're giving them time. Time is what this is about. To let the body heal itself. Not all of these patients, he told you, within a reasonable degree of medical certainty, based on his training and experience, had reached that terminal phase. And the judge will tell you, in the state of Ohio, the definition of terminal condition has a requirement that 2 physicians declare it. He told you lactate in the blood is not the same as lactate in the muscles, and his experience is not painful. And this is the guy that's board certified in pain management. Told you over and over again on each and every one of these 14 victims, there is no medical justification for the doses of fentanyl and benzodiazepine. I'd like you to consider, I'd argue you to consider his qualifications, consider his prior experience. You heard from the testimony of Dr. Ziv. What did he really tell you? What did Dr. Ziv really tell you? I would argue to you he spoke in generalities. He didn't talk in any specifics about any of these 14 patients. Didn't talk in any specifics about the doses they were given. I would argue to you he didn't do that because there's no medical justification. He wants to talk about in general. You want to cover the pain. In general, you want to do this. And unlike Dr. Schweiger and Dr. Ely, who took the deep dive, the necessary deep dive, the reason this has taken 8-9 weeks, however long we've been here, and what we...
Okay. What? I didn't hear what you said.
Burden shifting.
Okay. Ladies and gentlemen, it's the state's obligation to prove here. The defense doesn't have to prove anything. Okay? Now, he can comment on the testimony of the doctor, but it in no way shifts the burden to the defense at all. Do you understand that? Continue on, Mr. Zahn.
Unlike Dr. Schweiger and Dr. Ely, who took the deep dives on each and every one of these, and made mistakes in their reports. I mean, one of the mistakes was he referred to the victim as a he rather than a she. But there were other significant mistakes about procedurally what occurred to some of these people. He said, oh, yeah, no, that's right. Yep, you were right. In the medical record, I had said this happened at this point, but you are clearly showing me right now this is what happened. Yes, that was a mistake. Yes, that was an error. And they both did because, I would argue to you, the massive amount of material they reviewed and delivered evidence on. What did Dr. Zivit tell you about any mistakes or contradictions? Nope. 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 He didn't admit one thing was wrong with anything he said. What about the established medical science that's been tested, that all the other doctors in this case testified about the known synergistic effect, the potentiating effect when you give benzodiazepines and narcotic pain medication together? 1 + 1 doesn't equal 2. 1 + 1 = 4 or 5. And that wasn't just the experts. That was the doctors at Mount Carmel, the other doctors, his former colleagues. That was the pharmacist who told you that. That is a known thing. There are studies about that. No, I don't. That's not. So when the science contradicted what he wanted to tell you, that's not real. What about this organization you belong to and their recommendation? Oh, I resigned from that committee. I don't agree with that. What about when you testified previously? Oh, different context. What does that have to do with this? That has nothing to do with this. Different context. Wouldn't admit that there was anything contradictory or mistaken, except that apparently he accidentally put on 2 degrees he didn't have on a CV. That was one thing he did acknowledge he had made a mistake about. I would argue to you that what he is a crusader on is the government, the state, getting into the business of medicine. Doesn't like it when they do it in the death penalty. He doesn't like it when they do it here. And he's not some random doctor that was pulled from some hospital in Tennessee or Florida. Somebody sought out and said, what about this? He has a connection to the defendant. They share a mentor. So consider that in evaluating the credibility and the veracity of his testimony. Double effect. You heard a lot about double effect. First of all, it's not a law in Ohio. It is a bioethical and philosophical doctrine that doctors should be guided by, not just in palliative excavations, but in all they do. It is a recognized thing doctors have to consider, and that is the good must outweigh the bad. It's about proportionality. That's what this is about, proportionality. Does this good that we want to do, control pain, outweigh the bad, speed up death? So that is, while not a law in Ohio, it's something doctors need to take into consideration. And all the doctors say, well, it's about proportionality and moderation. And that, what he's doing to these patients, all 14, is not proportional to any symptom they have, and it's not moderate in any way or in any way. It is not a carte blanche for a doctor to do whatever he or she wants. The fact that there maybe have been more than one cause of death in each and every one of these victims is not a defense, as long as the drugs he administered were either the cause of death or the hastening of death. Remember that instruction when the judge gives you. There may be more than one, there may be one or more causes of an event. However, if these drugs were one of those causes, even if they had these other diseases that also caused their death, it's not a defense that they were just really sick people and died anyways. And Dr. Ely and Dr. Schweiger were unequivocal after the thorough and complete examination of these medical records. These doses either hasten or the out-and-out cause, especially in Melissa Penix's case. The out-and-out cause, he killed her with these drugs. Another thing, once again, we're back to that. This is about reason. This is about common sense. 12 people from the community in Franklin County. This happened in your town, in your county, folks. That's why you're here. What does your common sense tell you about fentanyl? Fentanyl is a powerful, dangerous narcotic pain medication with the known effect of suppressing respiratory function and can kill a person. Bedazzling is a powerful, dangerous benzodiazepine with the known effect of suppressing respiratory function and can kill a person. These two drugs used together have a known demonstrated synergistic effect, which potentiates the effects of these drugs they have on their own. People die every day in our community overdosing on fentanyl. Not something we just call fentanyl, it's really something else out there in the community. Fentanyl. The drugs he used, now not pharmaceutical grade, not of the purity he's giving them, but what everyone's out there dying and overdosing on.
Objection, Judge.
Okay. Sustained.
In your common experience, what is going out there?
Objection.
Judge, I'm allowed to talk about the common experiences of our community, and this is a
I
common
understand
experience.
what you're allowed to talk to. It's sustained. Move on.
Dr. Schweiger talks about the Utah study, This is one of the many studies that he testified about the known synergistic effects of these two drugs. The one that Dr. Zivit just said, I don't agree with him. These are 12 healthy men. And when they gave much lower doses than what he was giving to these very sick older people, 11 of the 12 had to be rescued. You're like, what are we here for? I mean, these people are so sick. Brian Hayes is gone. Drug addict. Timmons, gone. Drug addict. They're on their way out. Why are we here? Because it's a crime to kill a dying person, folks. So at the end of the day, though, you'll also be instructed on attempted murder. And this, you only get there if you feel the state has not proven beyond a reasonable doubt causation, in fact, on each and every one of these. And you're to consider each and every one of these separate and apart. That's why this has taken so long. These are 14 separate murders that in and of themselves would take a long time by themselves to try. But these are 14 altogether. So you look at count 1, and then you look at count 2, and then you look at count 3. And on any one of those, if you're not firmly convinced, your reason and common sense doesn't tell you 2,000 micrograms or 1,000 micrograms killed these people, actually caused their death, you may consider the lesser of attempted murder. And in attempted murder, before you can find the defendant guilty, and that's on each and every one of these, the lesser included is, was it his intention to at least try to cause or hasten their deaths? So you will be given the instruction of the lesser included offense of attempted murder in these cases. But only go there if you, as a group, no, state didn't prove cause on count 1, count 2, count 3, etc. Whatever count you're on. I say that way because it's not like an all or nothing thing. It is each individual count needs your separate deliberations. Don't go there as a compromise if you believe the evidence supports the greater charge. Attempted murder is the same thing as murder, just with the word attempt in there. The judge will tell you what attempt means. We talked a lot about this. We talked a lot about the purpose. What was someone's intent? Why was he doing this? Motive. The state need not prove motive. The presence or absence of motive is one of the circumstances bearing on the defendant's purpose. And the judge will tell you, in the state of Ohio, you can have a good motive for doing something. You can have the best motive for doing something. But if it's illegal, if what you're doing is a crime, but I'm doing it for a very good reason. I'm doing it for the best of reasons. I'm doing it for mercy. I'm doing it because I think this is what good medicine is, quickly and painlessly causing the death of these dying people. I'm doing this because I want to be a good doctor and do good in the world. But if he is purposely causing their death and includes hastening their death by this, that good motive is not a defense in this case. We've talked a great deal about this in blood here for this very reason. Motive is the why. One of you said when we were talking about it. Motive is the why. Why did you do it? Purpose is the intention. What did he intend to do when he did it? You can find that he might even have had a good reason as to why he purposely caused or hastened the victim's death. That's not a defense to the crime of murder in the state of Ohio. It's like what we talked about in one year with the vet, right? When your dog or cat is at the end of its life, that vet who has given great care to your animal throughout the course of its life, who's done everything, who's done miracles, to bring it along. But when it's over, and you've made the decision that it's time to, what we euphemistically call, put them down, put them to sleep, and you take them to the vet is not giving them that medicine because that veterinarian is a bad person with malice in their heart for that dog or cat that they've otherwise given great care to. They are doing that out of mercy because that is what you do to sick animals. But their intention is not just to cover the pain and let them die a natural death. Their intention, their purpose, in giving the drugs they give those animals when they euthanize them, is to kill him. And that's fine in veterinary science. That is not fine in the ICU at Mount Carmel or anywhere in the state of Ohio. Things not to consider. Of all the things, and I want you to consider all the evidence. And to reiterate what the judge just said, I want you to hold me to my burden. Because I've got to prove these things to you beyond a reasonable doubt. And this is too important not to hold me to that burden. So while I comment on what you consider Dr. Zivit for, remember, no matter what, hold me to my burden. Did I prove to you that he purposely caused the death of each and every one of these people? And of all the things I want you to consider, no matter who produces the evidence, either through direct testimony or through cross-examination, which was extensive, was excellent. The things I ask you not to consider are things like sympathy. Either sympathy for the victims' families who lost their loved ones and then were told months, years later, they did not die naturally. Or sympathy you may have for the defendant and for those that are here who love and care for him. Put that aside. Any bias you may have, either against the people that testified for the state, or any bias you may feel against anyone else involved in this, put that aside. The last thing I ask you not to consider, and the judge will instruct you on this, is the topic of punishment. Punishment, if we get there, and I argue to you we should get there in this case, is reserved by law to the judge, Judge Holbrook in this case. And as I said in voir dire, I know it's on your mind after a guilty verdict, because if anyone chooses to talk to us afterwards, that's the first thing they ask, and that's fine afterwards. But in considering whether or not the state of Ohio is necessarily believing that he purposely caused the death of any of these folks, of all of these folks, I ask you to take that out of the equation and just consider the facts, circumstances, and evidence. So what to consider? Everything that's been admitted to, physical exhibits, the testimony and stipulations. That's the evidence in this case. Thank you.
Thank you. Mr. Baez, it's late in the thing. You want to stand up and say hello, and basically that's about it?
I'm more than happy to start when we all come back from lunch.
Okay, fair enough. Let's give you guys, we'll get started at 1 o'clock. Okay? Have a wonderful break. Remember the admonitions. It's particularly important you don't start discussing the case. You don't have the law yet. Okay? With that,
All rise.
have a great lunch, guys. Thank you for the coffee, by the way. Y'all can be seated. Okay, for the record, anything, Mr. Zion?
Well, we would like to talk about some of the slides the defense has provided to us this morning.
Do you guys want to do that here, or you want to do it in back?
You can do it on the side. I'm hoping this won't take long. But
Well, why don't we do this? Why don't we eat our lunch? You guys talk about it and see if you can get a compromise. If you can't get a compromise, then we'll meet, let's say 22, 1.
sure.
That way my court reporter can get something to eat. Okay? Anything else?
No, Your Honor.
We'll get started with continuing the closings at 1. With that, I'm going to close the record.
I want to make sure that Matt knows that was there, and I'm sure he does. And then once we switch out, and Matt, you know that laptop.
I'm sorry.
Oh, the TV.
He just went that way. I think maybe, yeah, we'll just try this result. This is working fine. Yeah, Matt's going to sort it out.
Oh, good, good.
Yeah, we need a college visit Saturday. It was kind of cold and rainy. So enjoyed a nice Sunday. Our youngest daughter, because we have 6, 3 boys and 3 girls, is a senior, is committed to Ohio Wesleyan in Delaware. So it's fun, private liberal arts school. And I'm excited because that's where I went, but I didn't influence her. She wanted to go there. So it was, it's fun. It's always good to go back and visit, not too far away. So it's such a cool experience. So, yeah. In hindsight, I was going to look at the following Saturday, but you never really know the weather.
What does she play?
Well, actually, she plays lacrosse, but I don't think she's going to play in college. But it's Iowa Wesleyan in Delaware, Ohio. So, fairly well known. Good.
I'm curious.
Yeah. I went there many, many years ago, graduated in '86. They also do a little extra for you if you're a legacy as far as scholarships. Otherwise, it's, $63,000.
I go to Capital Law, so
yeah.
I know, yeah. Lots of student loans, they're fun.
Yeah. I think I am student loan free.
How did you manage that?
Scholars, baby, scholars.
Yeah.
I had nurse school my first year of law school, and then that summer I negotiated.
Would you go back and tell them we're done with the technical difficulty in maybe a couple minutes?
Yeah.
What helps in your Cali in every class?
They kind of expect that when I pop in about 10 minutes still.
Didn't help either that I was in the swing with the dean. Barely drinking wine, and when I got the email saying we're going to pull the next one, I'm like, you got 2 extra options here. And he's like, I don't worry about it. By the time we get back in the I'm like, well, I need to know now because I need to like transfer. And literally by the next day, I knew like, oh, that's fine.
Well, it was like about 60 grand a year, but I did it summer, so more like 70 grand. And I got like 20 grand in scholarships. I also went. So I don't have the time to offer like options, but
They wanted to fabric afterwards the whole article. I was like, yeah, that's a hard one.
that's hard. It's good. About to be good time. We'll be in 4H.
Yeah, I have.
Might be able to talk my buddy into letting me take the vote out. Hey, you know the rule. You know what's better than the vote? Everybody that wrote the vote. I was like, put more there. But those are in a very particular order. Previous ones. This paper. Yeah.
Is it dead there, Matt?
What's that?
Is it dead?
No, it's on. I just have no idea how it works. The phone never shows me.
Well, he's got to hit the camera first, I think.
What about the camera?
It's hooked into the camera, I believe.
No, it should be showing the same thing these are.
Okay. Why don't you put on your PowerPoint for a second, see if it goes on the screen, please? Turn on your PowerPoint to see if it's showing on the screen.
It's on.
Huh?
This is the first slide. Those blank pages that you see, those lines.
I understand that. I just want to make sure that that's what they're seeing over there. Are you seeing three white lines?
No, they have like a screensaver here on it. This monitor works. That screen works. That doesn't.
No, yeah. No, I tried. I did not.
The feed is on.
Amy, did you guys show them all the magnets?
Magnets.
No, we didn't see any of the magnets.
They're everywhere.
I assume they're pictures of people.
Just pictures of people with
I asked you
pictures.
specifically what those were, and I said, is there anything underneath there? And you said no. Was that a joke?
No.
Is there something underneath this?
No.
That's right.
It's a magnetic board.
I apologize. I thought you said no.
Well, I'll put it this way. They're so similar to the pictures you use. I actually asked my tech guy if you stole our pictures, because that's how close they were to.
Okay, no. I thought you had something underneath this thing,
No.
like he did in the beginning when he's pulling things off.
It's a
and I said-
magnetic strip.
No.
Oh, okay.
See?
Well, I haven't seen these either.
Have you guys watched the videos?
We're watching the last one, which is a
These are the
video
pictures you guys sent us.
Okay.
that is going on 2 to 3 minutes long.
See, that one I was pretty sure we both had the same one. And that one. Mm-hmm. And that one.
Yeah, I have no objection to any of that.
They're all just literally pictures from the testimony.
Okay. Trust but verify. Because I was just told some things about the video clips, and there's Casablanca in there.
That's before my time. I don't really like Casablanca.
It's a good movie. You should watch it.
I don't appreciate it.
Well, there you go. Look at you.
I got time for this experience once I was born. And it's just the family members. Same thing.
They spent a lot of money for all this to go back to the court.
Well, we can have the, what was it, the drug dealers fund?
What's that?
What was it, the drug dealers fund or something you guys used?
No, just use the people's money.
Yeah. Taxes.
What are these?
Same ones we saw this morning. Promise I didn't bruise those and not any.
Just checking out.
Right?
All right, Judge, we've had a chance to look at this stuff.
Okay. As soon as my court report is ready, we'll go back on. Okay, Mr. Zion, you've had an opportunity to review. What's your commentary now?
Well, there appears to be a clip from Casablanca in there. We would object to that. There appears to be at the end a clip of a desert escape, which is a movie. Several minutes of that. We would object to that. And then there is a clip of the testimony of this Phoenix's daughter, and they've labeled it witness or evidence tampering, which we believe is entirely inappropriate.
Okay.
I'll take down evidence tampering if it.
Yeah, but I don't mind the clip. It's just a reiteration. Anything on the long clip?
Which long clip, Judge?
There was one that was supposedly 3 minutes long. That was a combination of the nurses.
Yeah,
It's
it's
4 minutes, and there's multiple nurses on that one, but there wasn't anything. And then
Okay.
the 3 minute
I'm willing to cut that in half and stop it halfway through.
No, It's no different than putting it up on the screen. It does have thing, as long as you put the proviso in, going in, that it's their collective memory that matters. This is to aid and assist you. That's it. We move on. Casablanca is a great movie, but
It's an analogy that I'm going to use.
okay.
It's an argument. I don't.
Well, how do I get out of avoiding 106 and having to show the whole movie? It's a great movie. It's one of my faves.
It's just an analogy, Judge. It's 20
Okay.
seconds long.
Fair enough. And the sunset? We all love a good sunset.
That's another analogy that I use.
Okay, I'll note the state's objections. I'll permit it as long as the proviso is put in. If you go into it and you start playing without the proviso, I will stop you, make the proviso, and then let you go on.
Yes, sir.
Okay? Anything else before we get started?
Please, the restroom, Judge.
Okay. I don't have any idea what Matt did over there. Is that screen working now? No? I apologize, folks. That one's working?
Yeah, that one works. Can you just hold the angle a little bit? Yeah.
This is what happens when Paul retires mid-trial.
It's the Zoom. It's all the Zoom rooms.
Yeah, I wrote if it has anything to do with gas settings.
I don't know. They made those improvements. Supposedly it took a whole day doing it, and it still doesn't seem to always plug in correctly.
JD, do you want this?
Did you guys take camera shots of those in case? Because you put them up in front of the jury doesn't mean he ain't going to go after them. I would make, if you got an exhibit you're going to use that's demonstrative,
Yes,
just for your own sake, make a camera shot before you go,
absolutely.
okay? Because as soon as you put it up, it's fair game.
Understood.
I don't think it's going to be resolved.
Okay, let's bring the jury then.
We're behind when this whole tricky and.
I apologize, people in the audience. This is a software issue.
Yeah, it happened.
We can't get it resolved today. We'll try to get it resolved in the evening. Yeah, let's roll.
Bottom right. You gotta sit. I think it's at its highest. Sure. Yep. Yeah. Thank you.
They're one of the happiest juries I've ever seen.
All rise. Thank you. Please be seated.
Ladies and gentlemen of the jury, I hope you had a wonderful lunch. Mr. Baez, are you ready to proceed?
Yes, sir.
Go ahead.
Please support. Good afternoon, ladies and gentlemen. Welcome back. I first off, I too want to join Mr. Zeiner in thanking you for your service in this case. Both sides know it was no small task. And it's interesting because I've often said for a long time that jury duty is kind of like the worst job in the world. You have to sit here for 8 hours a day. And sometimes when we go off and speak in secret behind your back, it's not really behind your back, you have to sit next to someone who you don't know, you're complete strangers, and the only thing you have in common, you can't talk about. So it's understandable the sacrifice that you guys have made. And, you know, justice is a lot like making sausage. Once you see it, you never want to eat it again. It's kind of like that. It's not a scripted event. And things don't always go smoothly, especially when two sides see things very differently. So for that reason, it's this part of our presentation is a little different, because I think there's going to be times during the case where you saw things come out and you weren't really sure what's the point of that, or what are they trying to show us? I don't get it. And as artfully as we think we are as lawyers, it just doesn't make sense. Sometimes we have to help you connect the dots and show you what it is that we're referring to, what certain pieces of evidence came in, and I plan on doing that this afternoon. Over one of the weekends, I was sitting here thinking, how do I want to explain some of the constitutional principles to you? And I sat here and I sat at home and I thought different ways. And it's unique because the world is not the same as it was a couple of years ago. I think we all agree with that. Things have changed. And we realize just how divided a nation we really are. How different we are. How different we see the world. And fortunately for us, the constitutional rights that we have as citizens have never been more so important than they are today. Never. And when you think of things, you think of that we all, as citizens, we all have rights. And it's interesting, when you look at rights, you say, well, do you really have rights? I mean, half this trial, you had to wear a mask before you came in the building. Some of us have had to get vaccinated. There's all different types of things that come into play. And you might say to yourself, well, there's the Bill of Rights. The Bill of Rights is where I get my rights from. But if you read the Bill of Rights as I do, they're not really rights at all. The government can pass no law that tells you what kind of religion you should practice. You have the right against the government from having unreasonable search and seizures. You have the government cannot restrict your speech in certain circumstances. So they're not necessarily rights as much as they are to the government. Wait, you cannot do this. It is a restriction on the government more so than it is an individual right that we carry around with us every day. And that's where these concepts come from. Concepts of beyond reasonable doubt, concept on not having a burden when accused of a crime. But what makes it real and what brings it to life are you and you and you. This is the unique opportunity where you are serving to maintain those rights, to make sure that it's not just verbiage, that this is something real for which we've all made sacrifices, and those who came before us made the ultimate sacrifices on the altar of freedom, where we're equally treated, all of us. And a citizen, whether you're rich, you're poor, you're white, you're black, Puerto Rican, what your sexual preference is, whatever it is, that we all be treated the same, and that we have equal protection under the law. I don't say these words lightly. I don't use them lightly, because in this scenario, where you have all put your lives on hold to ensure that our rights are upheld, no matter what governmental agency chooses to do, whatever the system is, the ultimate decision will lie with all of you. But it doesn't mean anything if you can't hold on to those rights. And when I refer to the beyond a reasonable doubt, it's a brilliant concept in one way too, in another way as well. It takes into account our biases because it sets that bar so high. You may walk into a room and not like a certain person, but you all swore to take, and you took an oath to say, I'm going to hold the government to this burden, which is beyond and to the exclusion of every reasonable doubt. Now, I heard Mr. Simon this morning talk about circumstantial evidence versus direct evidence that's just as strong. Yes. But you have to have evidence. And there are numerous times in this case where you've been asked to take a leap of faith, to find things that aren't necessarily there or might be there. Well, that's not beyond a reasonable doubt. And that's not fulfilling your burden. And in that essence, there's something else. Each one of us has a role, as you've heard. The judge will instruct you on the law. It is what the judge says is the law, and the buck stops there. I am Dr. William Husel's voice in court, as well as Ms. Menashe. We bear no bones about that. And we do so proudly. In addition to that, the state of Ohio has a burden, they have a job, and they have a duty. And that duty is to be ministers of justice. That does not include putting forward before you anything that is not true, misleading, or just not fact. Each and every one of us deserves to be able to go through the process of justice without that ever happening. And I can tell you, throughout this case, it was an exhausting effort to go and weed through all of these things and point out to you multiple times where we thought you were being misled. I don't think we caught every single thing. We are far from perfect. And as I stand here before you, my heart is beating quickly because I'm afraid throughout the time I have to speak with you this afternoon that I'm going to forget something and let him down. That there are so many things to point out to you where there's reasonable doubt, no doubt at all, no evidence at all, things that were fed to you that were just not true, that are completely contradicted by the records. And it's not about making stuff up. That's not what this process is for. It's ever so important for you to hold on to these principles for the mere fact that it is one of the most important decisions you will make in your life. On top of that, in our system of justice, it's true that you're not to consider punishment. That's what makes your decision that much more important. Our system says that while you are going to make an important decision, you are not to consider the consequences of that decision. So it's important with the role that you have in this process that you hold them to their burden and that you ensure that what you do and the decisions you make are yours. You have every right to your convictions. And while you're supposed to, throughout the deliberation, listen to your fellow jurors, if it's your belief, you hold on to that because that is what we have all paid for. That's the sacrifice you made in front of the altar of freedom and all of those who came before you. And nothing could be more important than to remember that throughout this entire process. Now, I want to go through some of the instructions, and I don't want to take up too much of that time because there's just so much to cover with you in such a short period of time. But some of the instructions that I think you'll utilize during your deliberations are these. Is that the first? No, we went over. We're going to go back. First. Proof of motive. Now, you heard a lot during jury selection that they don't have to prove motive. And that's true. But there's a portion in the instructions that are important. And that is, proof of motive is not required, but the presence or absence of motive is one of the circumstances bearing upon purpose, which is the intent. I believe it was Aristotle who once said, all that is done with an eye towards something else. Simply put, to understand the deed, you have to understand the motive. Why? And all of you know that there was not one shred of evidence submitted to you as to why we're all here. Why will this man risk his family, his career, 17 years of trying to be a doctor, every single thing he has worked for, to hasten someone's death or to kill them? Specifically to kill them. Now you have a tough job because this is such a unique case. It's a novel prosecution. The mere fact of taking someone off life support, as you've all learned, is hastening their death. And not a single person has testified to you as to how long they would have lived without the fentanyl, or the Dilaudid, per se. How can you say it's going to hasten someone's death if you don't know how long they had to begin with? No one testified to that. That's asking you to take a leap of faith and they didn't provide that to you. And there's so much more, so much more. As it relates to purpose, I don't like this word purpose because it kind of is a little misleading. But simply put, purpose and intent mean the same thing. I think intent is a little more helpful in remembering it. What did he intend on doing? Where is it that he intended on killing people? Where did you hear that evidence? Now, there's a lot of innuendos and a lot of taking certain facts and trying to substitute what intent actually is. But the reality is that no, there wasn't anything of intent. Now, the prosecution earlier said, well, you can't get in someone's head. True, you can't. But there are lots of other things that you could look towards that would be very helpful in that regard. And he also said that's it's not something unless someone expresses it. And he did this with his hands. Well, we're going to get into that a little bit later, but I want you to remember that. And all of these records, every single thing here, a majority of all of this is all we have. And there's numerous reasons why that's all we have. And I'm going to get into that in a minute. But there's numerous reasons that this is all we have. And what the state is going to ask you to do again is take that leap of faith. Go against common sense. You all know common sense tells you that he's got no reason, no motive to harm these people. He had no motive to harm his patients. To the contrary, you heard evidence after witness telling you about how this man saved lives, how this man was always accessible, how this man was a teacher of nurses and other individuals at the ICU. They're trying to use that against him. Like it's a bad thing to help your team be smarter, better, operate in a certain way that helps the overall patients. Why is that a bad thing? How is that a bad thing? It's a bad thing if you want to prosecute someone for this. It's a bad thing in every other context of a prosecution, but not in the reality for which we live in. Now, there was the issue of cause. And I heard that analogy of shooting someone as they're falling down. None of that is relevant here. But one part in the causation instruction says this. And cause is an essential element of the offense of murder. Cause is an act which in a natural and continuous sequence directly produces the death. But here's the kicker. And without which it would not have occurred. They didn't tell you how long these folks, or show you any evidence. In fact, every expert said, I can't tell you. So without the fentanyl or the doses, how long would they have lived? How did we hasten it? Without which would not have occurred? No. It was an amazing thing to watch Dr. Shriver get up here and tell you all that all of these patients could have lived. When in fact the state's own prior expert said nothing of the kind, said only 4 of them could potentially live. They're contradicting themselves. They can't even agree amongst themselves. So, what we did, without a burden, we called Dr. Zimmerman. One of his most memorable quotes to me is, the easiest cane to bear is someone else's. Nothing could be truer. I think that resonates with a lot of people, including doctors. And they wanted to argue to you that he was general in nature. And I think Dr. Zivit's testimony, I'm bringing him up first because it's the most recent. And I think it's important to just touch on this fact. Then I'm going to start at the beginning of this case and how it started. But yes, it's not our burden to, after 2 months of sitting here, day in and day out, and hearing how sick these folks were, how many times they died. They died. How many things William Husel did to save them. You had heard it plenty of times. I guess I could have had him here for 2 days like Dr. Schreiber and gone through each and everything. But I know, I'm watching you and knowing that you're paying attention to the multiple times that they've done that. And here's the kicker. We put him up there. He told you he reviewed all of the medical records, including the dose amounts, and he found that they died from their diseases. And then it was open season for them. They could have did like we did with each and every doctor and cross-examined him on each and every single patient as to where he was wrong in his opinions. But it went unchallenged. His opinion went unchallenged and not cross-examined on one single patient. Not on one. He told you that morphine and fentanyl are two different drugs. Two different things. And this was important for you to know because there's been tons of evidence, misleading evidence, that's been submitted to you that it's equal to fentanyl. No, they're two different drugs. You heard Dr. Zivit tell you cannot give high doses of morphine. It's a natural opioid. Fentanyl is a synthetic one which was created to give higher doses. The only reason you would do the comparison is to determine if someone's naive, their tolerance levels. And isn't it interesting that in 3 hours this morning, not one mention was made of any of the tolerance of these patients. They're all through these records. Both their home medications and the medications they received at the hospital, they're there. It's a critical part of this case. But that's not shared with you. That's not pointed out to you. And the fact that morphine is different than fentanyl went unchallenged. And then he explained the differences between an internal medicine doctor and an anesthesiologist. Where and how you are trained is a significant fact. We hear of second opinions all the time. Even doctors who are similarly trained can have difference of opinions. They can treat you differently. And this is something we ask all the doctors in this case, is how is it that we're trained at the same place, but yet we could see completely differently as to how this patient should be treated. There's, I guess, a third opinion, too, which is the state of Ohio, who, despite the fact that there are no maximum doses, that fact went uncontroverted, unchallenged. There are no maximum doses of fentanyl. Why is that? Did they forget? Nobody forgot that opioids are an issue in this country. Nobody forgot any of that, but when it comes to palliative care, there are no maximum ranges. It's for the doctor at bedside to make that determination. That's it. And they want to make the comparison to street fentanyl. Nothing could be different. We don't know what's in that stuff. We've seen some users and what they find in their fentanyl, carfentanil, morphine, alcohol, cocaine. But who knows what they're taking there? Who knows where that's coming from? It's very different. I submit to you, it's probably why this case was brought in the first place. Everybody knows the negative connotation, especially here. Especially here. Everybody probably has someone close to them or knows someone who has someone close to them who's passed. And it's not pretty. But it's easy to drop that F-bomb, fentanyl, and make that argument when you don't have evidence. Make that argument. Yeah, they challenged him on a bachelor degree. He went to Canada. There's no direct correlation between what doctor lies about having a bachelor's degree. How ridiculous is that? That's what they impeached him on. Rather than helping you with the patients, they're rather talking about bachelor's degrees, lower degrees, and what was unique about Dr. Zivit, very unique, is that he trained at the same place as Dr. Husel. They didn't know each other at the Cleveland Clinic. He came much sooner. It was the director of the Cleveland Clinic who reached out to him and asked him to get involved. And the man did so. And he put his money where his mouth is. Dr. Schreiber made $7,000 before he even spoke with one patient. Dr. Zivit, as you heard, is against euthanasia. And he's also uniquely researching an area that is very unique. This is the one guy who researches how to use medications, how they actually kill people in the death penalty. That's another important factor that made him a unique, highly qualified individual from Emory University, one of the finest medical institutions in the world. This is no guy from Tampa, from a Catholic hospital in Tampa, who may or may not be the director of anesthesiology. This is not another doctor from Tennessee who's a devout Catholic and is baptizing people in the ICU. Now, I don't know where or how religion found its way into this case, but it really has no place. And this is not an attack on Catholics. I'm not going to be a Catholic myself. But this has no place in this case. But somehow it kept creeping in. Somehow it kept coming in. And in fact, this morning it was mentioned people go to a Catholic hospital because they want the Catholic treatment. Well, if that's the case, and the privilege of suffering is an issue, they should have made that a lot more clear with their policies. Another thing that is uncontroverted in this case. No policies at Mount Carmel, no upper limits. You have your basis of your training. And Dr. Zivit told you, how much is enough? Whatever it takes to get that patient there. And what's unique about this, ladies and gentlemen, is you saw throughout the case, there are multiple patients that did get these high doses, but it still wasn't enough. It still wasn't enough. And then you have a patient like Sandra Castle, who they were utilizing the order sets, and that wasn't working. She was suffering. She was in pain. She was suffering a bad death for hours at a time. Hours. Even after having maxed out for amount on morphine, she was still in pain. You remember Nurse Discharge, who had only worked 6 shifts, has no allegiance to William, wasn't enthralled by him and his charm, and still works at Mount Carmel. Tell you, I could hear her at the other end of the ICU. I saw a tear coming down her eye. She was agonally breathing. I'm telling you, agonal breathing is not painful. Agonal comes from the word agony. And to try and mislead you down that path is just another series of things that, quite frankly, if you can't trust the messenger, you can't trust the message. And you should not be misled or lied to once. I owe you an apology. Because at some place in the middle of this trial, I told you, or I asked Dr. Roth about Googling something where I did not see an article. That was my mistake. And I submit to you that's the only thing I can think of, or perhaps I asked a question that might have been a little misleading. Everything I told you in opening statements, I meant it. Everything that we asked about and we showed you, we tried to bring you the whole picture. And don't you think, maybe it's just me, but don't you think that we want to hold our government to a little bit of a higher standard than to mislead us, than to outright telling us falsehoods? Let me show you one. And this is another reason why I put Dr. Zivit first. You remember, during the cross-examination of Dr. Zivit, well, they tried to talk to him about giving doses to healthy individuals in a death penalty case versus someone in a terminal excavation, which we all learned is different. But in the questioning, he was asked a hypothetical. You all remember, I was here, I tried to go after that hypothetically and have the records. Well, now I can show them to you. A hypothetical posed to Dr. Zivit was with a patient who is being told they're brain dead and not being able to, being misled by saying they're brain dead, but so that they can have their organs harvested. That was referring to Ryan Hayes. Now, in this note, progress note, you'll see the decision of the conversation was had during the day shift. And here it says, patient is not brain dead. It's the second sentence in the middle there. Patient is not brain dead as he does breathe over the vent. Given the extent of his end of organ damage with severe derangements in his kidney and liver function, patient is not a candidate for DCD and is not a loop patient. Plans for palliative excavation this evening, once patient's son is available to get into town. He's driving here from North Carolina. He wasn't misled by Dr. Husel. The conversation was had by the day shift. It wasn't an emergency situation. They were waiting for the son. He wasn't brain dead. It's all over the records. You notice that they didn't ask a single nurse about any of these brain dead comments. Why is that? Why do you think they didn't ask a single nurse? Did you hear Dr. Husel tell Ryan Hayes that he's brain dead? Troy Allison that they're brain dead? Not a single one. I submit to you, ladies and gentlemen, the reason for that. They didn't like the answer they were going to get. It's okay to lie to you. It's okay to mislead you. As long as we win this case.
Objection, Your Honor.
Sustained. Let's rephrase.
It's okay to mislead you.
Objection, Your Honor.
Continue on with your comment.
You have a case of 14 patients, but each and every one of these are important, life-changing decisions. Now, why are you being asked, or why is a question being posed this way to this witness? Only to mislead you. Not to get any fact that will help you in your deliberations. Will asking that question help you in any way, shape, or form? No. It's because there's 14, you're not going to remember the specifics of each and every one. This whole thing mesh a little. It was an exhausting process to point this out to you folks. And one that we tried our best to do. Now, first off, it's interesting. During opening statements, I mentioned the pharmacy, and I told you about the reason how all this got started. Let me start there. And it's a fascinating thing here, because this case started a certain way, and it had absolutely nothing to do with the doses. And I'm going to show you where we kind of connected it a little bit for you. We tried our best. They started off with Talon Schroyer. Let me first show you all of the witnesses that testified in relation to the pharmacy. Now, I thought I might have mentioned where was the pharmacy of this, but I really don't recall. But I know this, I didn't make a theme, but we kept hearing, "Where's pharmacy? Where's pharmacy?" Well, ladies and gentlemen, the gentleman doesn't protest too much. And just like that overreaction, I will tell you where the pharmacy was, because in fact, it's still a mystery where the pharmacy was. This gentleman was the director of the pharmacy, and he talked about how they lost their funding. Well, they were placed in immediate jeopardy for their funding, and he expressed the importance of controlling controlled substances. This was the manager of the ICU, Mr. Randy Miles, who basically talked about what happened once the voice report was entered into. Gregory Dresbach was, I guess, a mentor to Talon Schroyer. They're kind of like partners. They worked together at night, and you heard them both testify, and they were pretty much on the same page. But the issue that we have here is there are far more pharmacists in this case than just this man and this man. And you heard, even up till today, the prosecution tell you that the pharmacy is unaware of these high doses. Remember that? Unaware. Well, that's not true. Look at this. Joanne Balasari, the nurse, and the nurse is Trisha Sauer, the pharmacist, Nathan Cockeyser. Where's pharmacy? Well, where's Mr. Cockeyser? He's not only the pharmacist for one patient, but he's also the patient. He was also for one of Ryan Hayes' doses. Where's Mr. Cockeyser?
Your Honor, I would object. It's inappropriate under the rules of evidence to comment on people on witnesses list that did not testify.
Sustained, let's rephrase.
Sure. You also have other pharmacists that were there that are parts of these doses, folks. Multiple patients. These are multiple counts. But you know what it is? It's about throwing it all against the wall and seeing what sticks. Because all it takes is one. All it takes is one murder case, and that's it. But Mr. Schroyer was aware of these dose amounts, because if you see, Mr. Schroyer approved Bonnie Austin and also Brandy Mcdonald previously. Brandy Mcdonald and then Bonnie Austin. What is he talking about? That's not true. And the same with Mr. Dresbach. Dresbach was involved with Ryan Hayes. Now, you also have in evidence, ladies and gentlemen, and I don't understand why you're being told this information. State's Exhibit 20D is an email dated on Thursday, June 14, 2018, 6 months before any of this happens. 4 months before any of this happens. Talking about, remember, the ICU, some of the high doses of ketamine and fentanyl from different providers at the ICU. And you heard every single nurse tell you, everybody knew about these doses, including the pharmacy. And that many times they would call the pharmacy, and that's not reflected on the records. Many times the pharmacy would talk to them. That's not in the records. Just briefly on the records, these are only worth so much. Because we heard of back charting, we heard of how busy things are, and we also heard they weren't trained in charting, and some are better note takers than others. There's a whole slew of things, especially when it comes to the times, when they're going back later and putting in times as to when something was administered or when something was done and so on and so forth. So you only have so much there. But think about this for a second. Where's pharmacy? I submit to you, they did not meet their burden at all. Only hearing from these two guys who had previously told you something? Folks, and then let's talk about how it got started, which was with Mr. Timmons. Now you may recall, and this is probably hard to do because we heard from a pharmacist early, and then much later on we heard from the nurses. But Talon Schroyer talked about how he got a call from one of the nurses, and that's what sparked all this. Now, by the way, you'll notice some of these don't have pharmacists, and that's what I mentioned to you in opening about this glitch when they do a scan to order, where sometimes it doesn't go to the pharmacy. Now that's only just a couple of these cases. The one that brought it to their attention was when Jacob Deemer called and talked to Mr. Schroyer about Mr. Timmons. And I want to tell you, I'm going to show you a couple of clips, but I want you to know one thing. The official record is done by the court reporter and your memory. You are to rely on your memory and your memory alone. And this is just a demonstrative aid for you to help maybe remind you of some of the testimony that came out. Okay? So I show you this short clip based on that. Please keep that in mind.
Do you recall the medication and the amount that he gave a verbal order for?
The second time?
Yes.
It was 10 milligrams of Dilaudid and 10 milligrams of Versed. Once again, I didn't pull those medications. Earl came back with a lot of medications. He had those medications, but he also had Ativan as well. I don't know where that came in. I don't know. He must have talked with the doctor. While this was happening, and I can't remember if it was right before dose number 2 or right after dose number 2, I can't say. But I called the pharmacy, called and spoke to pharmacist Talon Schroyer, and I told Talon Schroyer, we are doing a palliative extubation on a patient that has a really big opioid tolerance. He said, wait. He pulled up the MAR on his end. I pulled it up on my end. We could see every medication that was out of the Pyxis. And I said, this is what we're doing, this is what we're giving, but I also have this Ativan, an additional Versed, that I don't think I need because the doctor said give him what he needs, but not too much. So I was calling to say, hey, this is what we're doing, these are the meds that I'm giving. But then also, I was also calling him to say, hey, I also don't want to be responsible for these other medications that the patient doesn't need, and the physician said he didn't need them. I don't want to be, they were handed to me, I don't want these I don't want to be responsible for these, what do I do about that? And like I said, I couldn't remember if that was before or after dose number 2, but I ended up giving the 10 milligrams of Dilaudid and 10 milligrams of Versed. I later then returned the medications that we didn't use.
Give him what he needs, but not too much. There's some evidence. There's some evidence of that. But that's not the testimony you got from Mr. Schroyer. Mr. Schroyer said he was shocked with these wildly excessive amounts, notwithstanding that he had previously approved 2 prior doses.
Same with Mr. Dresbach. That's a severe conflict of the evidence, and that's how this case got started. The concern about things being bypassed to the pharmacy, nurses taking out meds without the pharmacy being aware, that caused a concern. The potential for diversion, all of that was an issue. That's how all of this got started. Not because he was shocked by the doses. I mean, look, he's giving prior approvals. He knows. And they want to say, oh, he called, is that an extra zero? Oh, it's for a procedure? No, it's in the records. It's for a palliative extubation. Even in this situation, Mr. Deaver's telling him, we're doing a palliative extubation with a guy with a lot of tolerance. Here's the scenario. It doesn't get any clearer than that. But he is shocked. Shocked. Reminds me of one of my favorite movies, in Casablanca, where Captain Renault is shocked that there's gambling going on in Rick's Cafe.
Everybody is to leave here immediately. This cafe is closed until further notice. Room at once. Gambling is going on in here. Your willing, sir. Thank you very much. Everybody out of one.
Shocked that these doses are here. Come on. Really? Nothing could be more untrue. This was a power struggle between the pharmacy and the nurses, and it got mixed, and it got sent up the chain, and one thing happened after another. They all knew this was, every single nurse came up here and told you, everyone here knows, even nurses who have been there 20, 30 years. Everyone, including the pharmacy all knew, but none of these pharmacists came and testified. None of these pharmacists for all of these individual counts, because it only takes one. And now we have this theory of attempted murder. That's a new one. So, I guess that's a conceding on that causation didn't happen, and you're going to assume that he intended on murder, but it didn't actually happen. I really am still struggling with that one, so I'll save those arguments for later. But
I would object to his characterization of the instructional laws given to you.
Yeah. It was ruled on accordingly, so let's bring our comments proper.
there's no evidence to support any type of attempted murder. That's not the case that was presented to you in any way, shape, or form. And you are the ultimate deciders of that fact. So, we have this Ware's Pharmacy, where there's emails, prior records, prior patients, all of this going on. And then this man steps into the picture. Now, what was really difficult in seeing this investigation, for lack of a better word, is that it was pathetic at best. Absolutely pathetic at best. You sat through this trial and now know more about palliative excavations than you ever want to know. But I assure you, you know 10 times more, and you know 10 times more than Detective Gillette does after investigating this case. How? How does this happen? And I bring this up for this fact. Let's start with how it all started. Mount Carmel went to the state attorney's office, but it was Mount Carmel who talked to the hospital witnesses first. The critical witnesses who were actually at the bedside were spoken to first by Mount Carmel. Not once, but twice. You'll never see that. The very first people that talk to critical witnesses in a homicide or attempted murder case are always going to be the police. Because it doesn't allow them time to get their story straight. It doesn't allow other people to influence what they're going to say. It's critical. Then, the police talk to them. With no medical records. Can you think of anything more absurd than the fact that they never spoke to a single witness with medical records? That's unacceptable. And I'm going to tell you why. Aside from investigating crimes to find if there's a bad guy, their job is to follow the evidence. By his own words, you agree with him. You follow the evidence. And that includes evidence of innocence. Evidence that's forever lost. Forever lost. Because this man did not do his job properly. And his team, the cold case squad. Then, Mount Carmel talks to the families. You heard a wide range of testimony as it related to these family members. But the very first people to talk to him was Mount Carmel. How is that possible? They were, the people who were there, how is that possible that they speak to them second? No, third, because upon actually speaking to them, a majority of them got lawyers and filed lawsuits. Well, everyone in this case filed lawsuits. And then, after that, after two different people had spoken to them first, then the police speak to them. Some of them at their lawyer's office, who now has an interest in the case. These personal injury lawyers aren't doing this for free. And these cases are still pending. And common sense tells you a conviction in this case goes a long way to ultimately settling a case, a civil case, a wrongful death case. And I submit to you that really that's where this case belongs. Because you don't have any evidence of intent to kill in either a murder or an attempted murder case. Zero in here. Zero witnesses got up on that stand and told you, Dr. Husel told me A, B, C, and D. None of that happened. And that's what I was telling you at the very beginning, folks. That's where these principles come from, beyond a reasonable doubt. That's why you have to hold on to them. They're ever so precious. You would think, this is impossible. He's here, he has to have done something, okay. No. Once you see all of the evidence unfold, you'll see that every day, across our system of justice, for one reason or another, we sometimes get it wrong. And it's a hard thing to admit you're wrong. And you have to fight it all the way to the very end. So, what are some of the pieces of evidence that this gentleman missed? Well, he doesn't even know what vasopressors are. Okay? The nurses told him the vasopressors could have potentially killed him. Well, okay, I asked him, did you research it? No. Do you know what it is? No. Did you tell anyone what it is? No. Did you follow up with anyone about what it is? No. What did he do with it? Well, I wrote it in this sheet of paper here. I don't know. I mean, what's the point of you being there if you're not going to do anything? You're a detective. Do some detecting. And he didn't do anything. Doesn't know what the doctrine of double effect is. He was told by the pharmacist, we consider the doctrine of double effect. Oh, really? Did you do anything with that information? No. Did you research it? No. Has no clue what it is. Didn't do anything with it. This man could have been protected. Their job is to protect and to serve. That includes William Husel. That's any citizen accused. You have the right to have a police do an open, fair, objective investigation, professional police work. That's not what this man did. Far from it. He had a whole team with him, and none of them did anything. It could be an avoidance. He wouldn't be sitting here if they had done their job right. Let me show you another example of what he could have done.
In that class, you were taught that, and I want to make sure I get this right, every patient is different. Don't be afraid to give larger doses of medication. I know it seems uncomfortable at times. Correct? You were trained in that by Mount Carmel? That sounds correct. And that training was conducted by someone from the day shift, correct?
I believe it was a nurse practitioner on the palliative care team on the day shift. That's correct.
Okay. And she, in fact, told you that I've given enough to put down an elephant. Do you recall that?
Object. Hearsay.
It's not being offered for the truth of the matter asserted, Judge.
What's the fact?
Effect on the listener. It was his training. You can answer.
My memory's a little bit fuzzy. That's certainly in previous records that I've stated that.
Okay. So you recall telling the police that that's how you were trained, correct?
I believe that's what it said in the. I believe that's what I said in the interview. That's correct.
So here you go. You have a critical witness to a potential homicide telling you, we were trained to do things this way, to give high doses. We were trained that by the day shift, that we've given enough to put down an elephant. Now, what could this detective have done? He could have gone and spoken to someone in the palliative care who actually did that training. Could have gotten a PowerPoint. You would have been able to see exactly what was spoken about, what was trained. You would have been able to see what kind of other evidence is there. That witness could have gotten up here and taken a stand and said, you know what, yes, I have given enough to put down an elephant, because when you're doing a terminal excavation, the primary concern is the patient's care. It's individualized. It's based on the patient. For someone who's opioid naive, maybe, yeah, it might harm them. But in this situation, this is exactly what we train our nurses and our doctors to do. Wow. Wouldn't that have been good evidence to have? They could have protected William in that way. But because of his either direct incompetence or his direct ignoring of it, he chose not to address it. He was also told this.
Correct. And you, in fact, brought to law enforcement's attention that you have seen studies that actually high doses of fentanyl control long life, correct? Yes, correct. And this is a study that you actually saw that was I guess, a medical journal? I believe so, correct.
What could he have done with that information? He could have brought it to someone's attention. They could have researched that. They could have pulled that article. They could have made the determination not to prosecute this case. If, in fact, giving higher opioids does reduce the agonal breathing, so therefore they don't tire out, and they actually live longer, that's a fact. You're not hastening anybody's death that way. You're prolonging it. That didn't matter to him. Then he was asked about potential side effects. He was told by certain people of the potential side effects. That Dr. Husel advised the families of these side effects. And his answer was, he didn't find it important. When you're giving families all of the information, and the ability to give an informed consent, to understand what kind of care your loved one is going to have, the most critical piece of information is, as everyone testified, how meticulous he was, including Wes Black actually said he was the type of doctor who waited till the very end, until there was no hope left, before he actually had to talk with the families. Whereas other doctors did it much sooner. This is stuff they could have used. This is information that if it was done correctly, we not only have more information, but we might not even be here. But that is all lost forever. Now, remember when I told you there was points that I don't think came out very well, and you might not have understood why we were doing what we were doing. This one has to do with the nursing stations and the computers attached to the nursing stations.
Mr. Schultz, the patient's chest when it comes to and they're unable to breathe, basically. Would an alarm go off on the ventilator?
Yes.
Okay. And that's also something the nurse looks for, correct?
Correct.
Okay. And so when a patient's on the ventilator, the nurse doesn't, you don't just let them be, you actually monitor what's going on, correct?
You have to assess the situation and inform the doctor and get treatment for it, yeah.
Okay. And in addition to that, during a terminal extubation, after a patient gets medication, they're still monitored, right?
Correct. We leave them on the monitor even during the withdrawal.
So you just turn off the audio alarms inside the room, correct?
Correct. There's a monitor in the room and outside the room in the nursing station, and we just basically shut off all the alarms so the family member is not aware of what's going on with the patient, and it's just a blank screen.
Okay. And you took me to my next question. And basically, what a nurse does afterwards is they give the family privacy with their loved one, and they go to the nurse's station where they can monitor the patient's vital signs there, correct?
Correct.
And that's attached to a computer, you see it on the screen.
Correct.
And after you said you left the room after you administered the medication, how did you come to learn of Miss McDonald's death?
So we have monitors, like the monitors in the room, you can turn to a certain setting so the family doesn't see or hear all of the beeping, but we can still see it at the nurse's station. So I could watch the monitor at the nurse's station.
And what would you see on the monitor then?
You could see her respiratory rate, you could see her heart rhythm. She had an arterial line in, so you could see what her blood pressure is continuously. You could see what her saturations were for her oxygen saturations. And did I already say heart rhythm? I think so. Anyways, heart rhythm, that too.
Nursing station, as you recall, there was more than one on the ICU floor?
Yes, ma'am.
And during a palliative excavation and the excavations that you participated in, were there times when you would leave the room to allow the family to have time with their loved one?
Yes.
And when you did that, where generally, in your experience, would you go?
We would go to either the nursing station, or we would go, if we had to go look at our other patients, we would go and proceed for assessing our other patient.
And fair to say, if you're at the nursing station, there are monitors there which allow you to continue to see what's going on in the room.
Yes, ma'am.
And while the machines visually and auditorily are shut off in the room, the patient is still being monitored even after you're excavated, right?
Yes, ma'am.
And that's when you went over to the monitoring station and you were able to observe for vital signs on the nurse's monitors, correct?
Correct.
And that's attached to a computer, and all of that is working at the same time that the family is spending their last moments with this test.
Correct.
And then after that, when you recognize that perhaps Ms. Castle had passed away, Ray, you went and got Dr. Husel.
Correct.
And when Dr. Husel came in the room, tell the ladies and gentlemen of the jury what his demeanor was like when he came back in the room to declare her.
The same, like calm, kind, caring.
Calm, kind, and caring. That's how this nurse, who barely knew him, described him. Calm, kind, and caring. Now, why were we asking about these computers? Because they're computers. And just like every other piece of forensic evidence, we would be able to know much more specifics. When did they stop breathing? Did they have respiratory depression? When did their heart stop? They didn't confiscate these computers. They didn't do any research on that. They didn't go in and remember when I asked the detective, hey, did you go to the ICU and ask them, walk me through a terminal extubation. What happens first? And where do you go then? And what do you do next? You would think that that's what they would ask to not only understand it better, but to see what potential evidence is there. What potential evidence could be used? William Husel sits here now because they didn't do that. Evidence that's lost forever. Evidence that really doesn't take a rocket scientist to be able to make that determination, especially for police who constantly, we live in a digital age, folks, you all know that. Everything electronic is there for us. How much better would that evidence have been rather than some backtracking? How much stronger would that have weighed when you make this decision of how important it is before looking at someone's notes? It would have been there for you in black and white. And I'll tell you this, they have that burden. It was their responsibility, and they did not deliver that to you. Not every citizen accused has the opportunity. In fact, no citizen accused has the opportunity to dictate that investigation, to guide the police to their innocence. You expect, hope, and pray that they're going to do a competent job. But this was far from it. Far from it. This is not something you would expect or want for your neighbor, your loved one, for someone who stands accused, for someone who saved lives for a living, who did so much for this community. Then we have some of the doctors. And people who testified for Mount Carmel. Put all these up at some point. But I want to focus in on those that work at Mount Carmel first. Let's start with these two gentlemen. Dr. Swanner and Dr. Olson. What have you heard from Dr. Swanner? Not a single person in 5 years ever complained about Dr. Husel. Physician of the Year, 2014. Was nominated several other times. In addition to that, you have Dr. Olson. Now, you may remember. You remember when the judge instructed you about admissions by party opponent. And he explained to you how, under the rules of evidence, the state can bring out things that Dr. Husel said. Not the defense. So, you heard not a single one, with the exception of one nurse, them ask any of these nurses about what Dr. William Husel said to any patient. You didn't hear it. I would object.
Ladies and gentlemen, you are the determinations of what the evidence is in this case. This is argument. It's to aid and assist you, but you can give it whatever value you deem appropriate. You are the true finders of fact. Let's move on.
In addition to that, this is the first case you're ever going to hear of. You know he was confronted but you didn't hear a word about what he said.
Okay.
That's what's.
Bring it back.
Right. Sure. That's a decision that they made.
Your Honor.
Okay. Probably a good time for a break. It's getting up to be an hour and a half. You guys need a break? Yeah, I see some head shaking. All right. Remember the admonitions? 10 minutes enough? 15? 15 it is. 15 minutes. We'll get started back at 25 till. You may be seated. Mr. Zion, objection?
Judge, it is bananas that he's up there arguing that somehow the state of Ohio and the police can keep a defendant from either making a statement to the police if they choose, and or, more particularly in this courtroom, keeping them from testifying if they want. Whether the defendant testifies or not is entirely within the defendant's rights and the defendant's decision. I, of course, cannot comment on that, as it would infringe upon his right not to testify. But then to argue that somehow he doesn't have that right, Your Honor, is completely inappropriate. Completely inappropriate. It's the first case I've ever heard a defense attorney argue that, to be sure. Thank you.
Counsel's comparing bananas to apples here. I'm specifically addressing that they have selectively chosen, and this has nothing to do with the police. He was spoken to by these two gentlemen who are not police officers. He didn't have a Fifth Amendment right at that moment in time. He could have said nothing, but they have intentionally solicited admissions on some witnesses versus others they didn't. Now, I can't say what he would have said had they done that, and I can't comment on what he said, but I can certainly comment on their tactical decision to show this jury certain statements he made and withhold from them others. And that I can say that has nothing to do with the Fifth Amendment.
Were any of the documents given to you in discovery as to what was said by Dr. Husel in the interview? Does anything like that exist?
Yes. The note to chart when he was spoken to by Dr. Swanner and Dr. Ralston.
Okay. They let you know what they were.
Correct, and I'm not going to say what they are, but I do have the right to point out that they did not admit that evidence, but chose to select other statements.
But they gave you the evidence of what was said.
Correct.
Was it relevant to this?
Oh yeah, I mean, of course. He talked about his intent. He talked about his dosing habits and so on and so forth, but I can't get into that, and I have no intention of doing that. But there was also a mischaracterization brought out during direct examination that he was polite and cordial, and we, of course, corrected that during cross-examination as well. But I think there's a distinct difference between what they selectively choose to elicit from witnesses who are non-law enforcement in a non-custodial situation, but choose to withhold in others. And that's all I'm doing. I'm not going any further than that.
Your Honor, he's suggesting that somehow we've broken the law to the jury. He's selecting that somehow we've done something inappropriate. We have not put on the defendant's self-serving statements, which we don't often do in cases. And, there's one very simple way to get in whatever self-serving statements he wants to get on, and that's to get up there on the stand and make those statements. And so
Okay, hold on. No. He has the right not to take the stand.
Exactly, and that's why this argument is inappropriate. He has a right to testify and not to testify, and to somehow say the state kept out what he really wanted to say to you folks. They made this tactical decision. No, they made the tactical decision. We just followed the rules of evidence. That's what we did. To say that somehow, the state of Ohio hid this from you. He really wanted to tell you this, but no, they made their evil little nefarious decision. It's completely crazy that he's allowed to make that argument. He can do it or he can't, but that's their decision, not ours. He wants to say what he said to Dr. Ralston and Dr. Swanner, get on up there and take the oath. He chose not to, which is his right, which I cannot comment on, which I will not argue about, but for him to be able to say that somehow this doctor really wanted to tell you what was going on here, but they chose not to. Well, you know, what can you do? The state of Ohio, as he's been saying all along, they're just selectively telling you things here, folks. Well, that is a completely inappropriate argument. Completely.
Anything else?
Yes, it's not. I'm not getting into the comments at all, and it is absurd that they would selectively decide what they want to ask for a part of your opponent admissions. But that's their choice. That's their tactical choice. So it has nothing to do with the tactical choice of the Fifth Amendment. It has the tactical choice to do with their burden of proof, which I'm free to argue, and what they did and did not admit into evidence. And clearly, there's numerous decisions where they chose not to ask certain witnesses certain things, but ask other witnesses other things.
Are you done with the comments on it?
Yes, that's pretty much it.
Okay. I don't think they're wrong for objecting here. I think you went over the line. But, you know, it's already out to the jury. I can give them the instructions that they determine what the facts are, and that's it.
Okay.
If you move on, fine. If you insist on there, I will be forced to cut you off.
Understood.
Okay?
Understood.
That's the only curative thing I can do, Mr. Zion. You give me the look.
Sit here.
Anything else for the record?
Nothing from us.
Thanks. Yes, ma'am. In a minute. Any objection to, instead of her typing what was on the thing because the volume was so bad, just to submit the...
Absolutely. More than happy.
We can make it as a court's exhibit. Because, I mean, it was a little rough. You were in constant...
Yeah, I was struggling through it myself.
Okay. When you're ready, Sam. I have to go on here real quick. Yeah, hold on. Just give me a minute. Well, you can go ahead and line them up. This won't take long. Okay, let's go on the record. During the break, I was approached by the court reporter. Can I have quiet, please? I was approached by the court reporter. She requested that the blurbs that were being shown on because of the volume and stuff be admitted as a court exhibit separate for the benefit, so because she was having problems getting it all. I talked to both sides. There was no objection to that, so they'll be identified. I think it's 18, I think is where we're at. Yeah. Can we include them all in one, or do you guys want each one specified?
Just put it on a thumb drive or something, I guess. I don't know.
This is 18?
Yeah, the whole thing needs to be made part of the record. Every slide, everything. If they can't print it out, just the whole thing needs to be on some sort of format that can be played with.
Well, they're going to ask for yours to be put on the record too. Since
I've already given that to you, Judge. I gave it to you this morning and asked that it be made part of it.
Okay. Any objection?
None.
Okay. Second issue, timing-wise. Okay. I figure you're halfway through your thing, Mr. Baez. I figure you're going to be a while. I don't want to be up trying to give a charge at 6 o'clock. So we're going to have to figure it out. I think if we go till 5, no matter who's up, I'm not trying to create a filibuster or anything, but, you know, I'm just trying to logistically do this for the sake of the jury. This is a long, complicated argument on both sides. So let's keep that in mind as we go. I figure you're about halfway.
Pretty much.
So, you know, I'm guessing you got at least another hour and a half, if not 2.
Hopefully just an hour, hour and a half.
Well, it's the old trial judge thing. We multiply the number by 2 that a trial lawyer gives us. So
Understood.
we will make the salary, but I just want everybody to perceive it. I don't want an advantage of Mr. Zion coming back tomorrow morning either. So we'll just have to adjust. I do the charge tomorrow morning. I don't think that causes any problems. It gives the jury a fresh start because the law is important. Not that you guys' arguments aren't, but it's something separate that they can read along with me, and I figure if we have to, we can go tomorrow morning with it. Okay, if there's no objections, let's bring them in.
All rise.
Thank you. Please be seated.
I hope you had a wonderful break, ladies and gentlemen. Remember, this is just the arguments of counsel, okay? You guys determine what the facts are after you get the law. So with that, Mr. Baez.
Thank you, Judge. Remember what I told you? I'm afraid I'm going to forget something. I did. Tracy.
Objection, Your Honor.
Let's see where he goes with it.
Now, you heard from Detective Gillette that he became aware of Tracy Young about 4 months into the investigation. I also asked him, did you go back and talk to anyone about Tracy Young?
and after getting her records. And he said, no. This is another instance where someone's experience is critical to the investigation. And the fact that she received more fentanyl than anyone in this case.
Sustained.
Now,
Ladies and gentlemen, your disregard the last comment.
he told you that he became aware that she got more fentanyl than anyone in this case.
I'll permit that. Let's.
So, in light of that, a person's experience, and we learn throughout this case, that's how doctors learn, through their experience, through their education, through journals, and different things like that. To have all of that before you would have been critical. We may not even be here in that scenario. They want to argue certain doses or lethal doses. I submit to you, without giving you everything, the complete picture falls far from short of reaching their burden. Now, we heard from, of course, Dr. Ralston, who is an internist, as well as Dr. Hagris, who's an internist, Gina Moody, who does pulmonary and critical care, and of course, Tom Brady. We also heard from the Patient Safety Risk Officer, Katie Barton, about the hospital's investigation and how they struggled to find the root cause. In fact, they kept it at a level 4. You remember there was a level 0 through 9. 9 being causing the death of a patient, and they had it at 4. And specifically, she was asked by the prosecutor, I want to make sure I get this right. I apologize. I had it here just a minute ago. There we go. You recall that it could change at any time. They could go back and change that number at any time for these patients, but they did not. And that they knew the medication reached the patient, but did not and could not determine the patient harm at that time. And then at the very conclusion of her testimony, when asked by the prosecutor, why does it stay at a 4? She responded, even after the root cause analysis, we were still struggling with the cause and effect. Now, at one point, during some of the questioning of other doctors, it was trying to allege that she's not a doctor. But you heard through her testimony that it was they had experts that dealt with the specialization that she questioned, and that she completed a complete investigation. There were multiple people on the team, including Dr. Roth. The hospital themselves are telling you that they are struggling with the cause and effect. But you have the prosecution telling you something else. You have the entire medical industry telling you there's no maximum dose, but you have the prosecution telling you something else. You know there's no policy at Mount Carmel, but you have the prosecution kind of looking the other way of that. And you saw how basically they changed their position over time. Now, they questioned you about other doctors and what they did. The judge will tell you, and you should know, these are not expert witnesses. What one doctor does has nothing to do with another doctor because each patient is different, every scenario is different. All of those things come into play. And internal medicine doctors are different than anesthesiologists. The one fact that you should remember is, despite the fact that they talked about how he was the only doctor doing these things, which is still questionable, because I'm going to go into a little bit of that in a bit, that he was the only doctor doing this thing, but he's the only doctor in the ICU trained in both anesthesiology and critical care, which means he's different. His training is different. And we brought you somebody that trained the way he did. You know what they didn't ask that doctor? Dr. Zimmer? The $1 million question. How many patients have you given 2,000 micrograms of fentanyl during a palliative excavation? They didn't ask him that question. They asked him questions about giving doses to death penalty patients that are healthy and have nothing to do with a palliative excavation. But they didn't ask him the $1 million question, folks. What are your dosing habits? How do you make the determination? They didn't like the answer they were going to get. That's probably why they didn't ask. Because maybe you don't need that information. Maybe you don't need it. Now, we also heard from a slew of other doctors. Now, you may be wondering at some times, why were these doctors called? Because they don't remember anything. They said they didn't review the MARs. Well, number one, none of them had any independent recollection of any of these patients, so it's hard for them. I question whether they in fact would even remember that. Okay, it's not the cause. They know there's lawsuits going on in this case. None of these doctors are going to sign on for that. The easiest thing for them to do is say, I don't remember, and that's not usually what I do. Keep me away from this. That's the easiest thing for them to do. But I'll tell you this, you heard Dr. Haggers tell you, he relies specifically on on the discharge summaries and that they review the medications. You also heard Dr. Roth mention it. And you even heard the nurse Derek Dreyer when he was asked about it during his HR interview. Where are the attendings, the discharge summaries? Clearly, these doctors would have raised an issue if there was an issue. If you can assume that they relied on it, why can't he rely on it? Why can't he rely that they're going to do their job? You know he didn't do anything to hide these dose amounts. Not from the nurses, not from the pharmacists, not from anybody else that would have access to these records, which are, I presume, hundreds of doctors, including the patient safety officer. There's nothing cloak and dagger in the middle of the night at the ICU. Why is that? That's a constant theme, the cloak under the nighttime ICU. But the reality is there's systems in place. And Dr. Husel's intent can clearly be understood that he did nothing to hide these dose amounts. Nothing. And to allege otherwise is simply not true. It's all here. When you do something wrong, we remember, when we do something wrong, the first thing we try to do is hide it. When we do something just not right, we try to hide it. That tells you his intent right off the bat. He didn't make any money if these people died. He didn't have anything against Sandra Castle, Mr. Timmons, any of these patients. There's no evidence that they got into arguments. There's no evidence of any of this. They're asking you to take a huge leap of faith to turn this case into a criminal case. The dose amounts and the wrongful deaths, that will all be decided in another courtroom, in front of another jury.
Sustained. Ladies and gentlemen, the civil case has nothing to do with this. This is the evidence in this case, and you are to interpret it.
So you have all of these individuals everyone knowing what's going on. And then we get to the experts. These are all of the experts that testified in this case. And the first distinction I'd like to make is the toxicologist, who basically only testified about the drugs contained in both of the overdose patients. Something that the state's experts chose not to look at. Weren't provided with the autopsy reports. Which doesn't make any sense at all, given that a forensic pathologist is the doctor who investigates causes of deaths. It's their job. It's how they're specifically trained. They get all of the information together, and they make the final call. I'm saying neither one of them were declared as a homicide. In fact, you have all of these other doctors show you the comorbidities of what actually killed these patients. What it was how they were sick, basically. And if you believe this guy, Mr. Schweiger, they all could have gotten up and walked out. Forget that you died 5 times in the hospital. It doesn't matter. Forget that you're reliant on vasopressors to survive, or your heart to keep beating. That doesn't matter. They could have all walked out here. It's absurd. It's absurd. And to classify them as random doctors from Tennessee and Tampa is a little inaccurate. They were hand-picked. Hand-picked, hired guns who came in here and testified as to what they thought. And they didn't even agree. And again, Dr. Ely is not even an anesthesiologist. Not trained the same way. Different training. Qualified, good Catholic. They're both good Catholics. But what does that have to do with this case? Nothing. Nothing. Yes, they understand the privilege of suffering. Well, not everybody subscribes to that. Not everybody thinks it's a privilege to suffer. And if that's the doctor you want to go to, you have every right to go to that doctor. There's nothing against the law for that. But you also have the right for a doctor to keep you in comfort in your final moments. So, really, the ones that are trained in the same area and expertise are these 2 doctors. All he did was cut and paste a good chunk of what his opinions were, ignoring every other doctor at the hospital who said these patients were terminal. You remember Ms. Menashe going through those cross-examinations and pointing out, what about what this doctor said? This person is terminal. I'm afraid they won't survive. What about this patient? Without this life support, they will die. All of these other doctors are in cahoots. They must be enthralled with William Husel. They don't work with him. They don't know him. Well, maybe they know him. But how did they get enthralled too? All of these issues are constant within this case. James Allen had respiratory failure, had cardiac arrest, his heart stopped. He was on 2 vasopressors. His blood pressure was sinking. He was in the ICU, left the ICU. This is something interesting. You heard a lot of testimony from the nurses talking about how William Husel was always available. Remember that. Well, there's an importance to that. It's not just, hey, you know, he likes hanging out in the ICU, okay, it's all fun today. No, it's being there for your patients. You may recall during the cross-examination of one of the nurses pointing out, Mr. Allen, we pointed out that when he left the ICU, his blood pressure started to go down. He started to crash. And he wasn't provided the proper care by Dr. Manjan until he arrested him. The nurse paged him 10 times. Remember something about that, about being paged 10 times, and then the doctor finally called back, and then he hung up on her? That's not being available. But yet, he sits here. Beverly Scherzinger, she's the one that had a liver biopsy. Normal liver biopsy, but she bled out. What did Dr. Manjan do? Mr. Not available? When they finally got him, he gave her salt water. And said, oh, it's probably from the pharmacology. You saw that in some of the records. She crashed. Who was there to save her life? He saved her life. Tried to leave to kill her later. 14 life-saving measures William Husel utilized to try and save Beverly Scherzinger's life. CPR, he intubated her, gave her a central line, an arterial line, maxed her out on three vasopressors. Even Dr. Schweiger will tell you, every single witness who took the stand told you how fast the vasopressors end. 30 seconds to a minute and a half. He took it a step further, and he talked about if you're dependent on the ventilator, you're going to die in 4 minutes. Each and every one of these patients were dependent on the ventilator. Michael Phelps, last time I checked, is not amongst them, who could survive holding their breath for over 4 minutes. They couldn't breathe. They needed machines to keep them alive. Their heart wouldn't beat, so they relied on these vasopressors to keep them alive. And the second those things are turned off, that's your cause of death. And he sits here, charged with murder and attempted murder, after saving Beverly Scherzinger's life and utilizing 14 different measures of trying to save her life. All of them done within an hour of extubating her. That's a fact. Those facts were never presented to you during the state's case in chief. All brought out during cross-examination. Every one of them. Rebecca Walls, she went in to get for the stent for her heart surgery, had to bleed. Again, you see the doctrine of double effect coming out multiple times in this case, and how it relates to certain patients. Miss Walls didn't want to bleed out and die, but she needed that surgery. There were risks. There are risks every time a doctor touches you. Lots of risks. They're not miracle workers. But after 14 different attempts to try and save Miss Scherzinger's life, William Husel could do no more. Bonnie Austin, getting CPR, punctured her ribs broken, punctured one of her lungs. That caused her to die. But she had 5 cardiac arrests. 5. 5 times she died at Mount Carmel. Dr. Schweiger says she could live. Walked out of there. Ryan Hayes. With carfentanil in his system, overdose. And it wasn't just carfentanil. It was carfentanil, morphine, fentanyl, alcohol. All of these things together. We don't know what's in these drugs that are taken in the streets. But an elephant tranquilizer is not a good thing. Another case, Dr. Ely didn't even know what carfentanil was, his first cross-examination. When he came back here, he looked it up. Said they were kissing cousins. Maybe in Tennessee they're kissing cousins, but here they have absolutely nothing to do with one another. It's 100 times more. In fact, you heard Dr. Zimmett tell you it's even used as a chemical weapon. That's how strong it is. But yet he stands here accused of his murder or attempted murder. Sandra Castle was having a bad death. Those order sets were doing no good for her, and she was suffering. She also had 6,000 micrograms of fentanyl in her hospital stay. Bonnie Austin was also on hydrocodone at home. Rebecca Wallace got 6,500 micrograms of fentanyl while in the hospital. It's like 1,000 micrograms a day. She had a tolerance. You did not get a proper presentation of evidence on their tolerance. You're going to have to weed through this to go through a lot of it. We brought some out during cross-examination, but the reality is these patients had some factor or another that contributed to their dose amounts. That's why they're different doses. That's why you heard one of the nurses talk about a terminal extubation where the patient didn't get any fentanyl. That was Jordan Blair. Troy Allison had 4 heart attacks. I still can't understand how they're saying he would have walked out of that hospital. He could barely make it to the ICU. His heart kept stopping. The doctor in the note says, I walked away for just a minute and he arrested again. This was a very sick man who was on lots of pain meds, the equivalent of 750 micrograms a day. Now again, the comparison between the opioids and fentanyl are for tolerance levels. 750 a day he was getting. He was non-compliant with the pain from his leg. He had a car accident. He had all these problems. His glucose, his pH level was at 6.53. He's a walking miracle. Well, he wasn't walking, but he was being kept alive by machines. His glucose is at 899 when 100 is normal. His lactate was at 16 when it should be 1. All of these things, kidney failure, cardiovascular failure. Danny Millette, also on hydrocodone, got 2,000 micrograms of fentanyl, had multiple hospital stays, built up a tolerance, as well as 6 cardiac arrests. 3 maxed out vasopressors. You can't live like this. You can't. And what's unique about this case that will trouble you forever is when you take someone off a bed, you're already hastening their death. When you turn off their vasopressors, you're hastening their death. They can't tell you how long. Beyond a reasonable doubt, they would have survived if they didn't get any fentanyl, but yet they want to tell you you're hastening their death. It flies in the face of reality. It's absurd. This whole case doesn't belong here. Joanne Belisari, her hospital stay, received 8,600 micrograms of fentanyl. She had kidney failure, respiratory failure, cardiac failure. She was in septic shock and had 2 vasopressors keeping her alive. James Timmons, 3 heart attacks. Cardiac arrests. 2 vasopressors keeping him alive. Multiple kidney failures. And I'm going to get into his tolerance in just a minute. Now I want to talk to you about probably the most critical witnesses in this case. I'm going to put the nurses. The nurses are by far the most important witnesses in this case, and they can hide from them all they want, and they could not ask or give you the complete picture. But the fact of the matter is they're the only witnesses in this case who are independent witnesses, who don't have a dog in this fight. They're the only witnesses that had the most contact with these patients. They're the only witnesses that know what he said and did, because they were there. And something happened during this case that was really impressive and shocking and quite unbelievable. And that is that a majority, you heard, a majority of them are some of them are no longer nurses. They all lost their jobs. Something happened to them. Some are still nurses, but a few of them are. You would think they would be really angry at William Husel. You would think they would come in here and bury him. I submit to you, ladies and gentlemen, that the reason they didn't do that is because they're honorable people. They got into medicine to help people. They were there. We were not. They were not. Neither were their experts. And all the experts ever did was rely on their notes. Some took better notes than others. But you would think about that. Think about what they went through and how upsetting that would be, and how life-changing that would be. Imagine having a career, the job of your dreams, and as Mr. Zion pointed out correctly, they wanted to work with the sickest of the sick. And all they had to say, they all told you how William Husel was accessible, a good doctor, constantly. I know Mr. Zion called him a terrible doctor or a bad doctor, but that's not what the evidence showed. The evidence showed that this was a caring man that took care of his patients, that trained the other nurses and other individuals that worked at the ICU to make it a better place, to help people even more so. And they had every reason to tell you otherwise. And they don't have a financial interest in this case. They don't benefit. And they're all varying degrees. There was one. And there was one nurse, Kathleen Mcdonald, who, when questioned by the police in a homicide investigation, lied. Straight up lied. Said, I've never given any fentanyl, or I don't recall giving any fentanyl. I used Dilaudid or something else. I have nothing to do with that. But immediately after that, they had to call her back. They called her back, and they questioned her again. And they, wait a minute, what about this patient? And that's when she knew she needed to report. You don't lie to the police in a homicide investigation and get away with it. 3-4 days later, she's sitting in the office in front of the state attorney. She's got all kinds of stories to tell. This bromance. Well, Jamie Burke was not part of any bromance. Neither was Stephanie Lachard, who barely knew Dr. Husel. They all have varying degrees. They all, after this happened, we started questioning them about bromances. Many were thrown off guard, didn't understand what they were being talked about. She also talked about odd numbers. He doesn't like odd numbers. But yet, the state, odd numbers are okay for the state when it's convenient for them, like 99.9% sure that their organ failure, he allegedly said, or 99.9%, you can't get any more odd than that number. Something about a microwave. He doesn't listen to pharmacists. That allegation, if it ever existed in any of these records, that Dr. Husel did whatever he wanted despite the pharmacy, would have been front and center in this case. You all know that. That would have been the first thing you would have heard about, is how he ignores the pharmacy. But that's not the case. That's not the case, and you all sat here this whole time and know that. And this thing about this talk, he's 24 for 24. Why would he need to change his talk if he's 24 for 24? It's only done. You heard that Dr. Hagris does 15 to 20 a year. That's probably more than what we've seen from Dr. Husel. But you also heard palliative excavations are rare. They don't happen a lot at all. I mean, they happen, of course, but it's not a common thing. So, all of this, and of course she decides to rat out all the nurses. The police are investigating, talking, and want to know, what did nurse so-and-so tell you? What did this nurse say to you? They sent you a text. All of these different things. And they didn't like the word cooperator. They sure wouldn't like the word snitch. They wouldn't like informant. I don't know what you call it. But giving information on your coworkers, private messages to you, to the police and the prosecutors, is what she did. And I submit to you to stay out of trouble. Knowing she needed to get a doctor and get a prior sit down for a proffer with the prosecutors. And she never actually sat in a talk with Dr. Husel. Zero experience in when he spoke to the family. She had no experience to speak of except for participation in another patient that's not involved in this case. That's it. That's their star witness. Even she testified about how good a doctor he was. Nobody here agreed with her. And she was the only witness that they asked her about in terms of what William was talking about at the ICU. In addition, none of these nurses ever said anything about brain death. Why not ask Jacob Diener, hey, did so-and-so mention, did Dr. Husel say that this patient was brain dead? No. And you heard from multiple witnesses, Dr. Zivit, who said, brain dead, you're dead. There's nothing to do. When a person's dead, they're dead. When the person is, there's two ways that you're declared dead. One, you're either brain dead, or two, your heart stops. Those are the two scenarios where you're dead. Any medical professional knows that. And that's why the absurdity between the cross-examination of Dr. Zivit came out, as well as Dr. Ralston also talked about being brain dead in Florida, in Ohio, as it relates to being the law. Now, what they did with the nurses was they literally turned them up against the family members. And they presented to you a conflict in the evidence. If you look at, can you get the family members? Actually, before I get into that, one of the important things, as I mentioned earlier, were the side effects. They were never asked if Dr. Husel, it came out through cross-examination in a very difficult way, but it came out that Dr. Husel actually advises the patients of potential side effects. Tell us about all the things that you discussed.
Yeah. So on top of the prognosis with him that we detailed earlier, we talked about how we're going to turn off the IV pumps which contain the vasopressors. We talked about how we were going to discontinue the ventilatory tube. We were going to take out the endotracheal tube, put a little bit of nasal cannula on him if he needed it. and we were going to give him pain medication, medication that would help him be comfortable and pass naturally as a result of his underlying illness.
Did you discuss with the family the potential side effects of the medication?
They were discussed.
Okay. And did you feel that the family, what was it? Did you feel that the family was well informed by both you and Dr. Husel?
Yes.
Okay. And that included being well informed of the potential side effects of fentanyl?
I think so, yes.
Did he leave the decision up to the family, or did he tell them what he was going to do?
He left the decision up to the family if they wanted the patient to get more pain medicine.
And I asked you about these vials. Did you think that he would, during the discussion with Dr. Husel and the family, did you, let me put it this way. If Dr. Husel had hidden important information about the side effects of the medicine, would you have spoken up and informed the family and given them more information?
Yes.
Okay. And did you have to do that?
No.
Why do I have to ask that? Why do I have to dance around that issue? And every one of these nurses told you that he was meticulous, thorough, and always gave the family the options. And if he had not or misled the family in any way, it was their duty to speak up. Not a single one told you otherwise. Not a single one. How are these facts being ignored? How do you not, it's like you don't need this information. It's critical. And again, we're talking about side effects, potential side effects. We're not talking about factual things. You heard Jordan Blair say, what are the side effects? Well, respiratory depression and constipation. You know, it's funny, you watch a commercial about a medication on TV, half the commercial is telling you how great it is, the other half is telling you about the potential side effects. That just makes you wonder why they're even selling it at all. The fact of the matter is that as it relates to fentanyl, it's like every other medication. There are potential side effects. It doesn't make it a fact in a murder case. In fact, it's not a fact in a murder case unless there's some note or some indication that it actually occurred. Search through here all you want. You won't see one single patient, one single note, one single fact in any way, shape, or form that says that any of these patients suffered from respiratory depression. Not a one. Or that there was some adverse effect of this medication given to the patients. Not a one. Folks, you're not just to assume things. You're not supposed to make that connection for them. Remember, it's beyond clear and convincing. It's beyond and to the exclusion of every reasonable doubt on everything. Everything. But there, 14 cases, let's throw it against the wall, see what sticks. Because all it takes is one. All it takes is one. And that's a critical fact that they conveniently left out for you. Now, they don't like that Mr. Timmons got 14. Well, actually, before, let me get into this beforehand. You heard a lot about paralytics. Well, I would submit to you, ladies and gentlemen, that paralytics only apply in one of these patients. That was Melissa Bennett. And she received the paralytics 48 minutes after getting the paralytic. Their own policy, the order sets that they rave about. The first thing it tells you is right up here. Discontinue paralytics 30 minutes prior to ventilator withdrawal. That is the Mount Carmel policy, and that medication was given in compliance with that policy. In addition to that, look at where it says communication, patient care. Withdraw ventilator support when level of comfort is within the desired limits. No grimacing, no agitation, comfortable respiratory rate. 30 breaths or less. What does that tell you? You also heard every one of these nurses tell you that they give the medications prior to taking the ventilator off. They want to make a distinction that these people were not on ventilators. They were on ventilators when they got the medication. They were monitored. The nurses monitored each one before taking the ventilator off. If there was an issue, an adverse effect, that's the first thing that they would have noted in the records. In addition to that, it's the medication is given on a ventilator. And until the pain is going away, no grimacing, no agitation, they're comfortable, that's when you take it off. And what does it say under medications? They start getting into medications. Well, as we know, it doesn't have fentanyl. But what does it say there? Note, principle of double effect. In a note with an asterisk. It's telling us, remember the principle of double effect when you give these medications. Again, it's true, it's not, Mr. Zion argued to you that it's not a law, it's a principle, it's this, it's that, whatever you want to call it. Here you have Mount Carmel telling you that as well. And then the other issue, remember there was this whole issue with the synergy, and synergistic effect. Well, I always catch myself, but Katie Barga, the patient safety officer, attached a journal to the root cause analysis. And I pointed it out to her during cross-examination, where it specifically states, without any ambiguity, that the combination of benzodiazepines and opioids do not hasten death. That's in their root cause analysis. That's one of the reasons they struggled to find the root cause. Then, in addition to that, Dr. Haggard says that he gives the combination of the two. Dr. Zimmet told you it's the gold standard. To come up with the synergistic effect, that's a prosecution theory. Because it's not subscribed to by Mount Carmel, and it's not subscribed to by other doctors. And we have to make the distinction between what the prosecution thinks versus what doctors think. And they're not doctors. So that takes us to Mr. Timmons and his 14,000. Here, the 14,000 micrograms is listed in 4 different places in the records. 4 different places. This is not, as Dr. Schreiber likes to think, a mistake. Numerous different places, including the actual anesthesia record, which shows the start time and everything thereafter. Now, what's interesting about Mr. Timmons' compartmental, here's another place in the records where it is, in the MAR. And here are the surgery records. This was a quick surgery. You see the start time was at 12:05, end time 12:34. 29 minutes. We heard from the nurses that the withdrawal takes anywhere from 15 to 20 minutes. So this is 9 minutes more than the average time of an excavation, and he's getting 14,000 micrograms. There's no distinction here. It's minimal at best. And it shows that apparently, based on his background, in the OR, they felt he needed 14,000. He got 1,000 from Dr. Husel. And he got the extras, and you heard Jake Beamer say, they were worried about him going through pain Give him what he needs and nothing more. Give him what he needs and nothing more. So, as I mentioned, here's where we're at. Mount Carmel comes to them with lethal doses. They do their investigation. Now it's potentially all the patients were terminal. That was clear. They never made any allegations that you heard in this case about any of these people not being terminal. And the families really decided to withdraw care. Who knows what happened in this phase? And now all of a sudden, you have all of these different theories. And theories they are, ladies and gentlemen. Theories they are. Patients were not terminal. They could have walked out. James Simmons could have gone to rehab. They could have lived. Now they're all fatal doses. They tricked the nurses into giving high doses. They were so enthralled, these folks. Enslaved by his charm. And then, wait, he's not a man of many words. So how's he charming them with not many words? Okay. Happened in the middle of the night. The synergistic effect. That's a prosecution theory. That's all new. Stiff chest syndrome. You heard from the nurses that we asked, the alarms go off if there's stiff chest syndrome. The nurses will know. You can observe stiff chest syndrome. There's nothing in here that a single patient went through stiff chest syndrome. There's just as much evidence in here that they died with stiff chest syndrome than they had leukemia. Just as much, which is to say none. Just as much that they died of COVID than they died of stiff chest syndrome, or that they had any, or even side effects. Not a single side effect is noted in here. At all. There's just as much that a side effect or an adverse effect occurred than there is that they had leukemia or even COVID, which wasn't even discovered yet. Brain dead. Folks, this is a new theory that is in none of the records at Mount Carmel. None of the witnesses from Mount Carmel testified to it. You only got to it through the family members who had lawyers that mentioned it in their lawsuits. So, forget the medical professionals who were there, who were independent, and believe, there was just a couple of them, and I'll go through that in just a moment, but let's bring that up. Before I discuss the families, I think everyone would agree we're incredibly sorry for their loss. They lost someone very close to them. There's no way there's no fact that would ever change that. Having said that, only just a few testified about this brain dead theory of the prosecution or the personal injury lawyers brought forward. And I'm going to get into those in a moment, but I think when you have a hospital calling them and telling them a certain fact, they probably do believe that William Husel contributed or hastened the death of their loved one. Especially after having a lawyer and deciding to move forward in something like this. Probably do believe that. And after an onslaught of how this man is the pariah in this town was out there, there's zero doubt that they don't believe that William Husel, at the very least, hastened their death. But many of them didn't even look at the medical records. Many of them. And I understand it's probably not an easy thing to do. They left it up to the lawyers. But only a few of them. But the first thing I need to point out to you, before I even get into that, is how few of them are the actual power of attorney or decision maker to withdraw care that the state called. That can shock you. There were only 4 out of the 14 patients that the power of attorney actually testified. A person who was ultimately in charge of the decision to withdraw care of their loved one, only 4 of them that testified in this case were the actual power of attorneys. There's one that's questionable, it might make it 5, and that was Mr. Allen's son, who the spouse left it up to the decision of the rest of the family and the children. But that's still a curious number. Why is that? Why are they not bringing you these family members, the actual decision makers, and then asking you to make a decision like this? How is that possible? It's wrong. It's flat out wrong. It's not what a citizen accused deserves, and it's not justice at all. Having said that, you have a couple of patients who made this claim of being brain dead. The first one I'll bring up really didn't say it. It was Mr. Marshall from Timmins. He didn't say that William Husel said he was brain dead. He said that the nurse who called him in the middle of the night said that he was brain dead. It doesn't seem very likely or plausible that a nurse would call from Mount Carmel in the middle of the night and tell you, your loved one is brain dead. Do you still want us to resuscitate them? And he says yes. Remember, Mr. Marshall said that the only thing William Husel said to him was, I'm sorry for your loss. So in light of that, I don't really think you can put much stock into that. But there's one thing you know. Anoxic brain injury from all of these cardiac arrests were potentially there, and the likelihood of them being confused is great. So, starting with that fact, you have David Austin with Tara Schwartz. She was 16 at the time, didn't even have a driver's license. Mr. Austin said that Dr. Husel said his brains were dead, her brain was dead, her lungs were dead. That's not a medical term. It's her other organs are dead. None of those are medical terms. And the nurses are fully aware of what brain dead is and what's required at Mount Carmel and what's required under state law. And there's nothing in evidence that indicate that their training says otherwise. Fortunately, Nurse Ebrow testified late in the case, so I got to ask him, did Dr. Husel say anything about brain dead? Did brain dead ever mention? No. They know. They absolutely know that you can't do a terminal excavation on a dead person. Or you can't give medication to the dead. So this whole brain dead theory, which first surfaced in a lawsuit, is something the prosecution just ran. It's something you can't forget. And something that completely contradicts these independent witnesses, all of them. Not a single one, not even their cooperator, informant, whatever. Not even Miss Mcdonald went that far. And then you have Miss Allison. Miss Allison, Christine Allison, was interesting, but she had a hard time keeping her facts straight as well. Another fortunate event was Jason Schultz, the nurse who was a charge nurse, an ex-Marine, an ex-war veteran, who came up here and told you that no, Dr. Husel did not say anything about being breathed in. In fact, these two contradicted each other. Her daughter said she had multi-system organ failure. Miss Allison said brain dead. That's the difference. I think she might have squeezed it later on during the second part of her testimony, or brain dead, but initially she said multi-system organ failure. And then again, they used that odd number, 99.9% sure. And then we had Beverly Leonard and Wesley Black, the nurse in that case, was specific and clear about nothing was mentioned of being brain dead. These are critical. This is clear conflicts in the evidence. Clear conflicts in the evidence, which you have to consider their motives. Right? All that we do is done with an eye towards something else. They contradict each other, and they're also contradicted by the nurses. And the credibility of these three patient family members are highly questioned. There's a financial interest in this case, and I realize nothing stumps the loss of a loved one. And they probably are angry, extremely angry at Dr. Husel. But that doesn't mean they're well-informed or correct. It doesn't mean that at all. Now, there were a couple of things that happened that you may have noticed or may not have noticed. Let me start off with Miss Leonard. Miss Leonard took the stand and and showed you all a bottle. And during her testimony, I don't know how many of you noticed it, she did something to that bottle. I'm about to show you a video of that, where we would argue to you that this is clearly something going on with this evidence. First thing I want to direct your attention to is there will be a moment where she gets to it. You'll hear the prosecutor talk about how the sticker is very small, the prescription is very small, and then at some point you'll see her go like this, and once she rips the sticker off of the bottle, she makes a face like that. And you can see her looking at it and then eventually putting it down. I'll show it to you right now.
May I approach the witness, Your Honor?
You may.
I'm approaching the witness with a small pill bottle and labeled States Exhibit 33.
Yes.
Do you recognize that?
Yes, it's my mom's prescription bottle for 15 milligrams of morphine.
Where did that bottle come from?
My mom's house.
Who gave it? How did you get it?
My dad gave it to me.
Okay.
Let's pause this so we get the, I'm going back, sorry.
You both are quick.
Let's pause it so we get the audio lined up with the videos. Can you handle it, James?
May I approach the witness, Your Honor?
You may.
Under pressure, the witness with a small pill bottle labeled State's Exhibit 33.
Yes.
Do you recognize that?
Yes, it's my mom's prescription bottle for 15 milligrams of morphine.
Where did that bottle come from?
My mom's house.
Who gave it? How did you get it?
My dad gave it to me.
And I know the script is awfully small. Can you find a date on there?
Right about
11/1/2018.
And what day did your mom die?
11/20/18.
And what does the prescription say on the label that it's for?
Morphine, SULER, 15 milligrams, tab, MAL. Quantity 60. Gregory runs as her doctor. Law prohibits free refills, and flu shots are now available.
I'll show it to you one last time really quickly, just in case you missed it.
Objection, Your Honor.
This is staying.
May I approach the witness, Your Honor?
I've moved on. So, why is this important? Why is this important? And that is because in the medical records, there's a difference of what the dose amounts were for Miss Pettick's home medication. You see, on one side we have 50 micrograms or 50 milligrams of morphine versus 15. We know that 15 milligrams of morphine is 100 micrograms a day that Miss Pettick was taking at home. And remember, in her obituary, she was now finally free of pain. But 50 micrograms is over 300 micrograms a day of opioids that she was taking for her pain. There's a big difference there. And you heard the testimony that this is something she gave to the prosecutors shortly before the trial. Messing with evidence in a case as serious as this is 1,000% improper. I feel for Ms. Leonard's loss, but this is an important matter that we've all labored over, and no one has the right to manipulate any kind of evidence to make things go one way or the other. And it's another perfect example that this is a witness that is an interested party. It's something you must take into consideration when you deliberate and you think of her credibility, especially based on statements she made. You also had heard that many of them have the same lawyers. And some of the phrases and things they said pretty much aligned up with one another. Oh, before I go into that, again, this is Ms. Pettick's, and as it relates to the different, to the paralytics, you'll see she was given the paralytic at 2200, and then the fentanyl at 2248, which is 48 minutes after, not well past the 30 minutes that's required under the order set. And you heard multiple times in this case, you were shown things, and paralytics was brought up multiple times. But what the state tried to do is show you paralytics during the intubation instead of the extubation. You may recall when I was cross-examining Ms. Sawyer brought up during Mr. Dreyer's testimony pain scores from 3 days earlier before he was extubated. Paralytics given in the morning when they're extubated at the nighttime. All of these different things. We shouldn't have to do that. We shouldn't have to point out the misleading information that's being given to you on the fly. Because we don't know what questions they're going to ask. We don't know where they're going to go or how far they'll go. But to do that on the fly and to be able to come up with these things and show you, look, this is from 3 days earlier. And they're trying to say, oh, this medication took care of their pain. It was sufficient. Even Dr. Husel knows 100 micrograms took care of the pain. Well, it's different during an extubation. The one fact that I hope you all take back with you is that palliative extubations are different for a multitude of reasons. But to try and mislead you and say, oh, look at this, 50 micrograms took care of the job, when in fact that was 3 days earlier, or paralytics were given and a person can't breathe when it's perfectly proper to do it during an intubation because they're fucking the bed. All of these things are unfair. This is not justice. This is far from it. And this is something you should hold them to a higher standard. Imagine having to sit in that seat and one misleading thing after another gets presented to the jury who will decide your fate. How atrocious and how scary is that? That's not justice. And that's why you must hold them to their standard. And that's why this case doesn't belong here. Far from it. Far from it. So, you heard Miss Allison say that they met at the lawyer's office and several other patient families were there? Well, yeah. Listen how they testify alike.
He's laying there resting comfortably, and now he's dead. How did we get there?
So did you, I mean, the family literally was in a state of shock when we were told she was brain dead, because how did we get there? How'd that happen?
I don't have any evidence to say these women knew each other before this case, but certainly we heard evidence that they did after.
It's okay, James.
And certainly before they testified. So, in the beginning of this case, I showed you this chart. Remember during my opening statement, I showed you this and I said to you, all you have to do is pick one. And William Husel is not guilty on every count. And that it is impossible for them to meet their burden based on these facts. I want to revisit them now that we've had the opportunity to hear the case in its whole. The side effects. There's not a single piece of evidence that you heard that any one of these patients actually felt or suffered any of the side effects. In fact, Ms. Penix, when she was taken off the ventilator, you saw the note that she was breathing afterwards. Brandy Mcdonald, it was shown there that she was breathing afterwards. There are no maximum doses. What's a doctor to do? Use their discretion and their experience. He utilized his experience with Tracy Young, and you see that throughout this case, that the doses vary based on their clinical picture. The other thing with Ms. Penix, if you remember, Wesley Black testified that they pleaded with the nurse and Dr. Husel that her greatest fear was suffocation. So what's he to do? Let her suffocate? Let her feel herself suffocating to death in her last moments? No. That's the time for compassion. And that's exactly why he utilized that. Her clinical picture, the fact that she was receiving opioids at home, and all of the other things, all of the other factors came into play. If your blood pressure is low, it's going to take a while for the fentanyl to get through your system. In the meantime, you're going to suffer because the blood's not pumping. It's not going to be able to distribute before it gets up to the brain receptors to be able to tell you, hey, take care of this pain. The pH levels, the acidosis, all of these things. a person's liver and kidney functions? Are they able to break down the chemicals the right way? All of these things, their tolerance. None of these factors were ever presented to you. We tried our best during cross-examination and through Dr. Zivit, and he explained all of the different variations that pain management with the healthy is different than pain management with the dying. And no one knows what's painful in death. No one knows what anxiety we suffer. Oh my goodness, I'm dying. I'm going to die. No one knows what that feels like. And you remember Dr. Zivit showing you the anticipatory anesthesia with you want to get over that pain before it's too late. You don't want to come back after. Now there are some doctors who will let you suffer. And they'll let you get some pain and titrate it and say, okay, let's adjust it. But that doesn't make it a crime. No evidence that the side effect ever occurred. That goes to his intent, and it also goes to causation. No maximum doses. We don't know. And again, folks, the medical community together can't come to a consensus. But they can? They don't want you to believe doctors. They want you to believe them. They don't want you to believe records. They want you to believe them. They're like, right, Groucho Marx, who are you going to believe, me or your lying eyes? That's literally what they're telling you. That's what they're selling you. No policy. Goes to his intent. There's not one instance where there's a policy involved and he says, I don't care, I'm violating that policy. Let's talk about for a moment what's fair. What's fair is if somebody has an issue with what you're doing, they tell you. And you saw all those pharmacists approving the medication. And when the one that had a problem with it said something, he didn't go to William Husel. He didn't go to him at all. Neither did the manager of the pharmacy. Neither did anybody until he's fired. Or until they suspend him, Until Swanner and Ralston decide to put him on suspension. And then they want him to be part of the order set. To help him develop a policy. If they thought he was a murderer, would they ask him to help him with the policies? If there was any evidence of that, would they ask him to be part of the policy? To fix what might be wrong? What might be different about you because you have different training? All of this flies in the face of reality, and it's such an absurd case. It's so absurd. And with any one of these, you have a right to hold to this and say, you know what? Because there's no max doses, I find him not guilty. I don't need to read this, because I know there's no max doses, and that went unchecked. You have the ability to do that. You have every right to do that. Because it's their burden that's deeply embedded in our constitutional values. Deeply embedded. It's what anyone would want for themselves. Anyone. And then, the medical studies show the opposite. You heard evidence of it. They told the police about it. And it went nowhere. Imagine telling the police that something that might exonerate you, and it goes ignored. That's not fair. That's not just. It's not justice. Doctrine of double effect. Boy, was that like to get it to have you guys consider. It's definitely embedded in medicine and in everything they do, and especially when it comes to opioids and palliative withdrawals. It's a factor. Perhaps that's why they're saying they could have lived anyway, to get rid of the issue of doctrine of double effect. I really don't know. I wish I could argue something a little bit more concrete to you in that respect. But the fact of the matter is, you see it in their own order sets. You've heard multiple witnesses testify to it. Even the nurses know about it. His experience. Tracy Young speaks in and of itself. And that was before all of these patients. The process. The fact that you would rely on the pharmacy doing their job. Do you know what Hagris testified to? Dr. Hagris said, Dr. Hagris said, that if he sees the meds being administered by a nurse, he assumes the pharmacist approved the order. His job, and he said it, his job is to deal with the patients, not to deal with any overrides or anything like that. He said the only way he's ever notified of an issue with his dosing is if the pharmacy reaches out to him. That's what he told you. And that he was never informed of an issue by any of the nurses that they had with him. Now, why is that acceptable for Dr. Hagris, but not for Dr. Husel? If there's an issue with his dosing, his expectation, his understanding, is that someone will come to him and tell him, I have an issue with this, and let's discuss it. They discuss it, they come to a consensus, and that's it. And then he also told you about his reliance on the discharge summaries, or on the attending physicians, that he assumes they're doing their job. He's going to assume it. And there was this whole thing with Mr. Zion talking about, you assume good intentions of your coworkers. Yes, I agree with that. But absent any evidence of anything wrong, you should assume that too. This I didn't get to during the openings, but the patients and their clinical picture, that literally goes to the causation. Vasopressors, 30 seconds to a minute and a half for all of these patients who their blood pressure was tanking. I think there may have been one that didn't have a low blood pressure. But all of these that were being turned off, it's going to act quickly, faster than the fentanyl. You heard the fentanyl is a 5-minute peak effect. They're still on the ventilator. The nurses can observe whether they're having an adverse effect. There can be things done. And it's so funny because it's okay for a cardiac, it's so interesting how the prosecution will argue to you, oh, you can have a heart attack, cardiac arrest, no problem. There are doctors there, there are nurses there, you're in a hospital, it's okay. Hey, I don't think anybody's going to volunteer to go have a cardiac arrest at the hospital. At all. But it's okay. No, you're not healthy. If you have if you die at the hospital, yes, sometimes you can be resuscitated, but sometimes you can't. So to make that argument flies in the face of it all. And the vasopressors are going to turn off before the fentanyl ever becomes a factor. Ever. And they never gave you, there was a causation on both of these, they never gave you any evidence as to how much time they would have lived but for the fentanyl. And that's because these folks were dying and dying, actively dying, even on life support. What's the opposite of life support? Death. When you can't breathe on your own and you're dependent on having a machine make you breathe, you're not going to breathe and take it away. You're also not going, your heart is going to stop when you don't have that jet fuel running through you. Any one of these folks, any one of them, is a reason that you can find William Husel not guilty. I want to conclude with something. But the first thing I want to tell you is to look at that man. He was pointed at. All kinds of things were said about him. It's called the defendant. He's less than, he's not even a person, he's the defendant. I submit to you, that's not who he is. He is not the defendant. He is Dr. William Husel. He dedicated his life to taking care of the ill, to taking care of patients, to saving lives, not to taking them. And to sit here and accuse him of something else is just nothing short of absurd. Absent any real evidence. You don't have a shred of evidence to his intent. It's true, you can't get in his head. Why didn't they get those computers? Why didn't they follow the evidence? Why aren't we listening to the independent witnesses? Why aren't we just saying, okay, you know, sometimes the easiest answer is really the real answer, which are these folks were dying. As sad as it is, they were dying. And we have to assume, because his dosing habits are different, that he's a murderer? Is that where we get? Is that where we've gotten to? Is that where we're at? Where he's a murderer because of this fact? I submit to you, no. It takes a lot more than that. Now, I'm not going to have the ability to get up here and speak to you again. And this is my final opportunity to speak with you. And I want to wrap up by telling you something. The prosecution, they will have the opportunity to get up there and say, and argue their case again. And it's not because we flipped the coin. You all know I would rather have the last word. But the reality is they have that burden. And he can get up here and say whatever he likes, just like he did the first time. When he told you, William Husel on Sandra Castle walked into the room and said, you want me to take care of that noise for you? Well, you know that's not true. Stephanie Lachard told you that she was, you could hear her on the other side of the ICU, and she went to Dr. Husel and asked him something for the death rattle. And what was the first thing he did? He gave her a medication for that death rattle first. And waited to see if it would go away. And if it made her more comfortable. It wasn't until Stephanie Lachard went to Dr. Husel again the second time before they discussed the fentanyl. And how this family knew what the potential side effects were and all of the relevant facts that were needed, and they made the decision. You just saw the video. He left it up to the family. And he told them, gave them the informed decision. They made that difficult decision. They made it on their own. But in this trial, the prosecutor can get up here and say, you want me to do something about that noise? That rattle? I can take care of that. Zoom, shoot up with fentanyl. And I'm sure I'm going to have plenty to say, but please remember that the burden lies with him. The burden lies with the state. Regardless of what he says, you can't create evidence where none exists. You can't make this up. Every person, their death was hastened when they chose to take their family members off life support. And it's just unfortunately a fact of life. that death comes. Death will come to us all. So as you're sitting there and deliberating this case, I want to conclude with reasonable doubt. Reasonable doubt, as I mentioned, is a unique concept because the one thing that makes it so important is it's irrevocable. You can't take it back. You can't come back the day after this verdict and say, you know what, I thought about it.
Hold on. Where are we going with this?
That it's an important decision.
It's an important decision, but it's not, well, let's move on to the important decision part.
It's a decision that you must make the same like you would in your most important affairs. And it's based on evidence, not theories, not possibilities, not potential side effects, not any of those things. And the people who were there at bedside all told you the truth. They all came forward and gave you the rest of the story of what they could. And not a single one spoke badly about this man. They knew him. They went to work with him every single day for 5 years. Despite this theory that he killed people multiple times, you didn't hear anything from Fentanyl, the drug company? Why didn't you get a witness from a manufacturer of fentanyl that will tell you, you know what, we did studies, and this is what we found, and this is the science behind this medicine? You didn't even get the insert to fentanyl. You got some lexicon description of it, but none of the other things. You didn't hear about any spike in deaths at the ICU that are different before and after Dr. Husel. There's no evidence here to suggest anything other than these were terminal excavations. When you go back and you're deliberating on this case, please remember it's your decision. You should listen to all your other jurors, but it's your decision. Stick by your convictions. And if you feel a certain conviction of not guilty, if these are your beliefs, they're your beliefs, and no one has the right to take them away from you. No one. As it relates to reasonable doubt, in this case, through all of the evidence that you've seen, I like to compare it to walking through the desert. You're walking. And you're walking. Beverly Leonard, you come across Beverly Leonard and you say, which way to the water? Beverly Leonard tells you, well, I know I messed with the pill bottle. I know there's a dispute, but the water's that way. And then you go that way. And you have Talon Shore standing there. Talon Shore says, I was shocked. I know I told you I was shocked by the evidence, by the dose amounts, even though I had other doses that I approved. And even though Jake Deemer says something completely different than what I'm saying, trust me. And he points you in that direction. You keep walking. And you keep walking. And you keep walking. And you keep walking. And then you realize, oh my God, I've made a huge mistake. The evidence is there. The records are there in the middle of the desert, and they don't send you in the right direction. And you could have made a huge mistake. In light of that, ladies and gentlemen, there's nothing you can do at that point. Do not allow this misguided case to misguide you. If you saw evidence of William Husel intending on killing people, then I will sit down. If you see anything in here that there was respiratory depression or they suffered a side effect, then I will sit down in an agreement. But none of these things were proven to you. This, in fact, as complicated a case as it is, it's a very simple one. We have a certain standard in a criminal courtroom that is much different and much higher and cannot be tried in another way because the consequences are far greater. I thank each and every one of you individually and collectively for all of the work you did in this case and the sacrifices you have made. William Husel thanks you as well. And I know you'll make the just decision. This is not a murder case, never was, never will be, and it's not an attempted murder case in a last-ditch effort to just try to get some type of charge stick. It doesn't matter how much you throw against the wall and hope that you'll compromise. You didn't come here to compromise. You didn't put your life on hold to compromise. And I ask that you do that. You do the absolute opposite of that. Stand by your beliefs. Thank you so much.
Thank you. Ladies and gentlemen, let's take 15 minutes. I imagine you use a break. Okay, it's been an hour and a half. With that, we'll come back and hear the rebuttal. It may carry a little past 5. Is that going to be a problem? No? Okay, David, call them up and send them out. Have a good break, guys. Everybody can be seated. Mr. Biles, anything for the record?
Not from the defense, sir.
Mr. Zion? Okay. Be in recess 15.
Well, I have to pay this weekend. You're all. Yep.
items first thing, because we're going to play discharge in a moment. Okay. Second thing, I just saw an email from Tamia. Is that your staple? Position?
Sure.
359, she sent it out? Yeah, you're kidding me. You see it?
That's yours.
Okay. Cool.
And we're seeing that therapy rings
A little shocking.
today.
Yes. So, okay, thanks.
Yeah.
That's the only outfit I own.
Double check, and if there's something I need to worry about, let me know. I know there's nothing I need to worry about, but. Okay, cool. Cool. Bye.
I just email you to your email with the magnet pictures, the videos. How do you prefer to do that? Same question to you.
Well, the magnet stuff and stuff will be gathered up by her, it won't be sent back. And she'll have it for Court of Appeals records.
Or do we just want to put it on like your whole
Well, if everybody agrees to that, great, that'd be the thing to do, so they can see it. If the other side will agree with that, fine.
I mean, I think that's the most
It is.
expeditious.
Yeah, but you're substituting something for the original. That's what makes me nervous. I like that, but I agree. About that time, David?
I'm trying to remember, I think so.
It was like 8 after.
Okay, let me run it.
David, just
Okay.
preferences for getting on like recordings of this, whether it be like USB drive or like the actual physical originals.
Can we talk about this later? I mean, really? Yeah, no, but we're trying to organize it, so, I mean, talking about the exhibits right now is not, helpful for us. We
We've
have
got
just a
time.
few minutes to work on this, and we'd
Well,
appreciate.
I mean, we're going to do the charge tomorrow morning anyway.
That's fine.
Because that means if we do it now, they'll be here till 8 o'clock tonight.
Yeah, no issues, no issues. We wouldn't have issues with guitar breaks or anything like that.
co-counsel, defense counsel, ladies and gentlemen. Let's start where he started. Start with constitutional rights, equal protection. Absolutely. The judge in his instruction will talk about equal rights clause of the 14th Amendment of the U.S. Constitution. But insofar as the defense counsel brought this up, I will echo that. Everyone gets treated equally under the law. That's what they're talking about. And just because you've had the privilege of education, just because you've had the privilege of training at one of the best places in the world, just because you have the privilege of a family that loves and supports you, just because you have the privilege of that title of doctor, doesn't mean you get a pass. In Franklin County, Ohio, for your misdeeds done at night. The title of doctor does not have in parentheses God Almighty in that. You don't get a pass. You do dirt in Franklin County, and he did dirt in Franklin County, we're going to call you on it. Reasonable doubt. Mr. Bias kept saying, it's beyond all. No, the judge will tell you what reasonable doubt is. He'll instruct you. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs, or depending on moral evidence, is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is of such a character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. That's the law of reasonable doubt in the state of Ohio, in Franklin County. It's not beyond all doubt. It's not to the exclusion of that right there is what the judge will tell you. It's based on reason and common sense. He put up motive. He put up the definition of motive up there. Well, apparently it was too much to write this next sentence, which is the law in the state of Ohio. They did put up the first part, and the judge will read it to you. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Where an act is a crime, a good motive is not a defense. So when he says there's no evidence that this man had malice towards these people, that they had some sort of argument, or that he bore them ill will, I would argue to you that is irrelevant to determining whether the state has proven its case beyond a reasonable doubt that he purposely caused their death here in Franklin County, and he's the one that did it. His motive could have been pure in his mind, because he's Cleveland Clinic trained. He's the only doctor there at night. He's the only one on the floor that can make these calls. He's the only one with prescriptive authority for that whole shift in the ICU. He's the one all these young nurses are coming to and listening to. He's the one that's teaching them. His motive could have been pure. But if it's a crime, and ladies and gentlemen, it's a crime to kill a dying person, it's not a defense. Mr. Baez seems to like the records when they support what he's saying, but these records, they don't tell the whole story. Well, those are the medical records we have from the hospital. They've been stipulated as fair and accurate. Those are the complete medical records. So when there's a suggestion that the state of Ohio was misleading you in any way by talking about portions of those medical records, the whole thing, stipulated by the defense, is right here in front of you. And that's not the only thing we have. Remember, the judge will tell you evidence is the exhibits minute and evidence, it's the stipulations, and it's the testimony of the people that had things to talk about in this case. And that included the nurses, the pharmacist, and the family members that were there. Mr. Baez makes the point that we, the state of Ohio, argued that teaching and helping is a bad thing. Well, when you're teaching bad things to your nurses, it's a bad thing. Made a point over and over again that no one can say, the experts wouldn't say how long anyone would have lived but for the fentanyl and midazolam. That's true. Remember Dr. Ely said, well, yeah, no one knows how long they're going to live. I can't say how long anybody in the world is going to live. I mean, on a long enough timeline, folks, we're all going to die, right? That was Dr. Ely's point when he said, Dr. Schweiger's point, no, I can't tell you when a person's going to die, right? I can tell you these drugs either directly caused their death at that time or hastened it so that it happened sooner than it would have otherwise. But no, otherwise, who knows how long someone would live? And that's not just true in these particular situations. Dr. Ely made it clear when he said that over and over again. Yeah, in general. Because unlike some, he knows he's not God and he's not playing God. Dr. Zivit's opinion. You'll have that. Defendant's Exhibit, Exhibit 1. It's about 5 pages long. Read it. See how detailed it is. Remember his testimony. There is no maximal dose of fentanyl. That's partially true. What was actually said by the state's witnesses is there is no prescribed maximal dose of fentanyl. Prescribed means prohibited dose that you can give. Not because fentanyl is like vitamin C, where if you take too much of it, if you just pee out the rest, that you can just take however big bottle you want of it, and, well, if your body doesn't use it, it just goes away. No, there is no prescribed maximal dose of fentanyl. Because, as the experts explained to you, with patients in hospice care, and these weren't hospice patients, in patients in hospital care, you heard reference to TY, people that were at the end of a very long illness. You can give, or people with very high, because they're at the end of that. You want doctors in those situations to give them as much as they need, because nobody is about, not the state of Ohio, not even the people that testify from the state, nobody is about making people suffer. This notion that Dr. Ely and Schweiger had some sort of demented philosophy of suffering and redemption and death. No, they didn't testify about that. Nobody does. And the medical community does. There's no prescribed, because in those situations, not these, you want doctors to be able to give 2, 3, 4, whatever they need to give to control the pain. So you don't want to give a prescription saying, oh, never give above this. That doesn't mean that for every individual out there in the world, me, the judge, anybody in this room, there is not a dose of fentanyl that will drop you and kill you in a moment. Fentanyl is a dangerous drug with the known effect. Not a possible, not like a 1 in a million chance, the known effect of suppressing a person's ability to breathe. And while as a healthy person, you can take in more because your kidneys and your liver is working, sick people can't process as much. So the maximum amount they can get before they die is much lower than a healthy person. There's no prescribed maximum dose. There is a maximal dose. Dr. Ely told you that any individual can get in this world, and they will die. I don't believe there is any evidence that Tampa General is a Catholic hospital, and I don't believe there is any evidence that Vanderbilt is a Catholic hospital. There was evidence that Dr. Ely is Catholic, and Mr. Bryce, well, what does that have to do? Why was that brought in? Well, that wasn't brought in by the state of Ohio, ladies and gentlemen. If you recall, that was brought in by Ms. Menashe during cross-examination. It made a big point of that somehow his faith made him less credible or was somehow subject to cross-examination and affected what he was saying medically his practices are or what the appropriate practices are. That was not the state of Ohio talking about Dr. Ely's faith. That was the defense talking about it, and I would argue to you in a very derogatory way. And whatever statements Dr. Ely did say about his faith, It enhanced, I would argue to you, how he took care of his patients. Because for him, for Dr. Ely, these weren't just the people he cares for. They're just not people taking up room in his ICU. They're people that matter. They're people that if their dying wish is to get baptized, and remember he said, I thought they just meant, yeah, we can do that. We'll get some holy water, because that's what Catholics do, right? We'll just do a little. You want the full dunk. So my staff went out and did that. They went to Costco. Because these aren't emergency things that the nurse has to go grab the fentanyl and override right at night. We got to get this done. You don't call people over and over again. DNR. That's not how you do it. This man's dying. We know it. What wrote it on the board? It was written on the board. They went to Costco. They got the tub. That was his staff that did that, not Dr. Ely. And he thought, I want to talk about this. That's why he wrote that article. Because with Dr. Ely and Dr. Schweiger, I would argue to you, you saw how it's supposed to be done. That just because you're sick and you're old, or maybe a drug addict, you still matter, and your death still matters. And it's not something to get over with in 15 to 20 minutes, so everyone can move on. Talks quite a bit about Sandra Castle, Nurse Lachard. Well, Nurse Lachard, her 6th shift as an ICU nurse, recent graduate of Johns Hopkins. She did question twice. And she talked to the one nurse, and then she talked to the other nurse. Oh yeah, the nurses that have been trained by Dr. Husel, this echo chamber they've got going on now. That's what he does, it's okay. She's not questioning that dose because it's something she's ever seen before. She's questioning because no one does this. She's brand new. And she's questioning the doctor of the year, Cleveland Clinic guy, to these other nurses. Is this right? I would argue to you that there was no testimony that agonal breathing, the word agonal refers to the term agony. That agonal breathing, however, was testified has a deep brainstem reflex. That is not painful. So, the state misled you. The state told you Ryan Hayes was brain dead. No, the state did not tell you Ryan Hayes was brain dead. Never said that. You'll have State's Exhibit 2. What the state did tell you, though, and what you heard from Dr. Ralston from his note was, when they're talking about it, it's right there. You'll have a chance to review this. About waiting 24 hours and reassessing as he may likely progress into brain death, given the CT scan showing diffuse cerebral edema. They thought that this was the best option of all, and at this point we'll do that. I did discuss with them that he is not experiencing any pain. I did discuss with him that we may never know what causes cardiac arrest. I did discuss with him that due to the diffuse brain injury, he's not experiencing any pain or discomfort as well. And he told you, Ryan Hayes, the part that made Ryan Hayes, the top part of his brain, is gone. But he's not breathing because he's still over-breathing the ventilator. But he is not medically suffering any pain or any anxiety. And even their own expert said, and it says it in his report, the only legitimate thing to give a patient fentanyl for is pain relief. So what's the purpose of giving Ryan Hayes? Not the usual dose. Not twice, not 3 times the usual dose. 1,000 micrograms of fentanyl, 10 milligrams of hydromorphine, 10 milligrams of dust, and 23 minutes later, doing it again. What other purpose can you have in that situation with a man that clinically cannot feel pain or experience anxiety? What's your purpose there? Your motive may be, this guy's gone. He's a breathing corpse. Come on, let's get it over with. He's in my ICU. He's taken up a bed. He's not an ICU patient at this point because we're not trying to keep him alive or anything else. Let's get it done. What other purpose do you have? But you don't get a pass for killing a dying man, even if you are Doctor of the Year. He said, oh, the state's theory about this brain death, it's all made up. Well, the witnesses that were there, the family members, who I would argue to you have very distinct memories of what was said to them. These were big moments in their lives. The nurses, almost to a person, had to testify. I didn't remember this at the time. I had to go back and review, or I had a slight memory of this case, because this is what they do with Dr. Husel in the nighttime ICU, year in and year out. This is just another Tuesday night. But for someone that's watching their wife die, or their father die, ladies and gentlemen, I would argue to you that their memories are very accurate. That those words, those visions, the things in their minds, the smells, is all right there, burned in. And they're the ones that said, we were told either brain damaged, and in many cases, brain dead. And, oh, none of the nurses say that. Well, Jordan Blair said it. Recall Jordan Blair's testimony. Yeah, I did hear him say brain dead in the context of the speech he would give sometimes. Jordan Blair heard them say that. And they don't want that in there because brain dead, as you heard, is a very specific medical diagnosis. It's a very specific thing you have to declare after many tests. And none of those tests were done in this case. But that's what these families were told. Either brain damaged, brain dead, you can let them live out the rest of their existence on a machine, or you can let them go peacefully. What a choice of that? Who would not say, oh, let them live out on the machine forever? Who's not going to say, well, then, yeah, doctor, let's do that, of course. Every nurse told you, everyone knew. Ladies and gentlemen, rely on your own collective memory. But these nurses don't work on other shifts in general. And didn't have contact with daytime doctors and nurses. So when they say everybody in the hospital knew about this, ladies and gentlemen, I would say rely on your own collective memory. That, I would argue to you, was not the testimony of these nurses. Wants to argue that we did not meet the burden by pulling all of the pharmacists that actually administered those. Now, we pulled 4 pharmacists, 2 of the ones that were involved in many of them, the ones that finally realized what was going on in the ICU, and were so shocked by the amount of drugs being used in the ICU, because a unit dose is 100 micrograms. So shocked when they found out this is actually for a palliative excavation, they set it up a line. Not to Dr. Husel, because when you call Dr. Husel, as Caleb had before, and said, is this extra zero? When he had called it before, that's for a procedure. It's okay. Where was the teacher there? Where was the teacher explaining everything to Caleb Schroyer? Now, he knew what he was doing. The pharmacy says I can't use this, I do what I want. So Caleb's, okay, well, when he finally had confirmation from Jake Deemer, and remember, Greg Dreschbach, you see the same characters over and over. And how many clips did the defense play with Jake Deemer to support their case? Jake Deemer. So, ladies and gentlemen, you heard about the procedures, about what happened with Taylor and Greg. You heard how for Randy Miles and Sean McConnell, how these procedures had been put in place years before, about how they disagreed, how at least Miles disagreed with that, or excuse me, Sean O'Connell disagreed with that. But that's what it was. They can take things on override. Pharmacy should not be held liable for that. You should just be allowed to clear them out. Well, the pharmacists were held liable for that, for those overrides. They didn't know it. They didn't know what was going on. And Taylor Schroyer, this whole thing of him saying it was either diversion or wildly excessive was not a recent fabrication said on the stand 7 weeks ago. That is what he told the pharmacy investigator to use
Objection.
them. What was his testimony, Judge?
That was his testimony. I heard objection, but I didn't hear why.
Based on the court's ruling?
I'm sorry.
Based on the court's ruling, sorry.
Okay. What time period was it?
I don't know, Judge. He testified and talked to the pharmacy. That's what he said.
Okay, let's move on it.
So not a recent fabrication. He said, remember, he's going to ask you, the diversion call. Yeah, they thought it was diversion because you're not really, no one really puts 1,000 micrograms into a human being and calls it medicine. I mean, they got to be sealed, right? Because if this is really palliative excavations, wildly excessive. And he's a 2-year pharmacist, folks. That's who broke all of this. A man that had been doing this for about 24 months. Talked quite a bit about Detective Gillette. I think he described the investigation as pathetic at best. Well, ladies and gentlemen, I would argue to you that the CPD investigation of this was thorough and responsive, and they weren't about to let Mount Carmel or anyone else dictate to them how they were going to conduct, potentially, a murder investigation. They are told about the allegations from the hospital because it's got to come from the hospital, folks. This is not something that was, family members, disgruntled family members calling up the police and making calls and saying, no, I think this is what happened, I saw them do this. This is the hospital coming to the police. People like Dr. Swanner and Dr. Roth coming to the police about their own doctors, saying, not the state going out and trying to find this case, not anybody from the state's attorney, we call them county prosecutors in Ohio, nobody from the county prosecutor's office trying to go dig up a good juicy case. This is the hospital coming to us and saying, we've got a problem. We need it investigated. And those detectives were not going to say, well, when you get a chance, let's round everybody up. They said, right now, I want to talk to people. Right now. And so these nurses and pharmacists and others that were involved in this are being pulled off their shifts, are being called up at home and told, you're coming to work right now. I mean, some of them were actually still working on their job. You have to go talk to HR. And yeah, they're talked to ahead of time by HR and a defense attorney who says, okay, I know you said you were told about HR here. These are your rights because in the next room, you're about to talk to the murder police. Right? Not the diversion police, not the theft police. You're about to go talk to the homicide squad. That's why the hospital talked to these people like that. That's why they didn't have the medical records. Because we're not waiting for you to tell us. We want now, right now, today. And yeah, they're struggling through this. This is a medical case. Detective Gillette is not a medical doctor. None of the people on his team have medical training or experience. They're relying on what's been reported to them, and they want to get it down now, as soon as we can. So they don't even have the medical records in front of them. That took some time to get those medical records to them. And so, yeah, they're fumbling around with them about dates and doses and things like that. That doesn't mean they're not doing a good and thorough job, because that's what the police do. They start investigating right away. They don't say, okay, Dr. Roth, you just tell us what to do and line them up and we'll talk to them when you say so. Nope. They did that on their own terms. And all those questions that Detective Gillette didn't know the answer to when he testified all those weeks ago, it's because... And he's not the one, ladies and gentlemen, that charged Dr. Husel. He's not the one that made that call, ladies and gentlemen. Like he said over and over, I'm not a medical doctor, I'm a cop, right? And ladies and gentlemen, we're not medical doctors over here. We didn't make that call. I'm just a dumb government lawyer.
We found expert witnesses that didn't know Dr. Husel, that didn't go to the same school, who didn't share the same mentor. We found experts from around the country who do this and have done this and who are recognized in their fields for their excellence and their experience, and said, take a look. And they didn't do it for free because that's what they do. That's, their time is valuable because they are so experienced and so well regarded. Do tell us, did he purposely cause their deaths? They don't get a bonus if they say yes. Just tell us, is this murder? And they both came in here and unequivocally told you it was. One of their colleagues, another doctor, he caused their death, he hastened their death. There's no medical justification for what he did in these cases. The hospital did talk to the victim's family before the police, but only after the hospital asked the police, can we do this? Because this is about to get out in the media, and we don't want husbands and wives and children to find this out on the evening news. We want to try to do the right thing here and call them first and give them a heads up. Let them know what's going on. Throw themselves on their sword and start calling people and told them this. And that's the reason the hospital even talked to them beforehand. They asked the police, though. And after getting consent from the police, they did so. I would argue to you, ladies and gentlemen, this was a thorough investigation. You saw the size of the packet. Over 75 separate witness interviews. Over 10,000 medical records obtained through subpoenas with the police. They did a thorough job. And so, let's start talking about acidosis, Detective Gillette. I have no idea what that is. Right? Who would? Wes Black, you saw a clip from him. I've given enough to put down an elephant. That's not him saying that. That's him kind of remembering. That sounds like something he might have said in the past from a nurse practitioner. Is that really evidence in this case that you can rely on in the most important of your own affairs? Does that really take anything away from what Dr. Ely told you and Dr. Schweiger told you? Or what Dr. Moody told you? They're not experts. The ICU doctors are not experts, but they have expertise, and their practices are relevant. Mr. Bias said, oh, geez, if the police, after Wes told them that, had just gone out and found this nurse practitioner who kind of remembers, he even said, I have a fuzzy memory of it. If they had just gone out and found her, wouldn't that have been nice to know? Well, ladies and gentlemen, if there was a nurse practitioner in the world, if there was a doctor in the world, if there was anyone with any medical background or pharmacological background that would have said these things, said what he did was okay, they would have been here.
Objection. Burdenship. Move to strike.
Okay. As to the comment, this is not evidence, ladies and gentlemen. It's the state's burden to prove guilt beyond a reasonable doubt. Okay? You're not taking it for anything else. This is commentary.
It is argument that, ladies and gentlemen, that witness didn't exist. Not trying to shift the burden to anybody. The burden's on the state of Ohio. We brought the charges. I've said over and over again, and I mean it now, I mean it at the beginning of this process, hold me to my burden. But when you say, play a clip of a nurse that has some fuzzy memory of somebody saying something that might be helpful, well, geez, that would have broken the case. Another nurse, I heard that actually high doses of fentanyl can prolong life. Do you have any evidence of that besides that statement? Where is that nurse getting his information from? Who's teaching him?
Okay. Ladies and gentlemen, as I explained, the burden's on him. This is commentary, argument.
So when that nurse said those things, once again, we're not shifting the burden.
When that nurse said those things, did you hear any of our experts actually say that? You heard them say exactly the opposite of what that nurse thought he had heard. I heard there was a study out there. Well, Dr. Ely and Dr. Schweiger said, there's no literature that supports this at all. It does not exist. Who is that nurse being trained by? Who is that nurse being told by? Because they're all like, whoa, what? How much? Oh no, it's what we do. Oh, they're getting stuff jammed in there, all our little parts, and they got this lactic acidosis, and they're in terrible pain. I mean, even though they haven't had any pain medication, even though all the pain scores are 0, they're in terrible pain. Who's training that? Who's teaching them that? Mr. Baez makes a big point that the computers were not confiscated. I guess he's suggesting that the computers in the ICU are like a personal laptop, that maybe the hard drives will have some good information that otherwise is not contained in the medical records. I would argue to you, ladies and gentlemen, that it's the common experience of mankind that these computers are hooked up to servers, and that the computers in the ICU are just terminals and outlets that within themselves have no evidentiary value. At any rate, you have the stipulated complete medical records and evidence as to what occurred with these patients. Katie Barga, not a doctor, had training in her prior career as a nurse, not a nurse at Mount Carmel Health. She is a patient safety officer. And I would argue to you, the patient safety officer is a euphemism for if someone gets hurt at the hospital, what's the hospital's liability? What happened here? Let's grade it. How much are we looking at here? I would argue to you, her job is to limit the hospital's liability when looking at situations. I would argue to you that if someone was biased, it was her, and that it was her job when Randy Miles forwarded Talon Schroyer's voice complaint to send this up, and it didn't happen in October. And because of her lack of action in October, 2 more patients were murdered in her watch. So yeah, she kept it at 4. You did not see that report. It is not in evidence. There is no literature that supports what Dr. Husel did. She kept it at a 4. So, once again, I'm not shifting anyone's burden here at all. I'm commenting on the defense's closing argument. When they say, why didn't they ask Dr. Zivit the $1 million question? Right? Well, ladies and gentlemen, why didn't they ask their witness the $1 million question? Think about that.
It's not shifting on that one.
Why didn't they ask him that $1 million question? They have the ability to speak to people.
Objection, Judge.
They could have. Okay.
Overruled.
Ask yourselves that. I would argue that question was not asked because they wouldn't like the answer to it. When you do something wrong, you try to hide it. Mr. Baez said that. And yes, acknowledge. That's one of those head scratchers in this case. But if you think you're doing something for a good reason, you don't hide it. He thinks he's doing good by euthanizing his patients. He thinks he's doing all right. Now, he's not putting down big notes. He's not justifying these pain medications in any of these medical records. If there is a note from Dr. Husel at all in any of these, and look for them, they'll be in the progresses. Look for them. You'll see them occasionally. A note from Dr. Husel. And it usually is, order DNRCC obtained, palliative extubation done, patient died, act. So he's not really explaining anything in those notes. Remember, Dr. Ely even looked at that. Wow, I just saw that. Yeah, I've never seen that. NRCC
excavation, and a death all in once. I've never seen that. 30 years he's been doing this. I've never seen that all in one thing, because that's not how it's done anywhere else in the world. The toxicologist that testified from the coroner's lab. The coroners did not testify because, ladies and gentlemen, I would argue to you, because they didn't test the postmortem blood. They tested the antemortem blood to see what they came into the hospital with. And all the postmortem blood would have told them is confirmed what the nurses and the medical records told you he did to them. So the toxicologist testified, we know what they came in with, we don't know what they went out with. The defense says, well, they got another Catholic at their other Catholic hospital, Dr. Schweiger. I don't believe there was testimony that Dr. Schweiger was actually Catholic. He was German. I remember him saying that. His mom called him Hansi. But Dr. Schweiger did not testify that they could all get up and walk out of the hospital. Now, what he told you is the real reason we have ICUs. And that is to give the body time to recover, if it's going to recover. To chill everything out. Calm everything down. Make sure you have the secured airway, that their heart's beating, that they got that oxygen coming in and out of them. You even paralyze them to do this. You sedate them. Just let the body relax. And then declare itself. And that takes time. That takes days. 48 to 72 hours is how long that takes. That's why you send patients to the ICU. Give their bodies a chance. He said the discussion of DNR in many of these cases was appropriate. What's not appropriate is time. Let's go. Let's go. It's the middle of the night. Let's go. 2 in the morning, call the family. They're done. That's what's not appropriate. We have not given these patients, all of them, time to declare themselves. Made a big point about the vasopressors. Oh, they're going to die in a few minutes. Anytime you see vasopressor, they're dead in 30 seconds, minute, 2 minutes. Well, if that were true, what about the patients on vasopressors that live for 20 minutes or so? If that were really true, and Dr. Ely and Dr. Schweiger told you that was not true, that why give them any pain medication at all? If you're going to take them off the vasopressors and pull the tube out, and they're just going to be done. What's the point at all? Because remember, even their own expert says the only reason you should give anybody pain medication is for pain. And if you're gone like that, remember, fentanyl takes 2 to 5 minutes to even get in the system, to peak. Why are you even giving them? I would argue to you because that's not true. Sandra Castle was not having a bad death. Her granddaughter told you, the whole family's there. If she were having a bad death, they'd be out there screaming to those ICU doctors. And they're not. She is getting morphine throughout the evening, appropriate doses. And her death rattle got loud. And what's important about the granddaughter's testimony is Dr. Husel came to her. You can quiet that down. The defense made a big point about this big decision that they had to make at that point. This big decision. What big decision is there in saying, yeah, give them enough pain medication so she's not suffering? There's no big decision there. That's a no-brainer. That is what we want you to do. Why would that be a big decision to say, yeah, if she's in pain, if she's in discomfort, give her enough pain medication so she's not? Why is that a decision at all? That is just what we want you to do right now. The big decision had been made hours before when Dr. Mahoney and the other doctor had talked to the family about her terminal condition. That was the big decision. Pull her off life support at that point. Hours and hours before. That was the big one. That's the hard one. Now we're just waiting. And not 10 or 15 or 20 or 30 minutes. We're waiting hours because that's how long that takes. And it's happening. Now, they want a big decision for, because it's a big decision for Dr. Husel because boom, give her 1,000 mics out of nowhere. That is not indicated anywhere in there. And he put her down like a sick animal. Troy Allison, I would argue to you, ladies and gentlemen, was not on 750 milligrams of anything prior to his admission. The medical records do reflect, and you'll see him in there, that he did have a prescription for 20 milligrams 3 times a day for 7 days of morphine, extended release. Not the equivalent of what he was given during his extubation. He was only in that hospital for 1 day. Danny Millette was only in the hospital for 1 day. The nurses, he said, oh, they're the most important people in the world, and if they were really doing something wrong, wouldn't they be angry at him? I would argue to you they are unwitting complicitors in this. That there is some collective guilt, morally at least, for what they participated in. They were duped by this man and cannot fully recognize what they were doing and don't want to admit fully what they did. They did come in and say, this isn't about diversion, nobody's stealing this, no one's pocketing, he's really giving appropriate doses and we're pocketing the rest and selling it or using it. We did put these drugs into these people at his orders, but he was so smart and he told us why we were doing this. And the other nurses told me it was okay. I would argue to you their testimony is reflective of their complicity, unwittingly. Remember, to be a complicitor, we talked about that in voir dire, you have to have the same intent. And if you don't have that as the principal offender, it's not a crime. But there is still, I would argue to you, complicity by the nurses in this case. Kathleen McDowell did not lie. She did not lie to the police. She did not lie to you. Defense said that. I'm not sure exactly where that was in the testimony. Remember, the police are not waiting for the hospital to tell them when they can talk to witnesses. They're going and talking to them without medical records and asking them about things that happened months and sometimes years before. And she did not recall this incident. And then when she thought about it, and she thought about it hard because she had just had a conversation with homicide, this woman who, a nurse who just never talked to the police in her life before, has just had a conversation. She thought really hard about it. And she called an attorney and she said, yeah, I think I know what they're talking about. That does not reflect a lie. That does not reflect deception, ladies and gentlemen. That reflects a person coming to grips with her complicity in this matter. She says, I'll tell you what's going on in there. And she told you about the toxic masculinity. She told you about the weird relationships that were going on in there. The fact that fentanyl can kill you, the fact that fentanyl causes, not potentially, the fact that fentanyl causes respiratory depression is not an invention of a bunch of dumb government lawyers over here. Not an invention of Detective Gillette with his background in marketing. That is a medical fact testified to by experts that have decades of experience in this field. That is documented in the literature you will receive. Not potential, not 1 in a million, fentanyl causes respiratory depression. Well, where do you see all of them suffered through respiratory depression? Respiratory depression means they stop breathing. They all stop breathing. Every single one of them, all 14 of them, they all died. That's your evidence of respiratory depression. He says, well, they gave the medication and then they checked them out and made sure they were okay and they're on the ventilator. It's really not getting them off of it. Was that the testimony of any of those nurses? They couldn't even remember if they gave it to them before or after, but it is in conjunction with withdrawal. It's either immediately prior or immediately after the withdrawal from the ventilator that they're getting these medications. All at once, in boluses, in those giant turkey baster things that they had to actually go in the other rooms for. Remember, Lachard was instructed? You have to go down there, pull it all out. A nurse says, I'll help you with it. You think he's helping her with it because he's not busy? Or because, yeah, you've got to get them all in your hands here, and then you got to take them to another room. And it's a process. You got to get them all into that because you got to get them to them all at once. If this was medicine, ladies and gentlemen, I would argue to you the ICU would stock medicine in that size. They wouldn't have nurses going and raiding all the Pyxis machines, having to go into other rooms, fill up big, giant syringes outside the view of the family, and walk in and give this medicine. Once again, synergistic effect between benzodiazepines and narcotic pain medication is not an invention of Detective Gillette or the state of Ohio. They didn't even know what synergistic meant before this case. Not an invention, it's a medical fact, demonstrated through studies that you heard testimony about. How does not putting on the powers of attorney wrong and not justice? How is that at all even relevant? That the person who had the actual legal authority to make the call was not put on the stand in all of these cases. I would argue to you there are reasons why an elderly spouse would not be brought in to testify. There are reasons why some family members, because of geography or whatever, did not testify. But you heard from at least one family member that was present during each one of those. And what relevancy does it have that they weren't the POA? They were there. They saw what happened. They saw what he did. They were witnesses to this crime, and they told you what he did. Brain dead theory. Once again, not a theory, not an invention by the state of Ohio or the police. And none of them were brain dead, folks. Not one of them. Not one of them were brain dead. We're not saying they are. But the family members were told they were. And their choices were let them live forever on a ventilator until they die on a machine, or let them pass naturally and peacefully. Now, Melissa Penish's daughter testified, and you saw that clip of her picking at that bottle. You had pictures, 14C and 14D, of those bottles before she was given that bottle. And for them to suggest, ladies and gentlemen, that she was somehow tampering with evidence in front of you, in front of 5 prosecutors, in front of an entire defense team, in front of the judge, in front of the gallery, on Google TV, whatever that is, for the whole world to see that she was somehow doing something intentionally by absent-mindedly picking at that bottle, somehow tampering with evidence, somehow changing evidence, I would say, ladies and gentlemen, is just desperation. Because the truth is, her mom was on 15 milligrams tablets twice a day as needed, as prescribed by her primary care physician. She testified to it. You see pictures of it here. And Ms. Menashe cross-examined her with those actual medical records. That's the truth of what happened here. If you can't trust the messenger, you can't trust the message. Who's telling you the truth on that issue? No one knows if it's painful to die or if it's anxiety-inducing. Yeah, they do. Not everyone dies in a coma. Not everyone dies like this, folks. These people were like unconscious in comas when he gave these things to them. Not everyone dies like this. People die awake. So yeah, people do know what it's like to die because they can tell it to other people. They can hold their hands. They can tell them what they need to tell them. Not everyone dies like this, floating away on a cloud of fentanyl and benzodiazepines. Double effect is included in the order set from Mount Carmel, has a caution.
Remember double effect. Remember proportionality. Start low and go slow. That's why double effect is included in the order set. Dr. Haggers doesn't know about how meds. He's never questioned about them. He puts in the order set. Boom, boom, boom. And never has any problems. He follows the policy. Are we to assume because his dosing habits are different, he is a murderer? Yes. Because you can't overdose people during palliative extubations. And he's not aggressive. He's not, give him twice as much. I get twice as much as what they were, which would be 200 micrograms. That's the upper dose, remember? I give 3 times as much. He starts them off 5, 6, 7, 8, 9, 10 times as much. In some cases, 20 times as much. Of the maximum of what that order set calls for, a maximum of what anyone else in the world is doing. Are we to assume? Yes, that's one of those circumstances. You are to assume that, I would argue to you. Reasonable doubt is a doubt based on reason and common sense. Reason and common sense. That's why you're here. What does your reason and common sense tell you about a doctor that does this in the 19 ICU under these circumstances? Is it reasonable that he's the only one in the world doing this? The only one in the world doing...
Okay, ladies and gentlemen, this is argument. You determine what the evidence is in this matter.
Is it reasonable that he's the only one in the world doing this? Does it make common sense that a brand new minted doctor in 2013 doing this all on his own without any consultation, without anyone else knowing about it, is just being aggressive? Ladies and gentlemen, this is about his dosing during palliative extubations of these patients. He could have had the best motive in the world for this. The best. But if his purpose is to hasten or actually cause their deaths, that's murder. And under the law, under the equal protection of the law, no one gets past that threat of death. Even if you are a doctor, even if you do have years and years of education to do that, even if you do have a family. You don't get a pass for what he did. He killed these people. And they matter.
Thank you. Ladies and gentlemen, we're going to do the charge in the morning. It's about an hour and 10 minutes. Plus I have some forms to do. One thing I wanted to talk about, after we do the charge tomorrow, we're going to divide the alternates away from the main jurors. Now, I know you guys have your places back here, but I'm going to put the main jury in the big room, and the alternates will be in the little room. Okay? Just warned you, if you got stuff there or stuff, you might want to get it out of there. Okay? Because once I separate you, you guys won't have any correspondence unless something happens. Okay? Just forewarning you tomorrow. I know you guys have gotten comfortable back there in your spots. Okay? So tomorrow, after we do the charge, then you'll be separated into the 2 rooms based upon the jury. Now, 2 of you have moved up in the jury pool. Okay, and David, who are they?
It's Damien and Sydney.
Okay.
Forgive me, I don't know the last names, but I think I do. I just don't want to say.
Well, I think they all know who
Your Honor,
Damon
Your
is.
Honor, I think the cameras are on.
I'm sorry? Oh, yeah, about the jurors. Turn off. Okay. Sorry about Anything more before I excuse the jury for the evening? Okay, ladies and gentlemen, have a wonderful evening. It is particularly important that you don't start discussing the case. You do not have the law yet. Okay? Have a wonderful evening. Remember the admonitions. Be safe. I'll see you guys at 9 in the morning. All rise. He's moving slow today, isn't he? Have a wonderful evening, ladies and gentlemen. You can be seated. Mr. Zion, anything for the record?
I'm sorry, sir?
Anything for the record?
No.
I
Mr.
have
Baez?
something for the record, just I
Yes, sir.
really got to run to the restroom.
Okay, go.
See you for 30 seconds.
That's the longest 30 seconds I've ever experienced. Huh? Maybe. Yes, sir.
Yes,
We're on the record, folks.
Judge, at this time, the defense would move for a mistrial based on improper comments to the jury argued by the prosecutor in what we believe is typical burden shifting in his multiple statements and multiple questionings. First, starting off with the potential witness that the prosecutor commented that we should have called in reference when he said, if there was a witness, you would have heard it, referencing this, the witness that trained Wesley Black, that made the comment, I've given enough to put down an elephant. I think that's a classic scenario where the prosecutor knows that there is a line here. It's one where the defense takes the burden of proof seriously. It is something that is one of the very few things in their toolbox as to constitutional protections, and to suggest that the defense should have called a witness that trained Wes Black is improper argument by the prosecutor. In addition to that, requiring that we present articles to support Nurse Derek Dreyer's statements about about patients living longer on opioids. That too is suggesting that we have a burden to submit such a fact, when in fact it really should be law enforcement following up on leads. In addition to that, why didn't we ask a question of Dr. Zivit? Is an improper statement to make. Just by prefacing it by saying I'm not burden shifting does not reduce the fact that he is in fact burden shifting. We don't have to, we can ask, if an accused wants to put a witness on the stand and ask them 2 questions or 1 question. That is entirely their right, and we do not have to present anything more. In fact, the whole reason he was up there arguing to begin with was because they have the burden, and he gets the privilege of having that last word because of that burden. But to suggest and to throw out there that we fail to ask a witness a specific question is, again, classic burden shifting. And in addition to that, if quadruple downing on the burden shifting wasn't enough,
okay, hold on. I count 3.
Okay, I've got
missing witness.
Sure. The West Black trainers 1. The nurse Dreyer not submitting the article to support Nurse Dreyer's statement. Why didn't we ask the question of Dr. Zivit? That's okay. I think he asked that twice. I'm sorry. He mentioned it twice in his argument. So that would be 4 in my count. And then number 5, absence of anyone in the world making the argument that no one in the world is giving these doses is, 1, assuming facts that are not in evidence, and completely improper. I don't believe that falls under burden shifting. So I can't in good faith argue that, but I think this is not 1, 2, 3, but 4 occasions where the prosecutor saw the line, knew the line was there, crossed it multiple occasions on a very serious constitutional protection that is set up for a reason, and Dr. Husel is entitled to those protections, and we would move at this point for a motion for a mistrial with prejudice based on prosecutor's comments.
Mr. Zion.
I didn't do any of those things, Judge. I said those words. You can't say, why didn't they ask the question of our witness, and then say somehow I am barred from asking why didn't they ask their own witness of this question. That doesn't shift the burden to anything. It is answering their argument. All of those things he mentioned were specific answers to his argument. And as the court said, and as I said, I'm not saying they had the burden to prove anything here, but if there was somebody out there in the world that could say this, where are they? And when I say there's nobody else in the world, that's based on our expert witnesses saying nobody else anywhere is doing this. That's what that was all based on. And these were all directly responsive. You don't somehow get me in a trap by saying, oh, well, they didn't ask our witness this question, so therefore they failed on their burden. Well, they have the same ability to ask if they choose to present evidence, and they chose to present the evidence of Dr. Zivit. They have the same ability to ask him questions as we do of our witnesses. And to somehow say that I'm not allowed to comment on their argument that I didn't ask or our side didn't ask in cross-examination an appropriate question, and therefore therefore that we failed on our burden, is appropriate to comment on in rebuttal evidence. It wasn't like I brought that up and said they didn't, it was an answer exactly to what he had argued. So, I mean, this is nonsense, Judge.
Anything else?
No.
Yes, Judge. To call the burden of proof nonsense is...
I didn't call the burden of proof nonsense. These arguments are nonsense,
Excuse
Judge.
me, I was talking. I waited for you to finish. Anyhow, to make the comment, I think the proper... A prosecutor who does know where the line is on the burden of proof could say there is nothing in the evidence on the record that states what Dr. Zivit's dosing habits are. That would be a proper statement to make. But to comment on us not asking, not doing something affirmative in their defense is classic burden shifting. He knows that. This is a prosecutor with much experience, and that still doesn't answer to the other things of us providing a witness who trained Wes Black on the excessive doses in their training session at Mount Carmel is a very serious accusation to make, or a very serious crossing of the line on burden shifting, as well as expecting us to provide articles to support Derek Dreyer, their witness's testimony, that he in fact advised law enforcement of the fact that there were studies out there that show opioids can extend life. Again, whenever you ask or argue that the defense should have taken an affirmative action on something in defense of themselves, that is shifting the burden. It's very simple, and it's not a complex concept. And prosecutors all across the land know this. And to take that jump is quite fascinating. And of course, to make the statement that no one in the world, like somehow they're experts going to know that what everyone in the world is doing in dosing of opioids, that's somewhat absurd. So I think we've laid our record. I appreciate the court's time in that regard, and we may supplement it with some case law tomorrow. Should.
So you want me to roll on in the morning?
Sure.
Okay. Anything else?
No, I have nothing for this.
And if you want to submit case law, everybody has my email.
All right, Judge, thank you.
Okay?
Thank you.
Anything else?
No.
Nothing from the defense.
Okay. Have a good evening.
Thank you.